Hi guys! It's a YSL reunion and I am so excited. The short story lore on why we're doing this is yesterday we were talking about two wrongful conviction stories. And in the mix of talking about those wrongful convictions, we mentioned Jim, Happily Angry Lawyer's fundraiser to fund the really expensive document procurement costs so he could do his research on other Fulton County cases. And we were scrolling and scrolling. And shout out, someone just donated, so shout out to whoever just dropped the 75. We got to this one mention. Where is it? It's this one. We were reading this on stream. And I asked the chat to guess who it was. And they guessed correctly, and they said we should watch more clips of that same individual. So yesterday's stream became a part one of an impromptu Love-A-Palooza. We're going to continue that today with some clips. The first clip we're going to get you guys is when Glanville is yelling at Love to sit down before the jury comes in. It's one of my favorite, like, sit down, Love. But this is how it started. This is a separate case. The first case you'll see there is James McDowell, Lloyd Stevens, and Demetrius Brewer. The three of them were convicted of murder. In their case, the prosecutor claimed in her opening statement that a particular gun, arguably tied to two of the defendants, was the, quote, literal smoking gun. It absolutely was not. Everybody agreed it was the wrong caliber. The worst thing, the state destroyed the gun before trial, so the defense could not independently verify the ballistics testing. So, obviously spoiler for this stream, but yesterday the chat got to guess who it was, who the prosecutor was, and there's a lot of familiar layers here, right? In the YSL trial, we have these, we found a gun, it's tied to this person, and then we get cross-examination, and at least one defense attorney gets up there like, can that gun even fire this caliber? And they're like, either no, or it would go horribly wrong if you tried. And there would be different markings. So very familiar there. That's how this all started. We are going to get right to the Love getting in trouble with Glanville. And all the familiar faces are here. Fatima's here. She says, do we really have to listen to Mouth Almighty, Tongue Everlasting on a Sunday? I know. You guys wanted to do it. So do I. Tebow, good to see you, says, hey, can't wait to see Kat and the chat. Trey Keisha seems to agree with Fatima. LaDonna Ames, good to see you. Oh, that is the thumbnail, right? I used the Doug with the glasses to hear clearly. Lady Libra, Nem, good to see you. Miss Scorps, good to see you. See, the whole gang is getting back together. YSL Kells. That guy, Nick, a long time no see, good to see you. Felicia. This is the clip we will be watching. Amanda, Plans and Pens. Brooklyn says, you win some, you lose some. That's the way it works, Miss Love. Glanville did have some good one-liners. And Biff, Biff is going through this again. He's putting himself through a day 2 of more Adriane Love. Keely, good to see you. And Jay Chill says, I don't think I can take hearing that lady's voice. We get it. But good to see you, and thanks for stopping in. And 773 Pisces. So we're going to start with a clip, and then we're going to do a longer watch of something from day 4 of the trial. 2 witnesses. There's lore behind both of those 2 witnesses, but I think, we don't revisit the beginning quite as much, so it's kind of forgotten. And I think a lot of people also didn't see those early days. So we're going to get some very early on Adriane Love and get to the root of 2 pieces of lore that carried through a good portion of the rest of the trial. But first, let's get Glanville. So Shart gets yelled at first.
Of some 105 pages,
hey,
that references that it's entitled Operation Planners and goes through and has different slides that they're in. The focus is on why didn't we file this stuff months ago, and let's wind it out and air it out at that point in time. Okay, so I'm going to ask the state their issue on this. Are you cutting this out? Did you have discussions with Mr. Sharp? Madam?
Here we go.
We did have discussions.
When?
Well, this morning.
That's too late. The evidence is excluded. The evidence is excluded. I'm going to exclude because I told you that this was going to happen. No. We're excluding that. And I'm going to exclude the PowerPoint that you all submitted. Well, you're not going to wholesale introduce it.
We had no intention. Your Honor,
All right.
we are not going to introduce this PowerPoint today. I personally reached out via telephone and called at least 2 members of the defense team and asked them to call me back. And I would like
But you all should not be identifying this stuff the moment of trial while the jury's sitting in a box. This is the last. I am not going to tolerate this any further.
Guys, okay, future me is in the top right here. Look at Hilton. Look at Hilton right here.
This is the last. I am not going to tolerate this any further. If you don't get together with your colleagues and flag issues and resolve them promptly, and if I have to take them up, remember, I can exclude them. We'll work the weekends, or we'll do a combination of both. So this time, I'm going to exclude those 2 sections.
Your Honor, Mr. Atkins, he confronted this witness with those sections. I last week let them know that we were introducing that.
If the exhibit's not ready and you haven't made, and you, no, well, Mr. Sharp's got objections to it.
But Judge, Mr. Sharp can get in and have our evidence excluded every day that he makes an objection
No.
at midnight, and then comes in and says.
Well, then you all should have gotten your stuff together before then. Some of our juries, please. Some of our juries. Have a seat, madam. Have a seat. You better exclude that, and next time, make sure you're prepared. Make sure you're prepared next time. I'm not going to do this anymore. I'm just not. We are starting right now. It's 1:20. So
we have talked to them. We have said we don't agree.
then file a motion and get it before me, and we'll take it up. Both of you all have equally responsibility to do that. Oh, it's going to be inadmissible right now.
You said to file a motion. There's nothing.
I'm not gonna have any more.
Look at his posture. You know, I don't know what they're called, but in the UK, the guards, the royal guards, have to stand with a straight face. I think he would be so good at this because he is holding it down. Look at her like posture leaning forward mid-action.
Discussion about this, madam. I'm not. I don't. Well, you know what?
I think he's saying a prayer.
Well, then that's why we have to.
Punishes the state because the defense.
I'm not punishing anybody, but you know, but prior preparation prevents poor performance.
Be prepared, Judge. That's why I sent them last week, a whole week and a half ago, 2 weeks.
I'm not.
Well,
and I have said I would like to discuss.
Our jury's coming in, madam. Our jury's coming in. Have a seat.
I think everybody needs a break after that. That was what courtroom does this happen in? For this to happen at all is crazy. And this is a televised trial. There's all these people in the room. It's not just like one defendant and their client and then me and maybe one colleague and the judge. I would never want to have bad blood like this with the judge. There's just so much here. This could be a whole stream of just ranting on why would you do this? Why would you think you have the right to be screaming in a courtroom like this? Because you can't get in a PowerPoint, which not for nothing, but a PowerPoint isn't evidence. A PowerPoint is a narrative. It's a compilation of how you want to put certain facts together to present your case. It's why things like PowerPoints can't be submitted back to the jury because they can't see all that stuff on the screen while they're deliberating. They're not supposed to have non-evidence in front of them. And yet you're losing your mind over it because you want to make sure you have your storyline put together. And don't forget, she was already writing this up on those whiteboards and she had Dennis on the stand, the little like giant pad of paper. Just a whole mess. Now, I think there was, yes. So Nem, a few people mentioned it in the chat when we had Whitaker, and it was time when we were bringing Dennis back on the stand. She wanted to get this PowerPoint back in, and the defense was like, "You're already told no." And she tried to fight with Love, and we're going to get to that. I have that clip of the whole day. But I do have the Whitaker clip at the beginning of this. We can watch that quick before we get out of this video. Coming witnesses and the evidence.
This is number 26, at least on my list. Tyrone Dennis, is he just has a lot of different types of evidence listed next to him. Is he law enforcement?
He is,
Okay.
he was one of the lead detectives
Okay,
that investigated that assisted in the investigation regarding
Oh,
Mr. Thomas.
right,
Later
yeah.
on.
we've heard about him in our videos we've been listening to. That Dennis, okay.
Yes.
All right, and then you also have music next to that. Is he gonna just testify about certain songs, or what's that gonna
He
be?
would intended to play portions, not
Okay.
whole songs.
Okay, and he'll give his gang expertise about what
Yes.
all that stuff means. Has he already testified once? Has he been qualified already? Okay.
Yes.
And don't forget, chat, what ends up happening with Tyrone Dennis when he's on the stand this time? Was he qualified the first time? Yeah. We get him on the stand second time. He ends up being disqualified and chastised. Not directly, because I think Whitaker said to relay the message, that Dennis knew better than to make a reference to a defendant's prior incarceration when he made the comment about Diamante Kendrick standing on the hood of the car.
All right.
But we got to watch the Magic City videos before that went down.
So
Yes, sir.
a couple things about the state's proposed evidence about through Mr. Dennis or
Mhm.
Investigator Dennis. With the music, I'm interested. Is the state planning on playing videos, audio? How is that? Are they proposing, of course, over our objections? And
Right, and a lot of that's already been ruled on. Let's find out. Did you intend to play video or audio when or whatever, I don't know what his rank is, Dennis is going to be testifying?
So it's audio, and these are the overt acts that we have listed. For instance, Act 78, 60, 74, 95, 97, 103, 125, and 129. So we would be playing the audio portions of the audio.
so strictly audio, no video, no pictures.
No, I didn't say that. I also said that we would be putting in the described social media posts.
Oh, yeah, no, he's not asking about social media. He's asking about when you're going to be playing clips of songs. Is that going to be just audio, or is it going to be video also? Is that the question?
Yes, and if there's video, I mean, we've discussed, from my recollection, and I wasn't the one litigating a lot of the
Right,
free speech, First
Right.
Amendment issues here.
right.
But if there's video, there's certain things in a video that could be problematic to be introduced in front of a jury as well. That's why I'm inquiring. Are we confining it strictly to the words that are spoken?
No. So when what I didn't make the distinction on my list of which ones we will be entering the videos of. So I will speak with Mr. Sharp and whomever else wants to
Okay.
be involved in that conversation and identify the videos that we will put in as or.
Okay, so this witness is within the first 30, and so by
Midnight. You said?
the end of Friday, you need to have details for what specifically, not just music, but,
Video.
a video of whatever the name of this song is, or, a 2-minute clip from this song, and here's the minutes that are included, and audio from whatever other song. Detail it for them so that then they can make detailed objections.
And Your Honor, also just to give the court a heads up,
Uh-huh.
87 Lima is operations planners PowerPoint.
Okay, hold before we get into the PowerPoint thing. When someone does the like double alphabetical like Lima Lima, I instantly think of Atkins every time now. Like his voice, just whenever he reads something in the alphabet, I think of Atkins. I don't know why. I think it's because he says it so hard. He'll be like 77 Lima Lima, and his arm will be flying out.
Don't
He's
have
not
it
even
in
in
front
the
of me,
room.
but I'm very familiar with that PowerPoint. That PowerPoint includes all sorts of conclusory
Papa.
language, all sorts of additional information that is not relevant to this case, all sorts of commentary from it written down on the, I believe it was intended to be a PowerPoint to other law enforcement. That's my understanding. I could
Is
be
that
wrong.
PowerPoint that Dennis is?
I believe so. And I understand that the state's intending to call him as an expert, but hearsay and an expert can't be used as a mere conduit to get into hearsay and other inadmissible evidence. And there's a lot of, I'm saying I know I have numerous objections. And
All right, is 87 Lima Lima already in evidence or no?
No, I don't think we've introduced it in
Okay.
evidence, but they.
I always love when
we were certain.
I always love during this whole trial when there would be look at Shart smiling because he already knows Steele's about to go. But the tandem when you would see one attorney making their arguments and another would be ready to also argue the same thing, like it was just like rapid fire.
With this, I'll get you the date. I filed a motion challenging the admission, and my memory is Judge Glanville said he's not letting that in and asked the state, and they said they were not using it. Now, if that's wrong, I apologize, but I'm pretty sure that's
Okay.
accurate.
All right, so
Now listen quietly to Love in the background. I'm going to rewind to 10 seconds. Listen very quietly to Love in the background.
I apologize, but I'm pretty sure that's
okay.
accurate.
All right, so
I'll check back into our notes because I don't have memory.
don't
of that
remember.
particular
Okay.
case.
All right, just check on that one.
So this was after, well, we'll check back into our notes. We're trying to reference a ruling by a judge. Your notes do not matter, quite frankly. And not for nothing, but Steele had already filed his motion. And remember, he put the timestamps to a YouTube stream where we could go watch the clip that we just saw where Glanville was saying, no, you cannot bring this in. This is excluded. And when a motion's filed, it gets disseminated. It goes to the docket. It gets sent out to everyone who's registered to get electronic notifications. It goes to the parties. So Love had it at her full disposal to go and watch, very conveniently, the ruling as we just watched it by Judge Glanville. I'll check my own notes. Screw what a judge might have said. We'll check our own notes.
Thank you. See, this exercise may be boring, but it's helping everybody.
And then after this, they pretty much break for the day, and we're supposed to be back. Okay, and that was old cat talking, but that was a whole day. And I do have, I guess we could actually do the PowerPoint. Do I have that? Where they're going through. That was a longer bit. If you want to, do you guys want to go through the dismantling of the PowerPoint, or do you just want a clip? Because I have a 24-minute clip, but I do think that was a little bit longer, but it was a lot of page shuffling. So I think the 24-minute clip might cut out some of that. So we could start the 24. And if it seems like it's missing too much, we could go back to that day. I have that day in my notes.
Between him and
Oh,
Mr.
started in the middle. Now we're here. All right. We got old school Sabata in the chat here. Like we got the OG Sabata. So guys, yeah, I'm going to keep myself like real time me up here, and old me is over there.
All right, so we can circle back to going through the evidence that's going to come in with the next few witnesses, including Mr. Sprinkle. If y'all are ready on that, we can move on to the wiretap evidence that the state intends to use. We can,
The PowerPoint maybe is,
I mean, we can do the PowerPoint. Would the wiretap evidence come before the PowerPoint?
no. it would
Okay,
be after the
PowerPoint. All right, yeah, we can look at that. So everybody should have the kind of revised PowerPoint, I guess, that the state provided over the weekend, I think.
We display it on, you're on before the lab, you can display it on the screen, so
Easily run through it.
Yeah.
And Your Honor, if I may just turn my back, you will give a thumb drive to Chris Winfrey. Yes.
And so what the state sent over at this point would be, y'all have taken out everything that you don't intend to use. So the hope is for y'all that all of what you provided is usable, and we'll sort that out. All right. Yeah, so if somebody wouldn't mind, I guess, just giving us kind of a slide by slide. And I
Because we
don't, I mean,
can
I
kinda
don't
see it
know
on
that
the
it needs to
screen.
be displayed on Zoom as long as we're all looking at the same thing. That might be a better approach. So let's all just get our email that sent it over and open it up and look at the slides on our personal computers or laptops.
It will be an email Sunday after 10 p.m.
It's visible a little bit on Love's screen, a little bit.
It was sent Sunday at 9:15.
And was it a Dropbox link or was it an attachment?
For the attachment with the PDF.
Okay, right. Okay. All right, is everybody ready? Everybody got it up? Yes, yes, yes. Okay. All right. Slide one, I don't see how the state could possibly need that slide.
First slide, and obviously it's a title slide, but she comes right out of the gate. I don't see how the state could possibly need that slide.
no, that's not.
Oh, I moved. And now my old me is on this other side.
No, I mean, it's not. No.
Okay. Slide one's out. Slide two, this is just sort of,
These are,
Take it out on her own.
identifiers that APD has identifiers that APD has identified, and
all right, hadn't there already been testimony about that?
there has been testimony about snakes and tattoos and red flags. Yes,
Okay, so that one's out too.
if you say it is, it is.
Huh?
I mean,
just to make sure we're all on the same page. What you're referring to, slide number 2, is the picture that has an arm with a
Yeah.
tattoo. Okay.
Yeah.
Which also coincidentally is the second slide in the attachment. That's what I'm going by.
All right. Just didn't want to make sure you weren't
All right.
the title page and then
Okay,
we're on the same page,
all right.
literally.
Okay, good. All right, slide number 3. What's y'all's argument for needing that?
Okay, we can.
Because we've still got some language on all of this too.
So we can take out, we can take out all the language.
Mhm.
We take out all the language.
Okay.
Can you take that aside? John, maybe be allowed to remove the Mondo board, the IT department.
Yes, that would be wonderful. We're not going to use it, so out it goes. So y'all go ahead and, yeah.
All right.
Okay. What about these 5 pictures?
So the pictures, Judge, are just, as he's talking, he would,
All right, so who are I see we've got
Defendant Williams,
Mr. Williams, Rich Homie-Kwan.
Bermian.
Are there pictures already in evidence of
Yes.
those 3 people?
Yes.
Then use the pictures already in evidence. How about the bottom 2? Who are they?
Donovan Thomas is on the far right side.
Is there a picture of him already in evidence?
There is a picture of him in evidence.
All right, use that. What's the middle 5th one?
And this is Defendant Williams. And pre the gang, pre the dispute, the war,
Okay. I mean, is there a picture similar to that if he needs to identify people or a group of people he could use?
Yes. Numerous.
Tell him, Keith.
Hold on one second, Your Honor.
Hilton.
We have videos of the groups of
All right, so
persons
you could do
together.
it still from a video.
We
Okay.
can.
All right, how about slide 4?
We have a squeak.
This is just, Your Honor, and our position regarding the displaying of these pictures is that they're demonstrative as he's talking about them. Of course, they've seen Mr. Copeland for what feels like ever. So they sort of know who he is. They haven't seen as many pictures, just face shots of Mr. Watts. So they're not, we would just.
Lots of shell
put forth that
cows.
they're-
Is there a picture of Mr. Watts in evidence?
Yes,
But
there
they're
is.
demonstrative.
Looks kind of similar to this.
So the reason that we would ask that the PowerPoint photos be allowed to be kept in is they're demonstrative. These are clear face shots of who they are talking about. There's nothing that is inherently or substantially more prejudicial due to the cumulative nature of these photographs that would cause either defendant to be in danger of being convicted of something or on something other than proof of the crimes we have listed in the
Are
indictment.
they going to, for some reason, be talking about Mr. Copeland and Mr. Watts together, that they're like,
Yes,
it's going to be crucial for the jury to see, here's Copeland and here's Watts?
not crucial.
Lots of
It's,
shell
but he will be talking about a specific interaction, specific.
Okay, well, he can talk about that without this, and if you need to like have the jury reminded, oh, this is what Mr. Watts looks like or something, just use something already in evidence. All right, what's this picture of some fence?
The gambling house that
Do we have pictures already in evidence of that?
knew.
Okay, and this one's fine. Slide 6.
Let's talk about this because we're obviously recapping kind of like or rewatching moments. Positive masculinity. Good to see you, by the way. I'm interjecting on a conversation in the chat, but I think positive masculinity has it exactly right. Judge Page started off pro prosecution, and honestly, I think most judges lean that way. But Miss Love was so intolerable that look at the shift that ends up happening to the point where you can see visibly, and the way I interpreted it, visibly, Paige Whitaker looked rattled at some moments of this trial, over it, pissed off. And each of those moments, there was like 1 or 2 times where she was pissed off at the defense, but all those other moments, it would be because Love did something. Like, and to be fair, when Love stepped back towards the end of the trial, when she wasn't present quite as much, that reduced a little bit as well. We had obviously the major hiccup when Hilton was questioning Mooney Lee, and we had the free qua hashtag red, which was obviously a big moment where Paige seriously stayed. I have to clean up your mess again. But a lot of those other moments were really Love just continually pushing her away, even though Whitaker was throwing her bones in the beginning. So I think this is a super, super, super huge point here. And holy moly, we have Vice Baby here. Oh, I'm so happy. Vice Baby, did you put yourself through the torture of watching the YSL trial the first time it came around? Because I think you might be one of the few that luckily did not have to deal with like 160, like 200 days of Adriane Love here over in the corner. It's awesome to see you. So glad to have you here. And that's a huge assumption. I'm not sure if you actually did or didn't follow the trial, but if you're hanging out with us today and you're doing this with new eyes, I would love to see what somebody thinks about seeing some of these clips for the first time. Yes. Oh my God. Perfect. So big thank you for showing the love and dropping 10 gifted subs. Let me get your channel link here. I cannot wait to see your your reaction to some of this. It is just, it is a time. It is a time. Okay, so we've got Vice Baby. Chat link, YouTube link in the chat there. Go hang out over there, you guys. If you guys remember Legal Vices, rest in peace, Legal Vices. Vice Baby is Jeff's son. He's got a YouTube channel. He's keeping the whole family together over there. So if you missed those days and were unaware that he had a channel, you've got to go check it out. It'll bring you back the good times that we've lost since Jeff has been gone. So great to have you here. So glad that you're going to be fresh eyes here. Please give your raw commentary as much as your heart desires. And let's see, where were we? Let's get back into, for context here, we're going through like a horrible PowerPoint that the prosecution put together where they wanted to have the gang experts, APD officers that are gang experts because they read hip hop magazines and watched movies. That's Detective Tyrone Dennis's expertise source. They put together this long Operation Planters PowerPoint to be able to present a narrative to the jury of this is why we think this incident is related to these individuals and that this incident was also part of a back and forth beef between different gangs or hybrid gangs or subsets, and how it all comes together somehow under Jeffrey Williams' Young Thug's command and order. He was calling the shots. First judge excluded this PowerPoint because state didn't do their job and disclose to the defense how they plan to use it in time. So we just watched a huge screaming match between the first judge before he was disqualified and taken off the bench for this trial. And Love was trying to get this PowerPoint back in, and the defense had to say, no, this was excluded. And now they're going through it slide by slide. It's just a hot mess.
With the stack of money and obscene gesture. Hold on. Well, that's Mr. Copeland, and it was that stack of money and that flashing of it at a club that led to the conflict between him and Mr. Watt. So,
Why is he so pity?
We've also got video of him doing exactly the same thing.
we don't have that video.
Yes, we do. We've had a video.
All right, well, don't talk over each other. Do you know what exhibit number that is?
Your Honor, we initially entered the video in June. However, that was after 3 o'clock. And so we did not enter it again this time around. So I do not believe the video is an evidence. I'll check. I believe that was after 3 o'clock.
Actually, a good point there, because we do need to make sure when we're finally reviewing what evidence is in and out, that we make sure that everything that was entered in that little period of time is unentered, if you will. So, okay.
For anyone that's missing what that was referencing right there, remember when we had the disqualification of Judge Glanville, that was during the testimony of Kenneth Copeland, and they made the decision that everything, because Kenneth Copeland, Lil Woody, was on the stand, they ended up picking the 3 p.m.-ish point in time where we're going to strike everything after that and redo those next couple of days where he was continuing to testify on the stand. And we've got to redo those things. We're going to ask the jury not to remember those things. And that includes any exhibits that were admitted. So that's that 3 p.m. time frame being referenced here. Just a mess of a trial.
This one's fine. He can use this one.
Can I inquire as to exactly what the relevance would be of showing a picture of Mr. Copeland holding money and flashing the bird?
Well, I mean, they said that was what had started a beef between him and Watts.
The flashing of the large sums of money.
Not the flipping the bird.
I mean,
So you don't, old me's calling it out.
the flipping the bird, I mean, it wouldn't have had it.
She didn't really say that's what started it.
Relevant
It was the
because
same
it
night.
shows Mr. Copeland with that huge stack of money that we're talking about, and it makes
Is this the night of?
it's.
Or is this
You
just
say the night of, not
the
John
night-
and Thomas.
No, the night that the beef starts between he and Watts?
No, Your Honor, it is not.
It's just an example of him with a
Flipping the
bunch of
bird
money.
and holding money.
An exemplar. Good word.
I think it's January the 8th. The 6th, January the 6th. So it was the night it was.
Okay, and for clarity here, earlier in the chat, I said, hey, should we switch over to Law and Crime? They have closed captions, but it sounds quieter. It sounds like the whole feed for the media pool just got quiet around this point. So if you guys want to redo that vote with new information, switch at the next.
A fight started that led
I think the sound issues are another key memory of this trial.
to the arrest of, I think, Mr. Kendrick and Mr. Arnold the first time when Bloody James punched out.
So this is a picture from the night that, it all got shot up or
I'll-
something?
I'll confirm, but that's what my
After-
understanding, that is January the 6th.
I don't know if she wore the 6th. What does that mean?
I don't know. I don't know. Maybe they know what he was wearing to the
It's
club
the
that night.
detective that gave it to us, so.
My recollection is that he had different clothes on the night when he was flashing the money than he does in this particular picture. I do not believe.
So do you have any kind of picture from that? I mean, if you can confirm it was that night,
We
that's
will.
fine. Otherwise, it's just an example of, hey,
Well, not just,
here's what we mean about flashing money.
No, the large amounts of money.
Right.
I think during the course of the interviews that the jury has heard, you hear them talking about a very, very large sum of money.
Right.
And, you know, one might argue or wonder, you know, what kind of money, how much money did he have access to that kind of money? Him having a stack of money like this. I mean, it could have all been ones, but even ones would have been a lot. I mean, I'm just saying. So the relevance bar is, of course, as the court knows, is a low bar. And the fact that he's sitting there with that.
Okay. Well, he also is flashing the bird though, or flipping the bird. So that's a little bit offensive, I'm sure, to some of the jurors. So maybe there's why don't you find out whether A, this is that night, and B, if there's some other photo already in evidence with him with large stacks of money, okay? Or to some of the jurors. So maybe there's why don't you
There we
find
go.
out whether A, this is that night, and B,
Yeah, so chat, are we missing this context? So let me put myself in the shoes of Vice Baby. So we're hearing a lot about Kenneth Copeland and Lil Woody, and obviously they're trying to get all these pictures in of things that Woody was doing that was starting some type of fight, right? Even if we take it at face value that pictures of Woody flashing money is causing some brawl to break out at this club, Club Crucial. Don't forget the context here that initially the key murder in this trial was the Donovan Thomas, aka Nut. That's why this is called Operation Planters, because it's really all about the pathway and the resulting fallout of the murder of Donovan Thomas. Lil Woody Kenneth Copeland was initially indicted for that. And we end up having Michael Sprinkle on the stand telling us about how, you know, we were initially looking at these 4 individuals, but we eventually ended up looking at those 4 individuals. And Kenneth Copeland ends up becoming the key star witness. He gets on the stand to start testifying. He pleads the 5th. They have this in chambers meeting, the state and the judges. That's where we have Kayla Bumpus stand in when Kenneth Copeland's attorney was on vacation and they needed an attorney there for him. And he apparently mutters during this ex parte meeting that, well, what if I get on the stand and say on the stand that I'm the one that killed Nut? And they don't disclose this ex parte meeting to the defense, but the defense finds out about it. And this is why Brian Steele is almost held. He was held in contempt and almost put in jail until all of the Georgia defense attorneys, Gactel shows up and they're like, Glanville, you can't do this. What are you doing? And then we have a month break because they need to figure out what to do until Glanville's ultimately recused from the case. So yes. So if you guys forgot, don't forget Woody was initially indicted for that murder. So, yeah, Blood Crucial, not Club Crucial. Let's get it right. Yes. Yes. Went from the star target to the star witness. Just crazy. Michael Sprinkle.
if there's some other photo already in evidence with him with large stacks of money, okay? So we'll revisit that when
It is gonna, their logo is gonna block
Yes, ma'am.
the PowerPoint, but we have captions to hear what they're saying.
Slide 7.
Shout out to their AV and tech issues today.
This just shows a couple of the, I mean, the Metro, but y'all, there's been testimony about the Metropolitan, right?
TIG Studios that
Right.
Mr.
So TIG Studios remembers Donovan Thomas's studio. And for more context, one of the reasons that Kenneth Copeland was a suspect during such a key suspect during this time is because he started telling the detectives in these initial interviews, like the days after, in the aftermath, he's freaking out. He tried to contact Jeffrey Williams and say, like, I need help. And he's telling the detectives that he thinks that they put the green light on him, meaning they've got the clear to off him, as if they had determined that the streets had determined that Kenneth Copeland was the one that did it. And he's happily talking to these detectives because in that moment he's safe and can get protection from them. Although I wouldn't trust them to protect me personally, but yeah, prime suspect.
Copeland is alleged to have shot up, or believed to have shot up.
We've had a number of crime scene photos ended of the Metropolitan. So there are a number of photos of that in already.
So it doesn't, there's nothing, if Detective Dennis is talking about this, putting it up doesn't take extra time. It just orients the jury as to what he's talking about. So it's a demonstrative aid that orients the jury, that is helpful to the jury, that is substantially similar to that is exactly what he's talking about. So there's nothing that should
Okay,
preclude him from
and
showing it to the jury.
TIG is who's,
Think it's a game.
Right,
It's the company that Rich Homie Quan was under, that Think It's a Game Studios is inside
Right.
that building right there.
okay. This one's fine. All right, moving on to slide 8. So this is several pictures of Mr. Thomas. We definitely do not need the Club Crucial, We'll Always Remember You part of that.
Okay.
And you
And remember,
know,
this is what they redacted.
the language about whether he's a high-ranking member of a rival gang. I mean, that's,
It can come out.
thank you.
But yeah.
I know it's asserted that he is, but this sets it forth like
Yes.
fact, and
it-
that's for the jury to determine.
Yes, Your Honor. I'm just trying to X over everything.
Okay, so,
Did you have something?
I mean, it says 3 pictures basically of Mr. Thomas and some of his
Brothers, family,
Well,
whomever.
I would object to the pictures of,
greed.
well, the pictures period. I mean, I don't know what the relevance is and what the jury would need or how this would aid the jury in understanding any testimony from Detective Dennis to show pictures of him and various individuals just standing around.
So, do you want to elucidate us on that?
Yes, we can take.
Okay, so they won't use that one. All right, slide 9.
So slide 9 shows just the type of,
Are these actual posts already in evidence?
no, we did not.
Okay, well, if they're not, then I would think if you throw these up, that is more than demonstrative. So if you want to enter those as examples, we can talk
Okay.
about that, but
Okay.
otherwise he can just testify that here's what happened on social media after the death.
Okay.
All right, slide 10.
Your Honor,
Yeah,
I would be objecting to Detective Dennis saying this is what I saw on social. Okay, you understand that?
okay.
Would
and
be hearsay.
because- And how would, well, no, what he saw on social media, he saw on social media.
If he's going to say, I saw on social media and someone posted the following, I'm assuming that's for the truth of the matter asserted. And the post should not come in. I don't know who posted it. It would have to lay a foundation for the writing.
So the fact that the posts were made and that they were publicly made is part of, is the evidence itself, not that it's true. This death to the big homie sent the word
What-
out from behind the wall.
What would you have the answer generally be? I mean, what would you presume his answer would be, or your question and his answer?
Were there threats made against YSL in the moments, hours, days following Donovan Thomas's murder? Yes.
Sounds like the truth of the matter.
There were public threats, social media posts, and the like, and these would be them.
Okay, well, that would. Okay, and that would be overruled because it isn't being offered for its truth. Okay, but we can just do that at the point in trial. We don't have to have this slide.
Okay.
The slides out.
Slides out. All right, slide 10.
L after L for Love's redacted presentation. That was entirely excluded by
Tell me, I
Glanville.
guess what I'm looking at and why he's going to be using this.
So I think we can take this out. I think that this picture is already in any event.
What'd they get in the picture of
Right.
the gang house? The gang house, the gambling
Slide
house?
11. There's a lot going on this slide.
There he is. He can testify about that. It's basically it's Mr. It's the services of the victim in this case. So he can testify about it.
It's a good
Take the
question.
victim impact.
what would be the
Just-
relevance of how, many people were moved by his death?
So she laughs.
Judge, if I may come back to the court on that, I can take out the slide and
Okay,
as to the questions about it.
all right.
So 11's out.
So the slide, yes, 11 is not
Adams.
going to be used, and
The
she'll get back to me on the relevance of how crowded his funeral was.
Do you guys remember?
He's very loved.
She just mumbled he's
And
very
maybe it
loved.
is, I don't know. But
Why is that relevant for
All
the
right.
jury to hear?
slide
That's so
12.
that's like a victim impact for state sentencing, not for
So
guilt.
how about slide 12?
We can take out that. It's a similar one as the one earlier, so we can take out, we can take that out in the same way and introduce it if we need to. And
Okay. Thank you.
And then watching this in retrospect, what did we hear from Donovan Thomas's mother after the last plea? You guys remember? The state never even discussed with them that they were offering the final pleas to the remaining 3 defendants. But all through this trial, oh, Donovan Thomas, let's show how many people showed up to his funeral. Let's show how much he was missed. Let's get his parents on the stand, which they actually did. His parents actually came and testified, which I think was, I mean, that's very victim impact. And yet they don't talk to the families when they're ready to wrap up with trial 2 and just get the plea deals. Little bit of a switch up there. Yeah, that was wild. She just hot mic'd he was loved. She should
Is
know
the
better.
Picture with the placards from obviously some shooting already in evidence.
I don't think this particular one is, but it will be. We anticipate that this will be admitted in
Well,
evidence.
if you want to present it to him and ask him about it, that's fine.
Okay.
And the second one on there, do y'all intend to have him talk about that picture?
We can take that out.
Okay,
L after L.
all right. So then.
Moses, I think she's
13
piecing it
essentially will be
together that-
used, and you can, if he can identify what's the crime scene photo, then he can testify to that.
That
Okay,
love just wants to do what love wants to
Number
do.
14.
You guys were not kidding about this PowerPoint.
So, Judge, we don't
Arguments
have
being
to-
wild.
Number 14, we would need to introduce, I think, the photographs versus putting it up.
Okay,
We would, yeah, as opposed to using it as a demonstrative.
okay.
There's
And
some
I mean, if they're
photographs.
already in, then obviously if he needs to testify to them, he can. And if they're not in, you need to be able to, obviously you need to be able to lay the foundation.
Right,
but-
and we may just get, some of the ones that are, as the court has already pointed out, some of the ones that are already in and put them on, just to use those as our exhibits with
Okay.
him.
She's got like one slide and one photo that can be used new out of all of this. Thank you, Moses. Like, this is crazy.
I mean, presumably this shows everybody's
Whitaker chose violence
relation-
today.
in a relation to these 3 people.
It does, he testified about that. But this is just like putting faces to the names and sort of family diagramming, and I think we actually did that earlier, so it would be referring back to something that's already.
I'd be objecting, Your Honor, the mother, if I interrupt, I apologize. If the mother of Mr. Thomas testified to family relations, the father of Mr. Thomas testified to family relations, and Detective Dennis testified. Now, he may not have, actually. He may not have. So it's definitely the parents, the mother and the father, I would be, it's just repetitive.
Okay, sounds like she doesn't intend to use this anyway, upon further reflection. All right, slide 16.
Okay, so I just dropped if you guys haven't seen the PowerPoint, I just dropped that in the chat. But I did want to flip over and look at the slide they were talking about that relates to the funeral. Like they're including this, we'll always remember you. And they put these comments about how people were like saying rest in peace. And where is Yeah, pictures of the funeral. So they're showing how many people were at the funeral. And they even wrote this comment that Peanut's funeral was treated as if he was royalty. Over 2,000 people showed up for his funeral. So this is when we're talking about like victim impact. I mean, what is the evidentiary value of this? And if anything, it could show that maybe any one of these 2,000 people, gang affiliation or just out of the love for somebody, could have taken some action into their own hands. Like on one hand, I don't see how it helps them narrow down who this back and forth beef was going back and forth with. And two, it's just trying to reinforce, feel sad. This is so sad. The community is mourning. Let this weigh on your decision as you deliberate and consider what you think you should make of the evidence. So just problematic. And excluded twice. Yes, I do think, Ashley, I do think Paige would have limited Donovan Thomas's
We still have
testimony.
a current intent to use this slide.
We cannot use 16.
Okay. Okay, 17.
17. We can as well not use, so what,
We have a past what the F in the chat. This is an old comment from What the F that rings true today. It says, I don't know this person, but it doesn't matter how many people show up to your funeral on being loved. Even hated people have lots of people show up. Yeah, and I mean, if you hate somebody and you have beef with them and you want to show that I didn't have beef with them, you got to go to their funeral. And there's other people that just for their own closure, they want to go and make their peace. They want to go and have their moment to be like, hey, sorry things weren't good between us. And you go to the funeral. So exactly right. What the F, what the F from the past.
I think that what we'll do is just take some of the pictures, photographs that we've already admitted
Okay.
and use
Just
those as
giving up?
exhibits rather than trying to introduce whole hog. this
Sounds
PowerPoint.
reasonable.
Whole hog, because she didn't want to say wholesale.
18. Y'all still want to be using that?
No, we cannot.
Okay.
We cannot.
Jeez, look at
Well,
Whitaker.
except that I think that the photograph in the bottom right corner
Yeah.
were guns that were recovered, but I'll confirm with Dennis. I won't need so that might be something that we could use as an exhibit and not a slide. So if there's anything in this picture, certainly not the top three,
Okay.
but if that bottom right picture, if we do anything, we would tender it as an exhibit versus trying to put it in on a demonstrative slide.
Okay. And these are all
It was the stuff that was collected from one of the vehicles.
from an alleged rival gang.
Yes, after the shooting at 1006 Hill Street. Actually, not the rival gang. This was the one that was collected from the people who were shooting back at the people who were shooting.
Oh.
She's talking about here is this slide. And remember, this is Kelvin Watts' Shell Kel. That was the major name that we heard as beefing Kenneth Copeland, Lil Woody, Shell Kel. We're always beefing back and forth. Always beefing back and forth. So this would relate to, she's not being clear, but she's saying the rivals. Again, with a beef that relates to Kenneth Copeland and not Jeffrey Williams and the others sitting on trial here. Miss Love. This whole PowerPoint, man.
Okay. All right. Well, I mean,
But
I could anticipate some potential objections from the defense at the point in time if you seek to tender that, but we'll just deal with that at trial. But don't be surprised, because I certainly think if I were the defense attorney, I might have an objection to it.
I think they wanted this part in because this
Oh,
is from
well,
the
we'll
other
see.
side. This is
We'll
the
see what
guns
the
from the
strategy is.
other side.
We'll see.
Okay.
Okay. That's what makes trials interesting.
So 18 is out.
18 is out. 19.
Adams with the double checking is great.
19, we have not yet introduced that photograph, but I think that
The one on the bottom, or?
yes,
Okay.
the one on the bottom. Part of that photograph is part of what was talked about in the interview with Mr. Copeland that has been shown to the jury so far. So we could definitely take out.
They are talking about this Haiti gang image here. And remember, Haiti Gang is affiliated to subset of If Gang. So this would be, this picture on the bottom right would be associated with Donovan Thomas and their people in whatever way the whatever way the state wants to say this picture relates to somebody. And of course, we have yet again another picture of Kenneth Copeland. Just Kenneth Copeland, not a gang of people versus a gang of people.
The word will do whatever the court instructs, but that photograph, we can introduce it as an exhibit if it has not already been admitted, and we cannot publish the PowerPoint slide.
Okay.
And in that vein, Judge, with respect to, since we're going through it like that, rather than introducing, no, I think maybe we should. I was going to say, rather than introducing the whole thing as just, here's his demonstrator that he's using, since we're cutting it up and using parts of it, rather than saying, okay, we're going to use this, we won't use the PowerPoint.
Right.
We'll use exhibits that either have been admitted
Okay.
or that we tender through
Okay.
him.
All right. And so that'll be true for the rest of us.
Yes.
Okay.
So the whole PowerPoint's out.
Well,
Am I hearing that correctly?
we won't use the PowerPoint.
Yes, so she was just saying it's going to be easier not to, because I mean, I would imagine he's probably kind of like press play and he's like, here's what happens in slide 1 and slide 2. And if he's not doing that, then it might be easier to do it another way.
Right.
Okay. All right. So then I guess as for the rest of it, we can keep going through with regard to the pictures themselves, or you can just, if there are some pictures depicted within the slides that the defense thinks are particularly egregious or objectionable that you want to go ahead and alert me to, that's fine. Otherwise, I guess we'll just see what happens at trial.
So there was the dismantling. And doesn't that feel a lot like a mom or a parent in general helping a student do their homework and saying, well, you don't need all of this. Like, this is the problem at hand. Focus, just keep your focus on this problem and try to work out this problem. Like, if you need to get a picture introduced, then follow the regular process as you would with any piece of evidence to get that photograph admitted. This specific photograph, you have to lay foundation rather than wholesale entry of everything you want to plop into this PowerPoint and just get it admitted because you're saying that Detective Dennis is a gang expert and thus he's qualified to talk about all of these things in this, which really would be layperson fact witness testimony rather than gang expert testimony. But this whole trial, we saw this ebb and flow from the state that whenever it worked for them, they would have a gang expert be a gang expert on the stand, and then they'd have them be a fact witness the next. Just like this back and forth self-circular bolstering. So a whole hot mess. Like, the PowerPoint is one of my favorite issues in this trial. The whole time Adam is like, okay, that one's out. Okay, that one's out. Okay, that one's out. So the whole thing is out. Oh, just a whole time. Just a whole time. Let's see. Where is let's see. I thought I had a short little one queued up. But I scrolled on my list. Was it this or did we watch this yesterday? Let me see. Let me make sure this isn't the one from yesterday.
So number 4. Back on the email by Mr. Wright.
Okay.
We never read that in, right?
So
I'll
number
remind-
4,
I'll remind
we did
the
not.
court that we approached about number 4. There were obvious problems with number 4 that were inadmissible. We were told to stay away from number 4. The state was told away from number 4, told to stay away from number 4.
These are all the Mungtung, Derek Wright, the emails trying to figure out the plea deal before that hot mess of a plea on December 28th, 2022.
For obvious reasons, there's all sorts of speculation in there. And now, after being told to stay away from it, and we were told to stay away from it, and we did not address it during cross-examination. Now, after witnesses have testified, the state's seeking to admit a document
Once
that has
again,
number 4 in it. And it's just, I mean, I don't know what we're doing.
Okay.
Your Honor,
And number 5 is not even relevant, right?
Your Honor, if I may just circle back briefly, as it relates to number 4, there was an objection to it. We followed the court's instruction. We did not ask him about it. And when the issue that I have with number 4 not being addressed here is more importantly, I don't know how an assertion that the witness did not adopt is prejudicial when he is not, he denies it and we change it and we take it out, that he was planning, he had personal knowledge that they were planning. That is powerful because it is a material fact that
He doesn't
denies.
have personal knowledge
That's
that they were planning it.
Judge, that's the point that I'm making.
so I pulled this up on the screen. This is the text. If so, I know a lot of people are listening. And obviously you won't hear it because they're not reading it. But this is the text of the item number 4 that's initialed here by Antonio Sledge. On or about April 28th, 2015, as reflected in Fulton County Indictment 9-4, defendant and fellow YSL associates Demikian Garlington and Quindarius Zachary committed a drive-by shooting using the firearm defendant wielded in the video, referenced in part 3 of this section, targeting family members of a rival gang. Now, what they're arguing about is this personal knowledge, because obviously you have Antonio Sledge acknowledging here on this form, but the acts were alleged to have been taken by 2 individuals that are not Antonio Sledge. But he's attesting to by initialing what happened in this instance for 2 other people that he was not part of. So anyone listening, that's what we've got on the screen.
That he says, I did not know that. The fact that something that,
Even saying I did not know that is sort of like,
or that's not
it
true.
was true, but I didn't know it.
No, he's saying that's not true. He is
No,
saying
he's
that-
not. He's saying, I don't know. I think maybe XYZ. That is not coming in. That
Look at Atkins.
needs to be kept out under 403 if nothing
No.
else.
403.
And
Look at Atkins. Hold on, look at
really the only
Atkins.
thing-
I know it's worth the buffer. Look at the side eye from Atkins at the table. Hoo-wee. And I don't know. Usually when it buffers when I
needs to be
reload
kept
like that,
out
but
under
look at him.
403 if nothing else. And that's really the only thing you wanted in, right? So
I didn't hear you.
is that really the only thing from this that you wanted in?
When you say this, you mean
From this being this part, the 8:43 PM email from Mr. Wright that is
Oh.
included within 460Y.
I didn't even, the language of what he says, I didn't even need to have that in. I mean, I understand.
And we're gonna watch some more related to this because we're gonna look at the Alfred plea. Fatima wants to see the rebuking of Adriane Love, and that was all in relation to Adriane Love brilliantly, incompetently, maliciously, accidentally, whichever word you want to choose to characterize it yourself. I have my own opinion. Reading the factual basis of an Alfred plea onto the record in front of the jury, which is something she also wanted to introduce Jimmy Winfrey's Alfred plea, even though that ended up being kicked back and vacated or overturned. I forget the specific mechanism for which that was undone. But not only was it undone, but it was an Alfred plea anyway, and she wanted to introduce that to the jury as well. So, you know, the pattern kind of suggests something to me. It led me to my own conclusion about that. But all of this, now she's being wishy-washy. Oh, I didn't really want that language in. You've been arguing about it for days. So it seems like you do.
And why that would be considered, and I understand the court's position there, why it would look like something was pre-planned. The reason that I was asking or seeking to have the assertion in is just to show that he says no to it. We could take out all of number 4 under Mr. Wright's email and just say, no, he denied it.
Well, we can't make it say something.
No, not put the word no. He said, Mr. Wright said on the stand that is something that we did not agree to and we took out.
And that's exactly the point. Mr. Wright said all this stuff on the stand.
We're not going to be admitting 460Y. And that leaves 451 through 456. And those kind of, what would be the theory under which those would come in?
It, Your Honor, provides, it contradicts Mr. Sledge's testimony when I presented him with a prior iteration, that there was an objection to it being called a prior iteration. And I asked him to show me things that were different. It contradicts his testimony that he saw prior iterations and was allowed to make changes to the prior iterations. He said on cross, the first time he ever saw that plea agreement, it might have been the first time that he saw.
Well, that was the first time he saw that plea agreement because all of these were prior versions.
And when I asked him, did he see it?
And this is so critical. This is so critical because if you guys haven't caught, or maybe you've caught it and it is really hard to follow, I'm telling you, Jim and Tiffany are doing incredible work for what they're doing for Mungtung. This December 27th, they have some version that they end up creating. They have a different version on the 28th, but it's still dated the 27th. And then during the plea hearing, because there's an issue where, you know, based on these terms, you don't have, if you try to sentence somebody, then you have to have some type of bond release requirement. And the criteria wasn't there to make it so that Mungtung could go home that day, which was the leverage that the state wanted to have over Mungtung. His mom was really sick. They waited till like the day after Christmas. They were speedy. They filed a recidivist notice, which gives the state more leverage in terms of sentencing. They filed a recidivist notice in early December, but they waited till right after Christmas to offer him a plea, knowing his mom was sick. And they're ready to go in and get this plea accepted with the acknowledgement that he's going to sign off on this personal knowledge he has on all these different terms. Court points out, hey, you just can't do it this way. So they change it in the middle of the plea hearing. And then the only copy of the plea Love had that day. And what's actually the final plea is not actually what ends up being filed with the court docket. And Love is seeing, Paige is seeing that happening at a different stage already, where, you know, you're changing the versions. And it's not clear that he actually knew that version at that point in time. So I hope Whitaker gets it with this most recent motion to vacate that was filed. If you guys are, the timeline right now is Jim and Tiffany filed a new motion to vacate with extra arguments at the trial court level with Judge Whitaker. But Judge Whitaker said, hey, before I consider these arguments, do the appeal for the first motion to vacate the sentence, where she granted in part, I'm going to vacate the sentence on the 133, but I'm going to resentence on count 1, the RICO count, and just use that 20 years. So they're gonna take it to the appeals court first on that first motion, the decision on that first motion, and then whatever happens there, if they have to come back down, they'll re-argue, or the judge will then hear the arguments from the new motion. So, and there's so much more, you guys. It is just it is just crazy. And that's not the only case. I think how Happily Angry Lawyer has found like terrible issues there that we haven't even heard about yet, but also in other cases. Again, if you want to help him raise money to offset the expenses, he's doing the work pro bono, but he's coming out of pocket for all the document costs as well. So if you want to help with the documents fundraiser, that is in the chat. It's a Give, Send, Go link. But just incredible. And Whitaker's getting it here. So let's hope she remembers this when she gives some consideration to this new motion.
Any prior versions, my recollection is that he denied.
I don't
seeing-
remember that. I think he said the back and forth between us and the state was up to my lawyer. I left that to my lawyer. That
And
was
Mr.
his-
Wright clearly testified
I'll-
that he took a version to speak to Mr. Sledge the night before.
And, I'll look back at.
All right, well, subject to that actually being some kind of so that would be what, impeachment by contradiction?
Yes, it would.
Okay, well, you can let me know if he actually testified
Your Honor.
in the way that you remember it. Yes.
And I don't think we should have to litigate this again, and I'm going to explain why.
Okay.
The state, under the state's theory, well, I mean, why don't they just do this for every case? They could write out their facts, just send them to a bunch of witnesses. Witness doesn't need to initial them at all. And then they take the stand, and then we just start bringing in all copies of documents that they wrote and sent to witnesses that witnesses looked at. I mean, it's false facts here. It's facts that haven't been adopted on these documents. There's inadmissible statements on these documents. It's a mess. And we didn't create this. We didn't tell the state to do it this way. We didn't tell the state to write their documents and then send them to an attorney, write the statements and send them to an attorney and see what the co-defendant says or the witness says. We didn't tell them to do it this way. They created this
I
problem.
understand. You can get back to me if you can find some kind of testimony that you think lets you get this in. Right now, they are excluded.
Yes, Your Honor. Thank you. And I will look for that.
Yes.
I can't say with certainty, but I'm just going to ask if there is also a case which in my mind, in the recesses of it, believe that it may address specifically like
Okay, well.
iterations.
Sure.
Okay, thanks.
Okay, 60-second, all caps. Forgot we used to do those. You want to do one, chat?
Holy
Past
moly.
Cat just granted a 60-second all caps vent session.
Even if Mr. Sledge did say there were never any other versions, and which I don't think he said, you've disproved that by presenting the testimony of Mr. Wright. So I think given the number of 403 concerns there are with 451 through 456, I'm going to just stand on my ruling excluding them.
Your Honor, with
Hallelujah.
respect to the
No, shut up.
403
Mm-hmm.
concerns that were raised, given that 403 addresses matters that are substantially more prejudicial than probative, and given the extent of the cross-examination and the efforts to undermine the willingness or knowingness of Mr. Sledge's statements, essentially even in the arguments that are made, it's essentially, the argument is that this isn't a statement that Mr. Sledge made. Showing that Mr. Sledge, showing a prior statement, contradicting that testimony.
That's what 444Y is. And that's it.
The,
As redacted.
that's the ultimate
That's
one that he
I
signed.
know. And
But
that's-
showing, yes, it is. It
I
is.
know.
Showing that he was untruthful and letting the jury decide, why are you telling stories about that? About seeing a prior version, we believe is strong evidence that allows them to judge his credibility, why he's saying what he's saying, any bias he may or may not have, and
Look at
help them
Steele.
to determine the truth of which statement they should believe. So we would ask that the court, I don't know, revive its prior ruling,
5 minutes ago.
revive the ruling that the court
Okay.
made.
Denied. Let's move on.
Oh, there's old me laughing. Oh, chat. Okay, so a quick note there. When we're hearing about things like extrinsic evidence versus a prior inconsistent statement, so something that's contained in something that's an acceptable statement, right? Like a final plea agreement that was solidly agreed to, it was accepted by the court. It's standing, it's valid. You can say, hey, look, we have this prior inconsistent statement that you signed it under oath and under penalty of perjury or whatever. We're going to impeach you because what you're saying now is inconsistent with what you said here. But we have a problem here with some of the stuff that Love is trying to mash together with all these different email correspondences and different versions of the plea agreement, because that's not really necessarily a official sworn statement. And even if it was, it might not be valid at this point in time when she's now trying to argue to get it in, because the version changed and something new was in effect and an old version was rejected by the court or never actually implemented. So when it's not actually an official statement, you're dealing with extrinsic evidence. It's not contained inside this type of written and signed statement. And there's different rules there. And I don't really know if Love wasn't getting it or if she was just hoping the judge wouldn't push her on it, but Whitaker was pushing her on it. So, so that was that. We have a lot more. I think one of the things we are going to watch is, I'm really interested in rewatching more of the mess around Munktung because it's still playing out. In my opinion, the YSL trial really isn't closed up with a nice little bow on the box and buried in the backyard. It's still going on because we might end up having a situation where Munktung doesn't actually have a conviction for this indictment, and that needs to be worked out after the fact, which means the case would still be open. So let's do a vote. Do you guys want to continue with the Alfred plea with Munktung? Do you want to take a break and go look at the day 4 stuff, the early days, and see the origins of the dreadlocks lore and the Are You Certain and Jeffrey Williams' silence while being questioned by police? Because those are two things that ran as a theme throughout the trial. Or do you want to stick with the Alfred plea since we're on the subject? Yeah, and that's how I feel. YSL isn't done until Munktung is home. All right, we've got a split vote here. We've got a split vote. And this will be a longer stream, you guys. We're going to watch a lot of stuff over and over. I also have Wright's testimony. If you want to watch Derek Wright's testimony, I have the, do you really want to call another attorney to the stand? That didn't work out so well for you last time. Oh, we have a 2-2 on both sides here. Well, we're going to do both. And then we have 4. All right, let's do early days, and then let's do we'll do all of the Alfred plea screw up, the Derek Wright stuff, the Ashley Merchant coming in. We'll do can you rebuke the other attorneys too? Because she's mad that she got rebuked. Let me pull up my timestamps. So do you guys remember Captain Reginald Pettis will be the first one that we look at. Put in the chat if you remember that testimony. And we'll jump around a little bit, but I do think we get Adams on cross-examination here. Let's see.
Reginald.
Make this big. And this is no past me for this one because I have the time.
R-E-G.
Let's see. So we will skip around a little bit with this. We'll speed it up because it's not a pre-recorded clip. So I don't think it was, obviously this was real time. We don't need to go through all of the stuff. So we'll skip some of the background on here's where I work for, here's who I am. But this is really what we're going to be looking at as far as the dreads, the lore, the origin of Adriane Love's obsession with the dreadlocks. So there we go. Also, big thank you here again to Vice Baby for gifting the 10. GV for staying green. She's been here for 10 months. And we've also got for always, forever, for life, 11 months. So that's a super long time. This is starting to compete with the length of this trial. And let's see. Oh, yeah, we got to bring back a Glanville emoji. That's right, you guys. We're going to get Glanville here, so be prepared. So let's get into the little bit of who Reginald Pettis is, and then we'll get to the heart of the matter. This is going to involve a lot of stuff about Trontavia Stevens. And one of the overt acts in the indictment was a robbery for Trontavia Stevens. And they end up thinking that Jeffrey Williams either commanded it or took part in it, even though he wasn't initially charged with it. But they're just trying to associate this story to Trontavia Stevens to then associate it with being under the rank and command of Jeffrey Williams.
I-N-A-L-D. The last name is Pettis, P-E-T-T-I-S.
Good morning, Captain Pettis.
Good morning.
How are you?
Doing well, thank you.
Captain Pettis, would you please introduce yourself to the jury and tell them what...
Oh, look at the closed caption chat. No. Right on the back of her head. Let's not do this.
Good morning. I'm Captain Reginald Pettis. I am assigned to Zone 3 of the Atlanta Police Department.
And Captain Pettis, I'm surprised I don't have to tell you this, but I need you to talk up a little bit louder.
Okay.
I can barely hear you back here.
All right.
The jury's able to hear you. So you're assigned to Zone 3?
Yes, ma'am.
All right. Would you tell the jury what area of Atlanta Zone 3 encompasses?
Southeast Atlanta.
And you can look at them, talk to them.
Okay.
Southeast Atlanta, the border of Zone 3.
The rough border would be south of I-20, west of Moreland Avenue, and east of Murphy Avenue. The southmost border being 285.
How long have you been the captain of that zone?
Since May 24th, 2022.
Now, prior to May 24th, 2022, and at this time, are you currently certified as a law enforcement officer by the Police Officer Standards and Training Council of Georgia?
Yes.
And how long have you been so certified?
17 years.
So prior to working or being promoted as opposed to captain of Zone 3, what was your position there?
I was the unit commander of our Homeland Security Unit.
Now, could you tell the jury what responsibilities that you currently hold as captain of that zone?
I'm the assistant zone commander, meaning that the major is the zone commander. I handle most of the day-to-day operations and the staffing of the zone.
And what did you do as unit commander of the Homeland Security Unit?
I oversaw a unit that consists of intelligence analysts, investigators, and technical investigators that have proficiency in all things computer related.
And how many investigators did you, how many persons were you responsible for overseeing?
Approximately 12, including 2 sergeants.
Approximately how many?
12.
How long did you work as unit commander of Homeland Security?
For about 2.5 years.
Where were you positioned when you were unit commander? working in the same place, Zone 3?
No, ma'am, we were in the headquarters building, 226 Peachtree.
And before that, where did you work?
I was in the Auto Crimes Enforcement Unit,
How long did you work there?
6 months.
And from what date to what date were you in the Auto Crimes Enforcement Unit?
Approximately
And let's be clear here. His shortest tenure is in this field, this area, this department that's relevant to what he's here for today. Because he's going to be talking about finding Trontavia Stevens with a Buick. And that was his shortest tenure of all these things.
January of 2020 until May of 2020.
What else is new?
Before that, what were your responsibilities?
As the Ace Unit Commander of the Auto Crimes Enforcement Unit, we were a traffic unit mainly, and our goal was to stop people from stealing cars, and once they stole cars, to interdict them and arrest those people.
What's interdict?
Figure out who they are, where they're going next, just gather intelligence on them. And then at the tail end of my tenure,
Gather intelligence on them. Guys, if you were gathering intelligence on me, would you note things like, she's wearing a hat, she was wearing a hat, she appeared to have short hair, she's Caucasian. Like, you gather these details about me, right? If that's what my job description is, it's what you'd be doing, right?
there we really were being tasked with a lot of street racer enforcement because it was 2020 and everybody was in the house and that's what they were doing.
Those are the times.
Yeah.
Prior to January of 2020, what did you do with the Atlanta Police Department?
I got promoted to lieutenant in January of 2019. I was assigned to Zone 2 as the day watch commander. Then I got moved to the administrative unit commander in Zone 2, and then to the criminal investigations division of Zone 2.
And what were your responsibilities with the criminal investigations division of Zone 2?
Well, back then we had our investigators assigned each zone, as opposed to now where they're all collected together at headquarters. So I supervised the investigations that took place in Zone 2.
Prior to January 2019, where did you work?
I was a sergeant. I was assigned to Zone 5.
When did you start working as a sergeant in Zone 5?
Approximately July of 2014.
And before then, what were you assigned to do?
Before that, I was an investigator assigned to Zone 3.
Is Old Hateville Road in Zone 3?
Yes.
Specifically is 20... Six 12 Old Hateville Road in Zone 3.
Yes.
And is 2608 Metropolitan Parkway in Zone 3.
Yes.
Do you have any idea approximately how far apart those two addresses are?
No, ma'am, not without looking at a map.
Okay, come back to that. So you were an investigator in Zone 3 in January of 2013?
I believe so.
Right. You said before you became a sergeant in Zone 5 in 2014 that you were an investigator in Zone 3.
And before that, an officer in Zone 3.
Okay. Tell me when you started working as an officer and when you started working as an investigator.
I got to Zone 3 approximately July of 2010. I worked as an officer in Zone 3 until I got promoted to an investigator in Zone 3, which was the end of January of 2013.
Tell the jury a little bit about the responsibilities and duties you had as an officer in Zone 3.
As an officer, your main priorities are responding to 911 calls. Secondarily, you are to interdict crime, and you can do that in a variety of ways. Usually officers utilize the traffic stop and the suspicious person stop. We also perform what we call directed patrols, which is an area that...
So we don't get into this with this witness, but, you know, leading up to the days that Trontavia Stevens is actually on the stand, I mean, we end up seeing that there's a pattern where they're just over and over and over and over and over pulling over Trontavia Stevens. It's like they know his car and they find a reason to stop him.
It's known to be a high crime area, so officers might pull into the parking lot there, turn their blue lights on, and complete their paperwork there. So we do response to 911 calls, proactive work, and deterrence efforts to prevent crime.
Were you always working in uniform during your time in Zone 3 in 2013?
No.
And on what occasion would you have to not be in uniform?
when I was assigned to the crime suppression unit, we would split the unit between uniformed officers and officers that were in plainclothes. The latter part of my tenure, I was assigned to the plainclothes part of that unit. We would perform various tasks in plainclothes. Some of them would be related to narcotics activity. Some of them would be related to general crimes, or what crime was trending that week and what area it was trending in. So a lot of time we would act as the eyes and then call in uniformed officers to make stops.
Now, do you recall January 25th, 2013?
Yes.
Specifically as it relates to an incident that occurred at 2612 Old Hazel Road. What were you working on that day?
I was.
And in what capacity were you working?
I was working in a plainclothes capacity, driving an unmarked civilian vehicle.
Now, what was it that took your attention to 2612 Old Hazel Road?
We received information from our dispatcher that OnStar was tracking a vehicle that was taken in a carjacking, and it was in the general vicinity of Zone 3. And one of the beat officers let us know that he located the vehicle, and it was parked at this apartment complex.
And so, how long after you got that notification did you do anything like respond?
My partner and I got to the apartment complex parking lot maybe 10, 15 minutes later.
Okay.
We located the vehicle, and we parked in a position that we could keep our eyes on it in case somebody came back to the vehicle.
I'm going to show you what has already been admitted as evidence and marked as case exhibits 4A and 5A, and ask you if you recall whether or not those photographs depict the vehicle that you were calling in to look for.
They do.
So what do you do as you get into the complex to respond to this call?
After parking, to keep eyes on the vehicle to see who returned to it, it's pretty much a waiting game at that point. We hadn't determined yet how long we were going to wait to see if somebody came to the vehicle. I think it took about 45 minutes before we saw the vehicle drive past us. So we had initially not seen who entered the vehicle and drove it away, but the apartment complex is constructed in a way that the parking lot is like a big circle. So the vehicle came back past us and reversed into its parking spot that it previously occupied.
Okay. How far away from you was the parking spot where the vehicle backed into?
I don't recall, but we were close enough that we could make out a general description of the driver.
What was the general description of the driver?
Black male with black clothing and a do-rag.
Okay. What kind of do-rag?
I believe it was black in color.
What did that person do?
Black do-rag. What kind of do-rag? I believe it was black in color.
Once they pulled in.
Well, I drove closer to the vehicle to get a better description of the driver and to try to see what apartment they were walking into. So as I did that, the driver turned and looked at us. So we were made at that point, most likely. So we saw the driver.
I'm gonna object to this person being made. Speculation.
I'm gonna overrule the objection, sir, at this point in time.
Go ahead, please.
So we saw the driver walk into the building, and then a short time later, several other people exited the building.
What, if any, apartment or building or unit did they walk out of? Do you know?
I believe it is apartment number 7.
And at this point, how far away from the vehicle that you were surveilling were you seated?
Approximately 10 feet.
What happened after that?
After the driver entered the building, several other males exited. They looked at my partner and myself in our vehicle, and they began motioning for us to roll our window down. They were shouting obscenities while doing so.
Now, what were the...
Hold on. Is it possible that they could have been asking for help? Like,
ethnicities or races of the other persons who came out of the building?
Black males.
Do you remember any general description of the persons who were yelling obscenities?
It would just be that they were probably all under 25 years old or around that age.
And why, do you know why they were yelling obscenities?
Objection or speculation?
I sustain the objection.
I would draw that, but you don't know what's in your head, but what obscenities were they yelling at you?
I did not roll the window down to the best of my recollection. There were some middle fingers. There were some gang signs being thrown. I cannot tell you what they were, but it was aggression was the general gist of it.
All right. So what did you do upon showing of this aggression?
At first, I did nothing, and then one of the males, who was the most, I would say, violent with his hand signals, his signs being thrown, and his motioning for me to roll down the window, lifted his waistband to show us that he had a pistol in his pants.
And what did he do at that point?
He pulled the pistol from his pants and held it down beneath his waistline while pointing the barrel at myself and my partner.
whoa. Pointing at yourself, I mean, I guess maybe you're in the same general vicinity, but it's like every time he wants to say something, it's so self-serving. Like when Adams had objected, they're moving through the apartment complex, and we had been made, I think, maybe. So you're justifying preemptively without actually knowing, but you're justifying why you might view everything else you're about to testify to with this hostile lens. You're giving a justification to say like, oh, and then they came up and asked us to roll their windows down so they could taunt us. Not because maybe they were asking for help or trying to see, hey, did you just see this other thing go on? Someone else was doing something.
What did you do at that point?
I drove away. I drove toward the front of the apartment complex, and then we communicated with our uniformed officers that we call the takedown team that we needed assistance.
What happened at that point?
We circled around the parking lot because we saw the suspect who pointed the gun at us run away from the parking lot. I believe that he ran the opposite direction from the street, so we're traveling one way toward the street and he's running the other way. We drove around the apartment complex, as I explained before. It's set up like a circle or a U, and we saw him coming back into the apartment complex through a hole in the fence. So he'd already made it outside of the fence and he was coming back in.
When you all saw him coming back in, what happened?
There was another vehicle that was traveling around the U. He flagged that vehicle down and then jumped in through the front passenger seat.
Then what happened?
The vehicle drove back out of the complex. By that time, one of our marked units had made it into the area, and the suspect exited the vehicle. The vehicle just stopped in the middle of the roadway, and the suspect got out the front passenger seat and began walking away from the vehicle. And at that time, the two uniformed officers who were in the takedown vehicle were able to take him into custody.
Were there any items collected that had been discarded by that person?
Yes, we called in the assistance of a K-9 officer. It was from a railroad police department, might have been CSX, I'm sure it's in the report. And myself and my partner searched the wooded area where we saw the suspect re-enter the apartment complex.
Break this down, Plans and Pens. The Plans and Pens says a person showing a gun to the police didn't cause the police to draw their weapon. So they say this happens. They say that, oh, we've got to call in this takedown team. But then they also say that they continue to drive and pursue. So it's like you're acknowledging some part of your operating protocols where, hey, if we don't have the manpower, if we don't have enough resources to safely, to tactfully approach this situation, we have to call in others before we do so. But they call in others, but then pursue anyway after they brandished a weapon at us. Like, there's a lot that doesn't make sense in that little area. It's almost as if nobody brandished a weapon, but they just wanted an excuse to call in the takedown team.
The K-9 was able to find a firearm that had been placed inside of a bucket.
And was that firearm the same description as the one that the person had pulled out after showing you the violent gangs or hand signs?
Yes, ma'am. I was able to identify it as the same weapon.
I'm going to show you what has been marked as State's Exhibit 2 Alpha
That was a slick question too.
and 3 Alpha. As the defense does not need to take a look at it, I'll show it to you and ask you if you recognize 2A and 3A.
I recognize them as being the gun that was on scene at the time.
Okay. Are those fair and accurate reflections of the firearm that you collected?
Yes.
Your Honor, state tenders 2A and 3A as evidence.
Any objection to 2A or 3A? Mr. Adams or anybody else?
I'll be happy to wait.
Anybody else?
No, Your Honor.
All right. 2A and 3A are admitted and maybe published as you see fit.
Thank you, Your Honor. I'm holding up 2A and 3A for the jury. Captain Pettis, let me back up to the time that you said that you saw the vehicle back into the parking lot before the gentleman got out and went inside. Was this gentleman, did you do or say anything to that gentleman?
No.
And how long would you estimate it was from the time that he went inside to the time that the group of people came outside?
Less than a minute.
And did a group of people come directly towards you, or were they doing something else and then noticed you?
I think that the
Objection to speculation.
I sustain this form.
What did you observe?
I observed them come out of the building with their attention already focused
Where?
on the vehicle that I was driving, myself and my partner.
Okay.
And then they immediately began throwing the gang signs and yelling at us.
Had you done anything to that group of gentlemen before they came out, focusing on you and your partner, throwing the gang signs and yelling at you?
No, ma'am.
Now, when you talk about gang signs, how long have you worked overall in law enforcement?
17 years.
And what, if any, training or experience have you had during that time that would give you the ability to recognize what a gang sign is?
We certainly had a block of instruction in the academy. In field training, we would be taught to look for those signs from our field training officers, pointing out the signs. But we would literally drive down the street and gang members would throw gang signs at the police car. Throughout my years, I've attended various other trainings that show gang indicators from tagging to dress to words being said, certainly the colors and hand signs being the most fluid and evolving indicator of a criminal street gang.
And how were you able to discern, a gang sign from just the middle finger?
I think it would be in the forming of the hands and it doesn't look like a middle finger. It's more complex than that.
I'm going to show you what has been marked as State's Exhibit 6
Look at West
Alpha,
Moreland.
7 Alpha, 8 Alpha, and 9 Alpha as it relates to this particular incident. And also, let me ask before I do show you these, 2612 Old Hazel Road, that's in Fulton County.
Yes.
I'm showing you, and given that this has been already served upon events, I'm showing you 6A, 7A, 8A, and 9A. Would you look at those without publishing to the jury? And let me know if you recognize those photographs of the person in the picture.
I do not.
Okay. Do you, at the time that this incident occurred, are you the one that photographed anyone who had been arrested?
No, ma'am.
Okay. Who was it that did that?
I don't know for certain.
Was it a crime scene taker from that?
No, ma'am. I think that it was one of our supervisors who responded to the scene.
Okay.
They usually kept the one camera that we had for the entire zone.
All right. And how did the supervisor or how did you all document or associate photographs with a particular incident?
It's usually done right there.
If he doesn't know, he's speculating.
Your Honor,
I'll sustain this.
he's literally answering.
I'll sustain it. It's a form of the question.
Okay.
I'll sustain the objection to that. You can rephrase it, madam.
Sure. When photographs are
And let's just be clear here that this is day 4. This is like their 3rd witness, I think. It was early on. They haven't even called 5 witnesses at this point. And listen to the snip from Love here when she doesn't get an overrule.
No, he's speculating.
Your Honor,
I'll sustain this.
he's literally answering.
I'll sustain it.
He's
It's a form of
literally
the question.
answering.
Okay.
I'll sustain the objection to that. You can rephrase it, madam.
Sure. When photographs are taken during the course of an incident that you are involved in, is there a way that the photographs are associated with the incident itself?
The answer is yes.
Is Miss Trish, is she like, oh my, she's like, why are you yelling like that? Oh, YSL granny. Also, while we're paused, MLS popped in here and said, if you guys remember yesterday, MLS popped in and I was like, are you doing anything? Are you streaming anything? And he was like, no, I'm not doing anything. And then, I don't know, like an hour or so later, I open up YouTube and I see that he's streaming this was crazy. You guys got to go watch this stream. He's titling it How to Destroy Your Own Case. This lawyer here was going bananas after this guy. And as you guys know with the deposition, depositions can be a lot more spicy because even though opposing counsel can object with the deposition, unless there's like attorney-client privilege, you still continue to answer. And then if something needs to be introduced and stricken from the record, that can be done later. That can be decided later. But you get to hear the answers to things that would normally be blocked live on the courtroom floor. So this guy, they had a counter going. By the time I joined, you guys already had dozens of I don't knows. This guy is being asked questions like, what do you do when it's time to change lanes? How do you safely change lanes? He's like, I don't know. Like, you put your turn signal on, you look when it's safe to go, you move into the other lane. Are you still getting work, doing jobs as a trucker? He's like, I don't know. Do you remember why you were terminated? Kind of. Like the whole deposition is a hot mess. And it relates to him while he was driving. He's not paying attention. It looks like he has his eyes closed or is looking down. Then he pulls up a can to drink something. So he's got to be awake. And he ends up like veering into an elderly couple that was driving and riding them off the road, which is really scary. But really a ridiculous deposition, which I'm assuming is why you didn't know you're going to go live. And then you saw something crazy and you said, we have to go live. So I dropped the link in the chat to this. You guys make sure you go check that out. It's highly entertaining and it's always fun to watch a deposition. More I don't knows than some of the witnesses we had in the YSL trial. And thank you right back, dropping a 20 here for the love. So big thank you here. Show MLS some love in the chat. Yeah, this is the way to put it. This guy was the most ridiculous witness. It was awesome. So I think you guys will like that. I think you guys will like the attorney was spicy too. The attorney doing the questioning was very spicy. Even though I don't think he had to be, because the witness was just...
What you said is that he was moving towards your car, right?
Right.
Motioning, roll the window down.
The head. I think we were actually here.
I'm trying to figure out the best way to say it. So let me think about it for a second.
Okay.
Hopefully Keith Adams is going to get great later.
In most cases, the photographs are associated with the incident that's occurring by way of the officer or the investigator that is on scene.
Okay. And are those photographs associated with the incident number in the record keeping?
Definitely.
I sustain this to form.
Is there an incident number associated with the photographs?
Yes.
Is that incident number and those photographs stored in the normal course of business with the Atlanta Police Department?
Yes.
Now, who is it that was arrested as a result of this incident that took place with you?
The suspect's name is Mr. Trontavious Stevens.
All right. And were there any other persons who were arrested on that day?
Objection, relevant?
Yeah.
I'll overrule the objection.
I believe that there was one other person arrested, but it was for a warrant, not a crime that had occurred that day.
And so the arrest that you made, or that was made that day, what was that arrest for as it relates to what you were looking at?
Mr. Trontavious Stevens was charged with aggravated assault, and he also had an outstanding arrest warrant. I believe it was out of East Point for aggravated assault.
Okay.
Now, to be clear, this ag assault is something that he pled to. So remember, Trontavious Stevens, Tick, Slug, he took a plea deal in this case. I think he was one of the first that we really got to hear the hammering home on that language in the plea agreements. That is, you shall not testify truthfully to the innocence or potential innocence of anybody else named in this indictment and trial. That language of you shall not testify truthfully. We really heard that first come out about Slug and Tick, and I think it was the first time I did a video on this case. I had just been watching it in the background, but I was like, and got mad and did a video on that particular plea deal. So Trontavious Stevens was a fixture early on in this trial. He did, in his plea deal, admit to committing what they classified here as overt act 1, this aggravated assault with a deadly weapon I think it's important context, on this officer, Reginald Pettis. So they're charging him with ag assault for pointing the gun in the direction of this one officer. So they're getting him for that brandishing.
Do you know what Mr. Trontavious Stevens' arrest warrant out of East Point for aggravated assault was that related to?
No, ma'am.
Was the other person who was arrested, what was that other person's name? Do you recall?
No, ma'am.
We're showing you a copy of your incident report, refresh your recollection?
Yes.
All right. I'm going to show you what we have labeled as State's Exhibit 50 Alpha, the narrative provided to defense and discovery. Would you just take a look at page 15 at the bottom? Just read it to yourself and do not read it out loud. Just look up when you've had a chance to read it.
Desmond. Okay.
Who is that person?
Mr. Desmond Hurst.
Now, was Mr. Hurst with Mr. Stevens when all of this happened?
No.
Okay, where was Mr. Hurst?
Mr. Hurst was inside of apartment 7.
All right. And how was Mr. Hurst found?
That's the relevance, Your Honor.
I'll allow it, Mr. Adams.
How was Mr. Hurst found?
The Zone 3 Crime Suppression Unit obtained a search warrant for apartment 7. The objective of the search warrant was to try to locate the vehicle keys of the stolen vehicle, of the carjacked vehicle. And during that search warrant, I've already forgotten his name. The other arrestee,
Mr. Hurst.
Mr. Hurst, thank you, was arrested because he was inside the apartment and showed to have an arrest warrant.
Okay. Now, the vehicle you described Mr. Stevens as getting into, what kind of car was that?
Objection, characterization of testimony.
I'll let you rephrase it. I'll sustain it as a form.
When you spoke about Mr. Steve, or better yet, when you spoke about the guy that flashed a gun at you, walking up to the front of the complex and getting in a car, what kind of car did you get into?
I think it was a Buick.
All right. Was there a traffic stop made on the Buick? By Georgia State Patrol?
Yes.
As a result of what happened?
Yes.
Okay. And where was that traffic stop made on the Buick?
Not far, at a gas station on Cleveland Avenue. The apartment complex that's on Old Hateville is maybe a couple hundred yards away from Cleveland Avenue.
What gas station?
I believe it was a BP.
What was the address of the BP?
It was in the 100 block of Cleveland Avenue.
If I show you your report, will it refresh your recollection as to the exact address of the DP?
Yes.
All right, showing you again State's Exhibit 50A, asking you to look at the third paragraph from the bottom. And just don't read it out loud, just read it and tell me if that refreshes your recollection.
Yes.
All right. Please tell the jury what the address of that BP gas station that the traffic stop was made by you again.
The address was 151 Cleveland Avenue.
151 Cleveland Avenue?
Yes.
And who were the occupants of that vehicle? Do you recall?
No, ma'am.
Would showing you the report refresh your memory?
Yes.
And the narrative asking you to look at that same paragraph.
Okay.
Don't read it out loud.
Shout out to
Look at it, put
Amy
it
E.
down and tell me if
Good to
it's
see you. Happy Sunday.
Okay.
Now, just leave that there for you to purchase if you need. So who are the occupants of that vehicle?
Mr. Stovall and Miss Latrice.
Are those Jarrell Stovall and Shawanda Latrice?
I sustain the objection.
Do you recall their first name?
Yes.
Please tell us their first name. And if you have to refer to the document to refresh your memory, let us know that that's happening.
Okay. I'm referring to the document.
Don't read it, but you have to look up.
Okay. Mr. Jarrell Stovall and Miss Shawanda Latrice were their names.
Now, when police went to apartment 7 of the complex, were there other persons inside?
Yes.
Besides the one that was taken into custody?
Yes.
Do you recall who those other persons were?
No, ma'am. I'd have to refer to the document.
All right. Would you refer to the document? Don't read it. Look up when you have a chance to refresh your memory.
Yak be looking at everything Doug does.
Okay.
Who are the other persons inside?
Alfonso Dixon, Trevez Watkins.
Watkins?
No, I have to look again. Johnson.
Okay.
And the aforementioned Mr. Hurst.
All right. What were the races or ethnicities of these young men?
Black males.
All right. Now, were the occupants of the Buick any of the people that had come out of apartment number 7?
No, ma'am.
Were the people that came out, including Mr. Stevens, did you indicate in your report whether they had come out of apartment number 7?
I did not indicate that.
Now, when you said that you looked at the occupants of the Buick and decided they had not come out of number 7, do you recall what you said in your report about the occupants of apartment number 7 as it relates to walking towards your vehicle?
No, I do not.
Would reading your report refresh your memory? And if it would not, you have to tell me so we can take another step.
I don't think it would.
All right. The report that I have in front of me is marked as State Exhibit 58. Would you look at it, not for the sake of refreshing your memory, but look at it and tell me if you recognize the report, first of all?
I do recognize the report.
How do you recognize the report?
It looks like the one that I wrote on January 25th, 2013.
Okay. Now, the report that you wrote on January 25th of 2013?
Yes, ma'am.
Was that written in close proximity temporally to the time that the incident occurred?
Yes.
And is it a routine part of your responsibilities and your practice to memorialize incidents as they occur?
Yes.
And does the report that you memorialize, the incidents that you write a record of, do they accurately inside your report reflect the incidents that took place in close proximity temporally to the report?
Yes.
All right. And are these reports made during the normal course of business with the Atlanta Police Department?
Yes.
And was this report made based on the personal knowledge you had at the time that the incident occurred?
Yes.
Your Honor, under 24-803, past recollection recorded the state tenders, State's Exhibit 50A Alpha.
Any objection to States 50A?
One moment.
Mr. Adams.
One moment, please.
Doug looking back.
No objection to its admission. This one does not bother.
State 58 is admitted.
Thank you, Your Honor. Captain Pettis, would you please read paragraph, the third paragraph from the bottom in its entirety, starting with several?
Yes, ma'am. Several Georgia State Patrol officers performed a traffic stop on the Buick in the parking lot of the BP gas station located at 151 Cleveland Avenue and detained its occupants, Mr. Jarrell Stovall, 04-12-82, and Ms. Shawanda Latrice, 07-25-91. This detention was necessary to confirm or dispel whether or not these occupants were involved in the carjacking. Officer J. Brown and Sergeant T. Henninger, 2397, knocked on the door of apartment number 7. After knocking several times, the door was eventually opened. There were 3 males inside, and they all were detained. Those males were Mr. Travis Johnson, 11-04-85, Mr. Desmond Hurst, 07-17-95, and Mr. Alfonso Dixon, 08-26-91. Officers M. Johns and K. Collins relocated with Mr. Stevens back to the apartment complex. Officer Ramirez and I then did a drive-by viewing of the occupants of the Buick and determined that they were none of the people that came out of apartment number 7 and walked toward our vehicle.
When writing, they were none of the people that came out of apartment number 7 and walked towards your vehicle. Who are you referring to?
The occupants of the Buick.
No. You said they were none of the people. The occupants were.
She's testifying this point, but she's stuck with them.
Your Honor, there's no stuff with you.
All right, if you're not looking at the screen and you can look at Yak react to this, like you realize what's going on.
The occupants of the Buick.
No. You said they were none of the people. The occupants were.
She's testifying this point, but she's stuck with them.
Your Honor, there's no stuff with you.
Hold on. I will sustain that objection. So, Ms. Love, that you do have to go through the proper foundation.
Sure, Your Honor.
You just can't tell the witness no.
I'm not trying to tell them.
Yeah, well, you just started to, so that's why you drew an objection.
All right.
All right.
So, Captain Pettis, let me make sure I'm clear. When reading that last sentence, when you said none of the people, they were none of the people, who were you referring to when you said they were none of the people?
Can I refer to the report?
Yes, please.
This was only day 4.
The people that I'm referring to are Mr. Jarrell Stovall and Ms. Shawanda Latrice.
Now, if you would, please go up to the third paragraph. Actually, you know what? Start at the top and read the first 3 paragraphs.
Your Honor, I'm good.
Your Honor, it's
Let him finish his objection first, madam. Okay, what's your basis of your objection?
It's going to be cumulative. He's already testified. It's going to be improper bolstering. He's already testified by the items that she's asking.
I sustain it as to the
Your Honor,
second
I did not.
basis.
There's a particular part that he did not testify about. I'm certain Mr. Adams is aware of it. And
Well, I'm gonna sustain the question as formed as of yet. You can rephrase it if you like.
all right. Starting at the top of paragraph 3, would you read what you wrote there in paragraph 3?
I witnessed a black male, approximately 25 years old, wearing all black clothing with a black do-rag and black hat, reverse the vehicle into its parking spot and then exit and walk toward apartment number 7. By this time, I had driven my undercover vehicle to within 10 feet of the target vehicle so that I could observe where the driver was going. The driver stopped walking and looked at me. Several other males then exited apartment number 7 and walked down to the street level. The Males were yelling at me and motioning for me to roll down my window. One of the males, later identified as Mr. Trontavia Stevens, was more aggressive than the other males in trying to get me to roll down my window.
Thank you.
You're welcome.
Look at Trish's face. All of their faces. Let's look at the whole gap. There's so much facial expression action happening that I missed Trish while Steele was doing his face and cool. You know, when Steele would get hot, he would start shaking, like he would start puffing his blazer jacket to air himself out. And he was doing that. I wasn't even looking at Trish.
The driver stopped walking and looked at me. Several other males then exited apartment number 7 and walked down to the street level. The males were yelling at me and motioning for me to roll down my window. One of the males, later identified as Mr. Trontavia Stevens, was more aggressive than the other males in trying to get me to roll down my window.
Thank you.
You're welcome.
Remember, this guy only did this job for 6 months. Look at Steele.
Now, do you recall the serial number of the file?
No, ma'am.
Would you please read the next to the last paragraph of the narrative of your report?
Officer Ramirez and I then met Norfolk Southern Railroad police officer J.S. Shirley and his K9 Smoke near the hole in the fence that Mr. Stevens used. Smoke tracked toward a plastic bucket approximately 30 feet inside the wood line, which contained the pistol that Mr. Stevens pointed at me. The pistol is a black Beretta .380 caliber semi-automatic pistol. The serial number, D as in David, 79, S as in Sam, 62, Y as in Yankee. The pistol was turned over on scene to Atlanta Crime Scene Tech number 7345 to be processed.
Your Honor, at this time, the state having made state's exhibit number 10A as in Alpha.
Why are they zooming in on her butt?
Chief Long, short student. Sorry.
Does anybody wish to examine the state's 10? Have you seen it? Okay, all right.
Great chat. First of all, big love to Amy E gifting 5 memberships. Make sure you guys are saying thank you if you just turned green. And if you just turned green, make sure you use some of those. I think we have an Adriane Love emoji in there. We've got the Vivarito in the bush. We've got the attorney emoji. So make use of them while we're talking YSL. Big thank you for showing so much love, Amy E. Love everything that you do over on your own channel. And I'm telling you guys, videos for days. So if you're looking for something to watch, now that Karen Reed's in the middle of stuff, and I don't know, I don't really see people watching Donna Adelson trial. I see some people are watching. But really, there's so much time to go catch up on this amazing archive that Amy E has together over there. And we've got to answer this question. That guy, Nick, says, how do you aggressively tell someone to roll down a window? Are you like, and that's assuming it's like a crank window, right? This is a button. You just go, roll down your window. Like, make it make sense. And honestly, if someone's like, hey, we need to talk to you, trying to flag you down, again, it could be because they're looking for some help and they're not actually the people that you were initially pursuing. But you wouldn't know because you barely have a description.
Thank you, Judge.
Okay. All right. Has the weapon been rendered safe? It has?
It has.
Sorry, neighbor? Okay, all right.
Would you take a look at 10A and tell us if that is the firearm that Mr. Stevens had? Look at it, pick it up, and look at the serial number, please.
Yes, ma'am. It matches the serial number.
And does it also match the,
Description, yes, it does.
and so is 10A the black Beretta .380 caliber semi-automatic pistol you described in your report?
It is.
State tenders 10A as evidence.
Any objection to state's 10?
No, you have to plead.
Anybody else? Anybody else have any further objection? All right, state's 10 is admitted. Maybe published as you see fit.
And do you guys, I'll find the clip. Do you guys want to watch later? Do you remember when Love was handling the firearm? with the guy that like resold one of the firearms to Jeffrey Williams. It was later in the trial. It was like day 100 something. I will find that and we can watch that.
Captain Pettis, what was the age of Trontavia Stevens at the time that this incident took place? And if you don't remember, I'm going to ask you to read it from the report that has already been admitted as evidence. And the date of birth would be
Per the report, Mr. Stevens was born on April 26, 1993.
And what date did this incident take place once more?
January 25th, 2013.
Thank you so much. That's all that I have for now.
Cross, Ms. Adams? All right, go right ahead, sir.
Okay, so this is, and we did get some Keith Adams towards the end of the trial, but some of his most beautiful work was done right away and with these beginning witnesses. So if you didn't catch the early days, Adams is just awesome here.
Oh, yes, sir. Go ahead right in. I'm sorry.
Thank you. Captain, that's good afternoon, sir. How are you?
Good afternoon. I'm doing well. Thank you.
All right. You and I have had a chance to chat before. Sure.
Yes.
All right. So I represent Philly, City and Black law in Mississippi. But I do want to ask you some questions about this gentleman that you arrested, Mr. Trontavia Stevens, and the incident surrounding him. Okay.
Okay.
You were an APD officer back in 2013, yes?
Yes.
You arrived at the location that we've been discussing at about 4:30 in the afternoon. Sure.
If that's what the report says, yes.
And I know we've spent some time with the report. You got it in front of you?
I do not.
All right. Matt?
Yes.
Yes.
Just please identify for the record, please. What?
Thank you, Judge.
Okay.
Judge, I'm going to, with the court's permission, approach the witness and show him what's been previously identified as states 50 Alpha 50A.
Okay, it's been admitted, so yes, that's fine.
All right, thank you, Judge. That's your report, right, Captain?
Yes, sir.
That's a report you prepared back in January 2013, right?
Yes, that's right.
Was that about 15 pages long, that report?
The report itself is actually only 2 pages. What's attached here is the warrant application, another copy of the report, and the actual warrants, along with the copies of the arrest tickets.
All right, the report itself that you wrote about 2 pages, right?
Yes, sir.
But it fairly and accurately captures what happened on that day and your involvement in everything that happened. Is that true?
Yes.
Okay. Just to be clear, you were not involved and you don't know anything personally about how this vehicle that you saw came to be taken, right?
Correct.
I mean, you were aware at some point that this is something that happened over Newton, right?
I would have to look at the report to tell you what jurisdiction it was stolen from.
Because you don't know personally.
Correct.
And then you don't know where the car was, who was in possession of it, or how it came to end up in this apartment complex where you saw it, right?
Yes.
You don't know who, Octavia Stevens, anybody else, was ever in possession of that vehicle prior to the day that you showed up in that apartment complex. Is that true?
Yes.
Okay. Now, I want to jump ahead a little bit and then come back, because what I want to make sure I'm clear on is that what you actually ended up arresting Octavia Stevens for was aggravated assault, right?
That was one of the charges.
The
The other one was pointing or aiming a pistol at another, and the last was the warrant that he had.
Okay. Essentially, what you, the officer who was involved, who was the crux of this case, what you charged the
Objection, Your Honor, as to the testimony about the case that Mr.
What's your objection, madam? Is it form? Is it, what is it?
testifying.
I'll sustain it as to form. Just rephrase, Mr. Adams. Okay, all right.
You, you were the officer who took out the charge, right?
Yes.
You are the person that's listed as the victim in this case, right?
Yes.
And the criminal offense that you charged Mr. Octavia Stevens with was aggravated assault, right?
Yes.
You didn't charge him with auto theft, right?
Correct.
Didn't charge him with carjacking, right?
Correct.
Because you had no evidence that he did any criminal act other than what you said was an aggravated assault, right?
Correct.
Okay. In fact, what happened here, and I'm jumping back now, is that you get to the apartment complex because you advised over the radio that a stolen vehicle is located in this area, right?
Yes.
Okay. You get there, you are in plain clothes.
Yes.
You don't have a uniform on, you're dressed regularly.
Correct.
Your partner, Officer Ramirez, also in plain clothes.
Correct.
Dressed regularly, no uniform, nothing like that.
Right.
You're all in an unmarked car, right?
Yes.
No police markings on the car, nothing that identified it as a police car, right?
Correct.
Anyone looking at the vehicle would see a regular car with two regular looking folks inside the car, right?
Yes.
Okay. You pull up, and the car that we're talking about is parked there in location, and you guys sit on it.
Correct.
About 45 minutes.
Yes.
At some point, you all don't know what happened to it because you saw it coming back your way.
Right.
Which suggests obviously that it left without you knowing that it left, right?
Right.
Okay. Comes back and it backs into a parking spot.
Yes.
Okay. A person gets out of that car and that person starts to walk towards apartment number 7 that you referenced, right?
Yes.
Now, that person, from your observation, you're inside the car and your windows are rolled up, right?
Yes.
And you move towards where the car had backed in. True?
Yes.
All right. You're now 10 feet away from this car, maybe from here to about there, right?
Yes. Yes. 10 feet.
Windows still rolled up, plain clothes inside the car, and some people come out from apartment number 7.
Yes.
All right. Now, Octavia Stevens, the person that we're talking about, who ends up, the person with the gun, the guy you arrested, he is not the same person who had gotten out of that car.
Correct.
In fact, at no point in this day did you see him interact with that car at all.
Correct.
Right. What you saw was him and other people coming towards your unmarked police car with the windows rolled up, with regular dressed individuals inside, and you saw them motioning to roll down the window, right?
Right.
And you said they appeared to be aggressive.
Yes.
In fact, one of the words you used is that, I think you said, Octavia Stevens appeared to be the most violent in his actions, right?
Yes.
Now, when you testified a while ago for the state, they asked you a couple questions about this. You said they were flashing gang signs, right?
Correct.
Now, you didn't say that in your report, did you?
No.
And I mean, you wrote a 2-page report, and it was very detailed about everything that happened and everyone who was involved, down to names and dates of births, right?
Right.
You put a serial number in there, right?
Yes.
And you're trained as a police officer that anything that is of significance, like if you think, for example, something is gang related, you put that in the report, right?
Right.
But that report, the same one that she had you read, right, because you couldn't remember some stuff, In that third paragraph where it talks about what you saw those people doing, you ain't say nothing about, I saw gang signs, right?
Correct.
What you said was that the person who would later be identified as Troncavia Stevens, and again, I'll represent that here, but what you said is that he was moving towards your car, right?
Right.
Motioning, roll the window down, right?
Right.
And then, and you never did, you didn't roll the window down.
I don't think so.
Okay, what was the better attempted?
I don't know.
You remember?
No, sir.
All right. You saw him motion towards his waistband or grab a gun that was in his waistband. That's what you said, right?
Yeah.
And held it down like below his waist and pointed at you and your partner.
Correct.
Kind of like this, all right?
Yes.
That is the element of the aggravated assault that you saw and that you ultimately charged him with.
Yes.
You drove off at that point.
Yes.
Right, wasn't any shooting or anything like that. You drove off and you called for either backup, what do you call it, a takedown team?
Yes.
Okay. All right. So that was the problem, the assault, right?
Correct.
So you show up, takedown team for one other car, a bunch of cars?
I don't remember the exact amount.
Would it be fair to say that within a relatively short period of time, there were cops crawling all over that location?
I don't think that would be
Beautiful
a fair
Avenue.
assessment. No, sir.
APD showed up, right? Other APD officers showed up, right?
Yes.
At some point, Georgia State Patrol was involved in this incident, correct?
Yes.
At some point, Norfolk State, Norfolk Railroad Police were involved in this incident, correct?
Yes.
Okay, a couple of different jurisdictions of police.
Yes.
Police went to the apartment number 7, right, and ended up getting those people out of the apartment, right?
Yes.
Police followed the Buick that Mr. Stevens was in for some period of time down to the gas station, and ended up getting those people out of the Buick, right?
Yes.
And you recovered a gun.
Yes.
Okay, well, not you personally, but a gun was recovered.
Yes.
That you would later say, yeah, looks like the gun that, that kid had, that he wanted.
I was personally involved in the recovery.
Okay.
Yes, sir.
All right. It was something like that, right?
Yes.
This is what else just not question, Judge?
You may, sir.
No, states,
50, no, what's that?
2A. Subject Madam Prosecutor Choi?
Yes, sir. And 3, is it just 2A?
Is it 2A and 3A, sir?
Yes, sir.
The only one.
Yeah, it's 2A and 3A.
All right, thank you. This gun, right?
Yes.
Out of this bucket?
Yes.
Okay. So, a question or two about descriptions. The person who was in the car, who got out of the car, as you referenced, was wearing black.
Yes.
Black do-rag or something like that?
Yes.
Black shirt or hoodie or something like that?
Basically all black.
Okay. Confrontation Stevens is a guy, he had a whole lot of hair. All right, like that.
I have no idea.
Here we go.
No,
Look
sir.
at Love smiling already.
All right. At the time that this incident occurred back in 2013, you had been an officer at APD for how long?
I got hired November 14th, 2006.
All right. By that time, you had received what I think I heard you say was some training in regards to gangs and gang recognition and stuff like that, right?
Yes.
All right. You were trained and you were told that if there's an incident that occurred and you believe it to be gang related or anything like that, that you indicate that on the police report.
Probably.
Okay. You didn't indicate that anywhere on this police report that there was any sort of gang involvement in this case, did you?
No.
All right. If you thought that there was some sort of gang offense committed.
Objection, cause for speculation.
Let's stand this if you can rephrase, sir.
You didn't charge him with any gang offense.
No, sir.
You didn't charge anybody with any gang offense on that day, right?
Correct.
All right. 10 seconds if you don't mind, Judge.
Not a problem, sir.
Maybe a little more. I think I heard you say earlier, or did I hear you say earlier, that one of the things that they were looking for in apartment 7 were keys to the stolen vehicle?
Yes, sir.
You weren't any keys found, right?
No.
Nowhere, anywhere on the premises, on location, outside, in the car, in the blue car, nowhere, no keys found.
Correct.
Okay. That's all I got. Thank you.
Any further
Look how pretty she
examination?
gets out.
Yeah, go ahead, Mr. Matthews.
Chad, look at Adriane Love forgetting that there's other attorneys and other defendants that have the right to cross-examine this witness. Look at this lady. Oh my goodness.
That's all I got. Thank you.
Any further examination? Yeah, go ahead, Mr. Matthews.
Good afternoon, sir.
Good afternoon.
And just so that I'm clear, no time after you completed your report did you offer a supplemental report indicating that you observed gang signs?
Correct.
No further questions. Thank you.
Mr. Williams, anything?
So the whole point of that beautiful, beautiful question from Matthews is there is nothing to tie this to gang related activity until after the fact, because it's not in the report. It wasn't even added as a supplement after the fact back in that period of time. But today somehow, and this is 2024, this day of trial, in 2024, suddenly all of this somehow we're tying this to more individuals by saying that gang signs were being thrown.
All right. Mr. Shard, anything?
No, thank you, Your Honor.
Ms. Westmoreland, anything?
No, Your Honor.
Mr. Weinstein, anything?
No, Your Honor.
All right, any further redirect, madam?
Listen to the subject of redirect. The subject of redirect.
Captain Pettis.
Yes.
I'm not going to keep it much longer, but you were asked on cross-examination, specifically whether or not you made any arrests of Mr. Stevens or took out any warrants on Mr. Stevens for the hijacking of the motor vehicle that you were investigating. Do you remember being asked by that?
I do.
Mr. Adams, that question?
Yes, ma'am.
So, beyond receiving a report of a located stolen vehicle, did you have any facts about what had happened in Newman
No, ma'am.
as related to that vehicle? And so you were also asked, or you stated in your report, when you stated in your report about the person driving the stolen vehicle and where they went. Notwithstanding where they went, you didn't find, according to your answer with Mr. Adams, you didn't find the keys inside the apartment where they went.
No, ma'am.
And the people who exited the apartment, Mr. Stevens was one of those people?
Yes.
The same one that threw the gun?
Even, is it just, I mean, maybe there's something else going on, but even the bailiff is over here laughing. Look at him.
Notwithstanding where they went, you didn't find, according to your answer with Mr. Adams, you didn't find the keys inside the apartment where they went?
No, ma'am.
And the people who exited the apartment, Mr. Stevens was one of those people?
Yes.
The same one that threw the gun?
Objection to the leading.
Sustained.
Was that the same person that threw the gun?
Yes.
Did Mr. Stevens run from uniformed officers?
No, ma'am.
When he was running or leaving, he discarded that gun, who was after him?
Nobody.
How did you all then encounter him?
We circled the apartment complex again in an effort to see where he was going and what he was doing.
I'm sorry, but does that seem like somebody was following you? Was anybody following him? No, ma'am. Well, then what did you do? We followed him. Like, what?
Because he ran the opposite direction that we were driving.
When you say ran,
He,
who was he running from?
I don't know.
All right. Were you all pursuing him?
No, we were going the other way. He pointed the gun. We drove the other toward the street, and he ran back toward the back of the apartment complex.
Did you said you called for backup?
Yes, ma'am.
Did backup arrive?
Not at that time. No.
How long after did backup arrive?
Long.
The time it took for us to circle the apartment complex, see Mr. Stevens re-enter the apartment complex through a hole in the fence, flag down the Buick that was driving by, get into it, go back around the apartment complex, so half of the circle back toward the street. Then they made a left, which was south on Old Hateville Road. Then a patrol car arrived, and we directed them toward the vehicle that Mr. Stevens had entered. So maybe 2 minutes. That would be my approximation.
Are there lights flashing?
No, because when the patrol car approached the Buick stopped on its own, and Mr. Stevens exited the vehicle.
Okay. Now, how often did you see people flash gang signs at you during your time as an officer?
My guess would be on more than 10 occasions.
And this was prior to this occurring.
Sustain the question.
Was this prior to your seeing Mr. Stevens and the others come out and get arrested?
Yes.
Mr. Adams asked you
Look at Steele.
not putting in your report that Mr. Stevens flashed gang signs at you. Do you remember that?
Yes.
Did you put in your report what the person who pulled the gun on you was wearing?
Can I refer to my report?
Please do.
Isn't this already, they talked about this. They're gonna say black clothes, black do-rag. What are they doing?
I did not write in the report what the person who flashed the gun at me was wearing.
Mr. Adams asked you about the person, the hairstyle of the person who flashed the gun at you. Did you put in your report the hairstyle of the person that you actually charged with aggravated assault was wearing?
No, I don't need to. I did not describe his hairstyle.
Wait, is it any less true that he had a hairstyle? I mean, it's something.
I sustain the question.
Did he have?
You ask somebody if they had a hairstyle. Everybody has a hairstyle.
A hairstyle?
To my recollection, he did.
Was he wearing clothing?
He was.
Was the fact that you didn't put it in your report indicative of the idea that it didn't exist?
Yes, it is. I sustain the question. Remember, you got him on redirect.
does the absence of those facts in your report equate with the absence of or the existence of those facts?
It does not.
Okay. Is there any particular reason you didn't put what Mr. Stevens, who's flashing the gun at you, was wearing in your report? Any particular reason?
Look at Doug.
I did not write a description of his clothing because he was captured so quickly afterwards.
Okay.
The time wasn't great enough to account for what he was wearing in the report.
Is there any particular reason you didn't write what gang signs he was flashing at you in your report?
No, ma'am.
Okay. And is there any particular reason you didn't write his hairstyle in your report?
No, ma'am.
How are you able to remember today that the gentleman that exited that apartment came out flashing gang signs at you, and in particular that Mr. Stevens was the most aggressive one flashing the gang signs? How are you able to remember that?
He's the one we had our eyes on.
I have a general recollection of the incident because this was the last investigation that I conducted as an officer before I got promoted to investigator. So it's
Oh,
more
wow.
important.
That I didn't know. I've been harping on how he only did this for 6 months, and I was thinking, hey, this wasn't for him, but it seems like he got promoted, not just transferred somewhere else. Look at the faces in this frame.
I guess than others. As far as the question that you asked about the gang signs, I've been, since I was subpoenaed here and had to recollect this incident and read my report.
But it's not in your report, Doug. Is that a gang sign he just threw up?
I think that when I let me refer to my report to what I actually wrote.
So you remember because you were subpoenaed and you looked at your report, but right now you don't remember. And you have to look at the report that you just looked at and said that's why you just remembered for the rest of your testimony. But it's also not in your report. Oh.
My answer is that when I wrote that Mr. Stevens was more aggressive than the other males, I was mentally incorporating the throwing of gang signs as a universal sign of aggression, but I didn't write it out.
And when you were asked by Mr. Adams, were you told to indicate if an incident was gang related? You answered probably. Do you remember answering probably?
Yes.
Can you state with certainty that at that time you had been instructed to make those kind of indications on your report?
I cannot.
And did you, as a matter of course, list out every single detail of every incident that you responded to as an officer?
No.
Were you assigned to the gang unit at that time?
No.
Is the information you've given to the jury the best recollection that you have?
I sustain the question.
Yes, Your Honor.
further, madam.
Do you have any particular relationship with anyone
Judge Glanville's aggressively telling her to pump the brakes.
at the state's table that would cause you to say anything that was not true?
No, ma'am.
That's all I have.
Anything further, Mr. Adams?
Just a little bit.
Just a little bit. Westmoreland is ready.
You're a police officer, right?
Yes, sir.
You're a captain.
Yes.
You, what you do when you conduct an investigation affects people's lives, right?
Yes.
You arrest people and take their freedom and take them into custody, true?
Yes.
And you are charged with writing reports that reflect the truth so that someone down the road, maybe a prosecutor, can rely on that information and know if to or how to prosecute someone, right?
Yes.
That is extremely important. Would you agree with me?
Yes.
All right. And so when you write your report, and when you were writing reports back in 2013, those things were just as important then as they are today in this courtroom, right?
Yes.
Okay. And so you weren't a rookie officer back in 2013. You had been on the force for some math, 7 years?
Yes.
Okay. And so before coming in here to testify, whether it's today, I don't know, yesterday, last week, whatever, did you have an opportunity to sit down with the prosecutors and talk to them about your testimony and your recollection of the events of 2013? Did you do that?
Yes.
Okay, right. And you still came in here today, and you came in here today rather, and this is the first time, right, that you're mentioning anything about gang signs that you saw when you were brought in here to testify in this quote gang case, right?
Yes.
Okay. Now, just out of curiosity, what was the gang signs?
Hold on, what's the basis for your objection?
Well, with respect to.
What's the basis of your objection?
For first time.
I'm gonna overrule the objection.
Okay.
Go ahead, Mr. Adams.
Okay. What was the gang sign you saw being thrown up that day?
No idea.
No idea.
None.
Okay. You know what's a gang sign, right?
Yes.
Okay. Said something a while ago I wanted to touch on real quick. You said that you will quote your words now, mentally incorporating the gang sign in describing the person as being the most aggressive. Is that what you said?
I did.
Mentally incorporating it. But you don't know what gang sign we're talking about.
No, sir.
All right. That's all I got.
All right. May we excuse, oh, I'm sorry. Go ahead, Mr. Matthews.
So, Captain Pettis, I just want to make it clear. You described these events about this individual, Mr. Stevens, pointing a weapon at you, right? And just prior to that, you said that he had flashed these gang signs, right?
Yes.
And you agree that if a person is flashing their gang signs at you and then they point a weapon at you, that's criminal gang activity, right?
I don't agree with that.
Okay.
No.
That's very interesting now in light of the Miles Farley affidavit, where they wrote 3 different affidavits relating to the recent stop with Miles Farley and Javorius Greer. And they have this alleged constructive possession because there was a glove in the glove box. Now, neither of the individuals were the owner of the vehicle, but they end up writing this affidavit 3 different times, and details change across the different versions of them. But Storno, you guys remember that name from this trial, he comes in, and as he's buffing up and amping up this affidavit, he's adding in these extra pages about affiliations with gangs and gang activities, right? It's just something that they consistently lean on and will include if they have the opportunity to. So they're thirsty to include any notation of a gang when possible, but here it's completely absent until this guy gets on the stand and testifies today in a RICO trial. Secondly, we've heard repeatedly, we have 1 arrest. If there were multiple individuals doing this type of aggressive gang sign stuff, why did you only go after the guy you already had a warrant out for and probably already had eyes on? When you don't even know if he stole the vehicle, because we find out that, he's running around somewhere, you don't find the keys, and then he gets in this vehicle as other people are driving it. It just seems like you had a reason to arrest him because of a different warrant, and you're going to tack on this other stuff. And honestly, I don't know if I buy the brandishing story at all. That just seems like somebody wanted to justify being a little scaredy cat.
With any criminal street gang activity, correct?
Correct.
Thank you.
Anything further on behalf of any counsel for the defendants? All right, madam, anything else?
Just briefly, when you spoke with Mr. Adams, and he asked you, is this the first time that you mentioned gang activity? What did you mean him to, or what did you understand him to be when he says first time?
I took that to mean as in regards to Mr. Stevens' actions that day.
Okay. And as they relate to speaking in court or anywhere else, is there any other time you've had an opportunity to talk about what Mr. Stevens did?
Yes.
When?
A couple times this week, today.
In a formal setting?
No, ma'am.
Okay.
Well, actually, let me, I don't know what the adjudication process was with this case. I don't know if I testified at grand jury. So I can't say with certitude that I've never spoken formally about this because I don't remember.
And when you were asked, what was the gang sign by Mr. Adams, and you said no idea?
Yes, I said that.
If you're saying no idea to what was the gang sign, how are you able to testify to the jury that it was in fact a gang sign?
By the forming of the hands, by the overall gesticulation. I think that you don't need to be a police officer, be educated in what sign means what gang and any.
But yet we've had every single gang expert get up here and talk about their training on how to identify gang signs. And now we have this witness saying you don't need to be trained. You don't need to have some other reason why you would be aware. This is ridiculous.
Of the gang rule handbook or any of those things to understand what a gang sign looks like when it's being postured towards you, especially considering the totality of the circumstances that I was in the moment. So I don't.
Were the signs that were being made by the individuals that came out of Apartment 7 similar in nature?
I can't answer that either. I wasn't well educated then on what the gang, what sign.
He's completely contradicting himself. Now he's saying he can't even say that the other individuals' hand signs might have been. So only he's so tunnel visioned on Trontavious Stevens, when he's here. The whole reason they're adding this gang sign issue, right? This officer is dead set on Trontavious Stevens being aggressive towards him because he wants to justify this claim of ag assault. Like, oh, he pointed a gun at me and I was scared. Those are the elements underlying that ag assault charge that's being used as an overt act in this RICO indictment. But here, since Love wants to have this guy connect it to other individuals to make it a gang activity, right? It's not just one person that we're going to say is Trontavious Stevens doing something. It's everybody. This guy either he can't figure it out or he doesn't know what answer Love is trying to get out of him and he's just flubbing it, even though he's trying to cooperate with her.
And relates to each gang, and I'm not today either.
What are those signs that you saw, signs that you had seen in similar circumstances in the past?
Yes.
Thank you. That's all that I have.
May I ask?
Yes.
Captain Pettis, did you get any training at the police academy on gang?
Probably.
That's all I have.
Anything further, Ms. Adams? All right, anybody else? All right, may we permanently or temporarily excuse Captain Pettis?
I don't remember that. I don't remember. Maybe I tuned out thinking that was it. Maybe I thought that was because I wasn't watching this on stream, so I might not have gone through everything back in the day. I know all the details of the stuff we watched together because we watched every second. But I'm wondering if I stopped right when redirect was done, thinking surely there's no more. I don't remember him saying probably.
Did you get any training at the police academy on gang?
Probably.
That's all I have.
Anything further, Ms. Adams?
Okay.
All right, Anybody else? All right, may we permanently or temporarily excuse Captain Pettis?
Your Honor, we can, at least temporarily. I don't anticipate needing him again, but I don't know how things are going to go, so we're releasing him for today.
All right, Captain Pettis, thank you for your patience with us. I'm going to.
All right, so that is, and you guys saw like the hair thing all started to, you know, get to Adriane Love when on cross-examination, the defense, Keith Adams, started asking, you know, he didn't write down any other description, right? You know, he didn't write down anything. You just, what did you notate again? And he was like, the black clothing, it was a black male, and there was a black do-rag. And then, and the point of that is to establish if somebody had distinguishing features, you would think that if you're trying to find a suspect, you would notate that, hey, we're looking for a suspect with these things, such as dreadlocks, or, you know, his hairstyle, even though he had a do-rag, you could tell that there was like volume under there. And none of that stuff was notated. Even worse, he ends up saying later, because of Adriane Love's redirect, where she gets it, you see her scribble down on the paper. When she gets up there, she's excited to ask, hairstyle, hairstyle, hairstyle. Did he have a hairstyle? Did he have clothing? Well, because of that redirect, we get additional prodding on recross, where we start to get into, well, even after you end up detaining Chontavia Stevens, because he had a warrant, so now he's arrested. Well, when someone's arrested, you have more time than ever to write down identification characteristics. And we still don't have anything anywhere with anybody denoting that he had a dreadlocks hairstyle at the time. And this is going to be relevant if you rewatch stuff with Chontavia Stevens. They end up going back and forth about, did the suspect have dreadlocks or not, with other issues that come into play. And it just becomes a constant back and forth anytime that Chontavia Stevens is a suspected player in some incident related to this trial. So that was the origin of it here. This, well, you keep going after these people and tying it to Tick, and you're constantly pulling Tick over. Just anytime you see his vehicle, it seems like. And yet you keep charging him with things or saying he's a suspect for things that don't match the description of the individual. So that was the origin of some lore there. From this same day, you guys, this was a crazy day. I think 7/18. The second part of this lore, I always play a certain clip. And I think it's really important that we get to it. If you don't remember where it's from, I have recently remixed it.
It was an amazing time.
Are you certain?
But just some very interesting questioning is the reason we have that "Are you certain" clip when a different officer, different witness, does not give the answer that Adriane Love wants. I think we start at 7/18 with this witness. So make sure this is the point. And again, this is day 4. This has been the way Love was for the whole trial. After this, we'll move back up to like the Alfred plea, the rebuking, and all of those wonderful, wonderful moments with Adriane Love. Just a mess.
First name is spelled Michael. Last name is spelled Monheim.
Good afternoon, Officer Manheim. Would you tell the jury a little bit about yourself and tell them where you currently are employed?
I've been employed with the City of Atlanta Police Department for 18 years now. My assignments is patrol officer, responding to 911 calls, accidents, proactive policing, and engaging in the public.
What was that last part?
Engaging with the public.
And what area, if any, in particular of Atlanta are you assigned to cover?
The downtown and midtown area.
Are you certified as a law enforcement officer in the state of Georgia?
Yes, I am.
Have you remained so certified in your entire career with the Atlanta Police Department?
Yes.
Prior to working with the Atlanta Police Department, what was your background?
I was prior military, and I worked for Armored Car Company.
Say the last part.
Armored Car Company.
Okay. what was your service? What branch of the military?
The Marines.
Thank you for your service. How long did you serve in the Marines?
8 years.
From what year to what year?
From 1996 to 2004.
And what was your position within the Marines?
I was infantry personnel.
And were you honorably discharged?
Yes.
In September of 2013, were you working with the Atlanta Police Department?
Yes, I was.
What was your position at that time?
I was a patrol officer at that time.
And were you assigned to any particular area of Atlanta?
The Midtown area.
On that day, did you have an occasion to conduct a traffic stop on a person that you later learned was Jeffrey Williams?
Yes, I did.
Would you tell the jury how that came to be?
On the date that you had mentioned, I was sitting at the intersection of Techwood Drive and 14th Street, which is near 1132 Techwood Drive. I was sitting there monitoring the flow of traffic during rush hour at that time. I was in a very far right lane facing westbound on 14th Street at that intersection. At around 8:26 in the morning, I observed a black Dodge Challenger. It was traveling westbound in the middle lane, which is a straight lane only. The tag number, I believe, is going to be P as in Paul, IN 4143. And it passed me in the straight lane only, and then it made a left-hand turn that was now traveling southbound on Techwood Drive. I observed that he made an improper left turn because he wasn't in the turn lane to make a left turn. And our signs indicated that have lane assignments. I then went to go pull the vehicle over, and he continued southbound on Techwood Drive, approaching 10th Street. As you approach that intersection, there is a right turn lane only, and that is clearly labeled with the sign saying right lane must turn right. I observed him traveling that, and he continued straight, going southbound, merging on the I-75-85 southbound ramp from 10th Street. At that time, I made a traffic stop on the vehicle on I-75-85 southbound underneath the 5th Street overpass.
At the time that you first observed the vehicle committing traffic violations, did you know who the driver of the vehicle was?
No, I did not.
And can you tell the jury, do you have a basis for knowing approximately how far the location of 1132 Techwood Drive is when you first noticed the vehicle from the address of 11 Demarest Avenue in Buckhead?
Approximately 3 miles.
So how is it when you were able to conduct the traffic stop? Tell the jury what it is that happened next.
The vehicle, the driver rolled down the window. I explained to him why I pulled him over and asked him for his driver's license. He said he didn't have a driver's license on him, but he gave me his name and his birth date.
And what name and what birthday did he give?
Jeffrey Williams.
Now, would you give the jury a general description of the person that was in the vehicle?
He was a black male, thin built, tall, and he had some long braids.
Okay. Now, you said that he told you he did not have a license?
That's correct.
Were you able to run this information and confirm that he was who he said he was?
That's correct. When he gave me his name and his birth date, I ran his information on the ACIC.
Just go ahead and you have some information sources, databases.
Correct.
Okay. So after that, after you were able to confirm who he was, did you allow him to drive away in that car without a license?
No, I did not.
What did you do?
At that time, I came back to the vehicle, asked him to step out of the car. He did. I placed him in handcuffs and told him he was under arrest for failure to obey a traffic control device at the intersection of Techwood Drive and 14th Street for making an improper left turn, and the intersection of Techwood Drive and 10th Street for going straight in the right turn lane only. They had no driver's license on.
Okay, hold on one second. I'm gonna keep you from going too far because I want to ask the question to make certain that you're responding to the question. All right. So when you placed him under arrest, just one second. Your Honor, may I approach really quickly? I want to make certain that we have a matter settled before we go on. It'll be good.
Deal.
Okay, can y'all hear me? All right, Kim.
Whisper. Adams looks like he's struggling.
Officer Manheim, I'm going to just ask you to step outside for just 1 second, please. If you wouldn't mind, sir. Don't get too comfortable.
And don't forget, this is where they were like in the beginning, like most of the APD or wherever they work now, those witnesses were coming in and their faces weren't being shown, and some of them were wearing masks, so their identity wouldn't even be revealed in court.
How are you going to handle the matter that we?
I think they might they show her shoes. I think they might confer just over like themselves. I don't think we get to hear it. I don't remember. Mute it while we do this so it's not blaring.
Officer Manheim, forgive my interruption. Would you please go ahead and tell the jury what happened after, did you allow Jeffrey Williams to get back in the car if you wanted to use unlicensed?
No, I did not.
Okay, and what did you do at that point?
At that time, I placed him under arrest for driving while unlicensed, improper left turn, and failure to obey traffic control device. As I started walking him back to my patrol car and handcuffs, I observed in the cup holder of the vehicle a clear plastic bag with some blue pills inside of it, sitting in plain view. I put them in the back of the car, and then I went back to retrieve the pills from the cup holder, and they were suspected Xanax pills. I did a further search of the vehicle, and there was a black Sig Sauer 9mm handgun underneath the front passenger seat.
I'm going to show you what has been marked as, sorry. Oh, you have? As 12 Bravo, and ask you if you recognize the exhibit marked 12 Bravo. You can go ahead and take a look.
Yes, I do.
How do you recognize that exhibit?
This is the firearm that I had recovered that was underneath the front passenger seat.
What is the serial number on that firearm?
The serial number is UU 748574.
What did you do with that?
So it's like really loading slow, and I've been having trouble with the Georgia document portal. It keeps showing me that documents are hidden on cases where I've gotten documents for, and it's intermittent. It goes in and out. But there was a motion relating to this moment in time, where before Manheim is on the stand, where as a motion in limine, Brian Steele wanted to make sure that the state doesn't ask this witness about Jeffrey Williams' silence post-Miranda. So when he was arrested by this officer, he's questioned, he's asked, who does this firearm that we found, who does this belong to? And Jeffrey Williams is silent. He doesn't say anything. But because it's post-Miranda, not supposed to be commenting on that. And Judge Glanville agreed that we're not allowed to mention that in front of the jury. So
That firearm once you recovered.
I ran that on ACIC to see if the firearm was reported stolen, and it was reported stolen out of the city of Atlanta.
Okay. Your Honor, the state tender states exhibit 12 Bravo is evident.
Any objection to 12B?
No, Your Honor.
12B is admitted. Maybe probably should you see that?
Yes. Would you? Great job. All right. All right.
yeah, this is 2013. I almost said 2023. 2013.
And what is the item that I'm holding here?
That is the magazine that goes to that gun.
Okay. And we don't keep ammunition with the guns in court. Thank you, Honor. Now, when you said that the gun was reported stolen out of Atlanta, by whom was that gun reported stolen?
It was reported stolen by, I want to say it was an Andrew Phillips.
Okay. And were you able to, or do you recall off the top of your head, the incident report in which that gun was reported stolen by Mr. Phillips?
I don't remember the APD case number off the top of my head, but I do recall that it was taken from a burglary.
You're saying and contradiction.
Yeah. May I respond?
Yes.
Your Honor, the officer is talking to the jury about what was reported and why it was stolen, why he did what he did as related to the firearm, and
Okay. I'm going to overrule the objection.
Go ahead, please.
That the firearm was reported stolen from a burglary from 11 DeMorris Avenue, which is in Buckhead, and that firearm was reported stolen on July 10th of 2013.
All right. And was the owner of the firearm able to, how did the Atlanta Police Department get the serial number from the owner of the firearm?
Basis.
Same. What?
Overrule the objection.
How was the Atlanta Police Department able to obtain the serial number for the stolen firearm?
The original responding officer that took the initial report, I believe, was the one that got the serial number from the victim, so he can list it as stolen.
And I'm going to show you a document we will mark State's Exhibit 55. 55 Bravo. And for identification purposes, I will show Mr. Steele. I'm going to show you what has been marked as State's Exhibit 55 Bravo. And ask you, are you familiar with State's Exhibit 55 Bravo?
I am now, yes.
Okay. Now, when you say I am now, what are you looking at it that makes you familiar with that exhibit?
It has the original case number for the initial report, but it was a supplemental report to the initial report.
Okay.
And it indicates on this police report that the serial number was added to the police report so that the vehicle could be put on the system as stolen.
The vehicle is done.
I'm sorry, we're done.
Okay. And what serial number is listed on that report so that the firearm to be listed or reported as stolen?
The serial number is listed as UU748574.
After you obtained the information regarding the stolen firearm and the absence of a license as well as the Xanax skills, did you take out any warrants for Mr. Williams' arrest?
Yes, I did.
All right, and what did you charge him with?
I charged him with making an improper left turn, failure to be a traffic control device, driving without license, theft by receiving a stolen firearm, and possession of a controlled substance.
Now, is the person that you, do you recognize Mr. Williams? Would you recognize him if you saw him today?
Yes.
All right. Do you see him in the courtroom today?
Yes, I do.
Would you describe what he is wearing and where he is seated for the jury?
He is at the second defense table in front of me. He is wearing a black turtleneck, and he's got his hair pulled back in braids.
Your Honor, the record reflect that the officers identified Lieutenant Jeffrey Williams.
Mistrial.
Officer Manheim, did you have any contact with the district attorney's office in terms of reporting that you had made these arrests?
Yes, I did.
And did you submit to the complaint room your warrants and your tickets that you issued in this arrest?
Yes, I did.
And did you have any control over the disposition of the case at any time thereafter?
No, I did not.
And do you have any personal knowledge, yes or no, about how it was that the district attorney's office chose to resolve the case?
No, I did not.
Okay. I think that's all that I have for now. Thank you.
Cross.
And Your Honor, we did not, we do tender the firearms state 12 Bravo is that.
That's already been admitted. Yes, sir. Yes, ma'am.
Afternoon, officer.
That's reminding me the way he walked up there of one of my favorite clips of all time. Please tell me I still have it in here. Yes, I do.
Oh, help me. All right, let's not comment on the various attorneys.
Hello.
Good afternoon.
You met Mr. Williams on or about September 9th of 2013. Is that fair to say?
Yes.
And to be frank with the jurors, you don't remember this traffic stop, but you're using reports to refresh your memory. Is that fair to say?
Compound statement.
I stand as to form. You can just rephrase it, chop it down a little bit.
You don't remember this traffic stop on your own memory. Is that true?
I would say yes, that is true.
But your memory got aided with your report that you wrote. Is that okay to say that?
Yes.
Okay. And you're doing your best you can today to articulate accurate facts to the jury.
Yes.
With regards to the burglary, you are not involved with the investigation, responding to the burglary, God forbid, of the Phillips home in Buckhead or anything like that. Is that accurate?
That is correct.
And that burglary, from what you read, is 2 months before you run into Jeffrey Williams on September 9, 2013. Is that right?
That is correct.
And when I say 2 months before, I may not be to the date, but approximately July 10th of 2013 is about 2 months before September 9, 2013. Is that fair to say?
That is fair to say.
And you're not telling this jury in any way that you have any scintilla of evidence that Mr. Williams was involved in that burglary. Is that fair to say?
Form.
I'll stay in this form. You can rephrase.
Is it true that you do not have any information Mr. Williams was involved in any burglary of the Phillips home?
Objection.
Is that true?
As to form.
I'll let him answer that. I'll hold that objection. You can answer that.
Say the question one more time.
Sure. You don't have any information at all that Mr. Williams is involved in the burglary of Mr. Phillips or Miss Phillips' home. Is that true?
That is true.
Okay. So now we're 2 months later. It's approximately 8. I think you said 8. Hold on one second. 8:30 in the morning. Is that fair to say?
That is fair to say.
And Mr. Williams is driving around Techwood 14th Street. If you could just tell the jurors what part of Atlanta is that, if you don't mind.
That is close to Midtown.
Okay, that's not the Cleveland Avenue. You know where Cleveland Avenue area is?
I do know where Cleveland Avenue area is, yes.
And Midtown is not near, near is relative, but it's not the Cleveland Avenue area. Is that fair to say?
That is fair to say.
Okay, so Mr. Williams is driving and you see him, you say, making a left turn from a straight only lane, and then you get behind him, and then later he continues in a right turn only lane but goes straight. Is that the 2 traffic infractions you saw?
Yes, that is.
Okay, and then you blue lighted Mr. Williams, he pulls over the car. Is that fair to say?
That is fair to say.
Okay, he didn't flee from you or anything. You blue lighted him, you pulled over, and you approached the car.
That's true.
Okay, and Mr. Williams was totally professional and cooperative with you. Is that fair to say?
He was cooperative.
And he gave you his name, date of birth, told you he doesn't have a driver's license, right?
Yes.
And you confirmed that?
Yes.
And then you felt duty bound to arrest him because he's driving without a driver's license. Is that fair to say?
Yes, that's fair to say.
Okay, and again, he's cooperative with you.
Objection. Asked and answered.
I'll stay in the question.
At this point, he's cooperative.
Objection. Asked and answered.
I'll sustain the question. Okay. Move on.
Okay, so I want to talk first about what's been marked as State's Exhibit 12B. Do you still have that exhibit in front of you, the gun?
No, I do not have the firearm in front of me.
Okay. Madam Court Reporter, do you have it? May I approach, Your Honor?
Yes.
So 12B, through your work, you find out that this item, from running a computer check, comes up stolen from the serial number. Is that how it works?
Yes.
Okay, and you found the item, though, underneath the passenger seat on the floorboard. Is that right?
I need to teach you about handling weapons. Please point the muzzle always downward, no matter if it's unloaded, okay?
I know it's unloaded. Yes,
You
sir.
make everybody nervous, okay? Including Mr. Kern, so you're pointing it out. All
I apologize, Mr. Curtis. Is that true? It's on the floorboard underneath the passenger seat. Is that true?
Yes, that's true.
Okay, and this is a two-door car?
Yes, it is.
And no other occupant of the car?
Correct.
And how long was that gun underneath that passenger seat floorboard?
Objection. Speculation. No foundation.
I stay in the
So
question.
you know how long that gun was under the passenger seat floorboard?
I've got no idea how long it was underneath there.
And that, tell the ladies and gentlemen jury if Mr. Williams owned that car.
Objection. That's speculation.
Why don't you rephrase it? I'll sustain it as a form. You can rephrase it.
Car, right?
Objection as to foundation.
Ask me a question.
There's no foundation.
I'll sustain the question. Mr. C, why don't you just ask him if he knows who owned the vehicle?
The owner of the car was, let me get this right.
And I object again on the basis of foundation because stating it doesn't cure.
Let me help y'all out. Officer Manheim, do you know who owned the vehicle that Mr. Williams was driving in?
Yes, I got that information from when I ran the vehicle tag information.
And Your Honor, the reason that I have the objection is that though he may have run it and no tag came up, he does not know who owned the vehicle. There's been no testimony about personal knowledge of who actually owned the vehicle.
He asked that question, so that question is relevant to his inquiry.
And the owner was you remember writing the owner on your report?
I don't remember the name of the person off the top of my head, no. But it is on the police report.
Okay, and that's your police report, right?
Yes.
Do you have your report in front of you?
No, I do not.
Let me show you what I'll. May I approach, Your Honor?
You may.
Your Honor, I object to this witness being shown that document about that.
What is the document, Mr. Steele?
Officer Manheim's police report.
I asked the court to look at it.
Let me look at it, Mr. Steele. Please. Just hand it to Mr. Kearns. All right, you may want to hand him a clean copy of that, Mr. Steele. It's got all your notes and everything on it.
Let me hand you a copy. Tell me if this is your police report, if you don't mind, report.
Yes.
So Najee, I'm going to spell it N-A-J-E-E, Sanford, or Sanford, S-A-N-F-O-R-D. That's the owner of the vehicle. Fair to say?
Yes.
I'm Mr. Williams is the driver on the day that we're talking about, correct?
Yes.
And the date again is the September 9, 2013, right?
Yes.
And the vehicle's not stolen, right?
The vehicle's not stolen.
Okay. With regards to the firearm, are there any fingerprints of Mr. Williams on that firearm? And at 12B is what I'm talking about.
12B? The firearm itself?
Yes, sir.
No, there was no firearms. I mean, there's no fingerprints lifted from the firearm.
Okay. And you have no evidence whatsoever that Mr. Williams ever touched that firearm. Is that fair to say?
That is fair to say.
And you have no evidence that Mr. Williams even knew that that firearm was in that car. Is that fair to say?
No objection, Your Honor. That would call for.
It's speculation. I'll sustain the questions to form.
Okay. With regards to, I'm moving on to the 7 pills. They're Xanax. Is that fair to say, or they look like Xanax?
Yes.
But not in a container. Is that right?
That is correct.
And when I say container, that's a bad word. Not in a prescription pill bottle like they're supposed to be. Is that true?
That is true.
Okay. And you found them, you said in the cup holder, right?
Yes.
Do you remember writing a draft report in this case before the final report?
Yes, I do.
And do you remember in the draft report saying that the 7 blue pills were in the center console area? Do you remember that?
That is true.
Nothing about plain view or in the cup holder in the draft?
There are cup holders in the center console.
Okay. But you didn't say that in the draft report?
No, I did not say that.
Okay. Now, to be fair, ladies and gentlemen, jury, I asked.
Objection as to the form of the question, then beginning about being fair to ladies.
I sustain the question. Sustain the form of the question. Just rephrase it.
Okay. I asked and you tried. Well, let's go back a little bit. At that time in September 9, 2013, you had the ability to record, and you did record this event incident with Mr. Williams. Is that fair to say?
That is fair to say.
And this is on, when I say recording, we're talking about video as well as audio recording, right?
That is correct.
And I asked to bring to court the video and the audio. Is that true?
I want to say the prosecutor asked me to bring that to court.
Okay. And you tried to find it, right?
Yes.
And other people tried to find it. If you know, if you don't know, that's fine.
I don't know how hard they tried, but other people did look for it, yes.
And it came back that there is no audio or video that I could show to the jury, right?
That is true.
It's lost.
It is lost.
By the City of Atlanta Police Department or the DA's office or somebody there, right?
Your Honor, I object to that latter part.
I'll sustain it as to the.
It's lost by the authority.
Latter portion.
Is that true?
Yes.
All right. You know Mr. Williams to be a well-known musical artist. Is that fair?
At the time of the traffic stop, no, I did not.
No, I'm saying you know that now.
Oh, yes, I do.
Objection as to relevance.
I'll sustain the question.
Okay. Okay. With regards to your encounter on this arrest of Mr. Williams, this is pretty much the sum and substance of everything, right? You went through everything. Is that fair to say?
When I did pull the vehicle over, the vehicle windows were tinted. So I cannot see what was transpiring as I approached the vehicle, getting out of the vehicle and approaching the vehicle. So I cannot see what was going on inside the vehicle.
Okay. You're not saying anything was going on inside the vehicle. You don't know, you're saying.
I'm sitting here saying, I don't know what was going on inside the vehicle.
And we don't have the video audio, right?
The video.
To compound.
I stand this to form. You can rephrase it, Mr.
We don't have the video, right?
That is correct.
We don't have the audio.
Here we go.
Okay.
That was one of the two major things about this. For this incident, they in theory should have had this video, right? We have a lot of missing video in this trial. Oh, it never captured one. One was never captured. We didn't obtain it before it erased. Oh, it overwrote itself. But here, we actually have, hey, this traffic stop was recorded, but we lost the video. We lost the video. Convenient.
Were you aware that this case was resolved in court?
I sustain the objection, Mr. Steele.
I have a certified copy of the disposition.
It's still not in the correct format. I'm still going to sustain the objection.
Okay. I will show you what I'll mark as Mr. Williams number 1. It's a certified copy.
Mr. Steele?
Yes, sir.
Please stop that, okay? It's not, I'm going to sustain the objection, okay? He is not the proper witness for this. And D1, I'm going to mark D1, it's a DW1 as the item for refreshing recollection, so you can start with whatever else when you come up, if you have any other documents.
Okay, this will be number 2, Your Honor. I'll do it as soon as the court lets me.
Okay, all right.
I have no other question. Thank you very much. Thank you, Officer Manheim.
Yes, Your Honor.
Now, here we go. One of my favorite sequences of questions with Love trying to get an answer that she wants.
Officer Manheim, you were asked on cross-examination who owned the vehicle Mr. Williams was driving to the tinted windows. Do you remember that?
Yes.
All right. Now, are you stating to the jury that you have personal knowledge about who actually owned that car?
No, I do not.
Okay, then what is it that you're actually testifying about?
I am testifying to, that is the person's whose name was on the legal documents that purchased the vehicle.
Okay.
And who the vehicle is registered to.
Okay. So is it always the case in your experience as a patrol officer?
I sustain the questions, the leading. You can rephrase, madam.
During your time patrolling the streets of Atlanta, do you always find that the person who is registered as an owner is the actual owner of the vehicle?
No.
Okay. And without saying how,
Here we go.
You were asked by Mr. Williams whether or not you had any information about whether Mr. Williams knew the gun was in the car. You remember that? Yes, when he was
No.
Okay. Well, without saying what he said,
what?
Yes or no, did Mr. Williams indicate that he knew the gun was in the car? Without saying what was said.
No.
Are you certain?
What's the basis for the objection?
I just asked, was he certain?
I'll sustain this. I'll sustain it on the grounds.
Do you recall
answering the question no, would you tell the jury what it is that you are stating? What you understand my question to be?
I sustain the question's vague.
Do you have information regarding Mr. Williams' knowledge of the gun in the car?
Objection calls for speculation.
No, it doesn't.
You can answer it yes or no, and then we'll.
Yes or no only. Did you have information regarding Mr. Williams' knowledge of the gun in the car? That's all I'm asking. If you need to process it, please do before you answer. Because I'm only asking for a yes or a no.
No.
Okay. Do you recall ever indicating that you had such knowledge?
No.
Okay. Your Honor, at this time, I have no further questions for.
And you know what's crazy? If she really had something here, she could have impeached this witness. She could have impeached him if she had something. But she just goes, okay. Like, what?
Officer Manheim, however, we are asking to reserve the right to recall him.
All right, anything further, Mr. Steve, or anybody else?
No, sir.
Anybody else have any other questions? Okay.
All right, so that was, thank you guys for doing the day 4 rewind. Again, this is some stuff that, you know, gets lost in the sauce because this was an extremely long trial. And I mean, really, these incidents didn't pertain to Diamante Kendrick, Shannon Stillwell, once we whittled down to the 2 defendants. So it wasn't something we were going to hear argued in closings, but like 2 of the craziest moments originate with this day, with the "Are you certain?" moment, and then this ongoing forever and ever hairstyle question for Chontavia Stevens. So what a mess. Day 4, you guys, day 4. We'll get back to the gallery here. We'll get back over. We're going to do the Alfred. Wait, I think that's above. And I said earlier in this trial, and I got to correct it, there was not an indictment for Lil Woody. There was just, he was charged. He was charged with the murder. And they didn't actually end up filing a formal indictment. So there was that. But that's all back on the sprinkle day. So let's see. Let's get into the Alfred plea screw up. This is going to be a little bit of a longer one because we're going to watch this. We're going to look at Derek Wright. We're going to look at is Ashley Merchant going to come testify? Do you want that? And then we're going to look at her desperate call to rebuke the defense attorneys. So again, yellow on the screen. I think it was the old banner color is the old cat. I'll put myself in top of the screen, so we know this is future cat. Let's see, edit, move me, update, get this going. This is now day 122.
Now, you were talking about having pled guilty to charges related to the drive-by shooting or to the shooting on April 28, 2015.
I plead guilty. Excuse me, Judge. At this time, can we get the instruction, please? That's the first question directly from the state.
Yes. Ms. Levis? Yes. Okay. All right. Ladies and gentlemen, you are about to hear evidence that a co-defendant in this case has pled guilty to some of the charges in this indictment. I caution you that this co-defendant's guilty plea conviction itself is only admitted for a limited purpose. That guilty plea is an admission by this witness only that he committed the criminal acts to which he pled. You are not to consider the co-defendant witness's guilty plea as evidence that any other defendant is guilty of committing any of the criminal acts alleged against them in this indictment. Each defendant is entitled to have the issue of his guilt determined solely on the basis of the evidence against him and not on whether another person has been convicted of the same charges with which the defendant is accused.
If you find that the co-defendant witness provided testimony on the stand that is inconsistent with his guilty plea admissions, you may consider the witness's prior inconsistent statement, that is his guilty plea admissions, including to the allegations in the charges to which he pled guilty, as substantive evidence, which you may consider against any defendant currently on trial for whatever bearing it may have on the issues on trial.
I think the state should have been prepared.
Thank you, Your Honor.
To do this instruction. Bruce stepped
So,
in.
Mr. Sledge, you mentioned pleading guilty to charges related to the April the 28th, 2015 shootings that you were just talking to the jury about. Do you recall that?
Yes.
All right. And when you pled guilty, did you...
Pause here. Great detail here. Aaron's looping us in. So it might be, we've had a lot of questions in this chat stream today about incompetence or on purpose and just pretending you didn't know better. So that way you can't get called out for it. But while we're hearing her, but she's about to introduce this Alfred plea, which means you maintain your innocence, even though you're acknowledging that if we were to take this to trial, you could have evidence to prove these charges against me beyond a reasonable doubt. And this instruction we just heard is specifically in relation to a non-Alfred guilty plea, right? Because that would actually be an admission of guilt. And the whole point of that instruction is don't use one person's admission of guilt as evidence that someone else alleged to have done the same or similar charges with them as necessary evidence of guilt, unless it's also proven separately. You have to weigh the evidence still. But this extra detail here that Jim recently let people know, that when this happened, Love should have definitely known about this Alfred plea because she was also the prosecutor on that case the Alfred plea came from for the shootings, the Adele Drive shootings in April. So there's no way she didn't know that the outcome in that case was an Alfred plea.
Did you do so in 2022 or did you do so in 2015 or 2017?
Obviously, I pleaded guilty 2017.
Thank you for that. So, at the time that you pled guilty in 2017 to the charges related to the April 28th, 2015 shooting after Demikion Garlington was jumped, was there a factual basis given for that plea? Do you understand the question?
No, what you mean?
Okay.
I don't.
First, let me ask you, when you pled guilty in 2017, did you have an attorney?
Yes.
And is the attorney that you had then the same one that you have now?
Right.
And did you trust him then the way that you trust him now?
Right.
And at the time you pled guilty, did the prosecutor tell the court that the evidence would show that on April 28, 2015, Mr. Garlington and Mr. Sledge were at a club called Club Crucial on Donnelly Hollowell Parkway earlier in the evening when members of, and preface this by saying Mr. Garlington, Mr. Sledge, and Mr. Zachary at this time were members of a gang called YSL or Young Slime Life that at some point had been affiliated with the Blood Criminal Street Gang. There had been a falling out carrying from the fall of 2014 into 2015. This, for lack of a better term, gang war was going on at this time. Mr. Garlington was jumped at the club by members of a rival gang, Aaron Mills, Dominic Carter, and others that are members of a gang which is a subset of If Gang or Inglewood Family Bloods, which is a gang that the dispute was going on with at that time, when Mr. Garlington was jumped and assaulted at the club. A decision was made by Mr. Sledge. They called Mr. Zachary, the co-defendant, to retaliate in some way. The evidence will show that Mr. Sledge drove the vehicle. Mr. Garlington and Mr. Zachary were inside with weapons, and they first drove by Adele Avenue, 1428 Adele Avenue in Atlanta, Georgia. And that location at the time is the home of Darren Mills and his mother, and at least one of his sisters and one of his cousins, and is an address that Darren Mills actually used and stayed at. He was one of the individuals that had assaulted Mr. Garlington earlier at the club. Mr. Sledge drove by and they shot at the house. There were not individuals outside of the house, but the house was shot. During the shooting of that house, Ms. Denise Bell, who is the aunt of Darren Mills, while she was in her bed, sustained a gunshot to her buttocks and had to go to the hospital and had to have surgery. She was shot. The house was shot up, and there were other individuals there at the time, including Cecilia Davis and Diamond Mills. Diamond Mills being Darren Mills' sister. Also, the car belonged to Cecilia Davis, which was in front of the house and received damage. The evidence is that Mr. Sledge was the driver of the car. After that, Mr. Sledge drove over to 1903 Drew Drive, Northwest, an apartment there was at the time being used by Philip Collins, who is Darren Mills' brother, and also present at the club and participated in the assault. In shooting at what they believed to be Philip Collins' apartment, they damaged apartments 1122 and 1120. Natasha Battle's apartment, which was 1120, her patio doors, windows, and couch were damaged from the gunfire. Ms. Troutman's apartment was 1122, and that was the other apartment that was damaged. Through investigations, detectives got a lead that Mr. Garlington and Mr. Zachary were involved, and they conducted interviews.
Yes, sir.
I can pause there.
Okay.
What's so interesting about this is she's so gentle and like grandmotherly right now. Almost as if, you know, when you've been walking on eggshells and you know you're tiptoeing the line, you get very polite because you know someone could claw at you if they wanted to.
Was that factual basis? Were those words read to the court by the prosecutor at the time you entered a guilty plea in 2017?
I don't remember, was it read by the prosecutor because I took a blind plea. And I think the judge read off the evidence. I don't recall what it was though.
Okay. Do you recall hearing those words read by somebody in court as the reason or the factual basis for the charges that were being brought?
If I could explain, I pleaded guilty because I felt like it was in my best interest. You had two co-defendants. Some of what they said was true and some they said wasn't true. But I did plead guilty because I felt like it was in my best interest.
Were you given an opportunity to say anything at the time that you entered that plea? Were you given an opportunity to make any statements?
No, not that I remember.
Do you recall the judge, after those statements were read, asking you, is there anything you'd like to say before sentencing? Do you recall that happening?
Yes, I recall him asking me that.
Do you recall telling the judge, no, sir?
I remember telling him, thank him for the plea that he allowed. I remember that. I remember me telling him, thank him for the plea that he accepted on the non-negotiable plea, the blind plea or whatever it was.
Would you explain to the jury what your understanding of a blind plea is?
Yeah, please explain.
A blind plea that I understood that you leave the evidence up to the judge and the judge determine on the sentence.
At any time, did you tell the judge, I'm not admitting this,
This is crazy.
I'm just doing this because it's in my best interest?
That's literally what an Alfred plea is, and she's asking him here, while this jury doesn't know the difference at this point in time.
Well, I didn't tell
Problem.
the judge that. I told my attorney that. When my attorney asked me, like, when he came to me with the plea deal, and I told him, I said, why I take the plea? Because it's best in my interest. You got two guys against one.
Hold on. At the time that you.
No, I didn't tell it to the judge.
That wasn't the question.
Oh.
At the time that you pled guilty, did you know what sentence the judge was going to give to you?
No.
Okay.
Not like no, I just knew it was
Did the judge, was it explained to you that you could receive up to the maximum sentence on each charge?
not a.
Interesting. It's like she's projecting her own strategic leverage right there.
If I understand, I think a deal was already worked out, if I ain't mistaken. That what made me take it. I think it was already worked out between my attorney and the state.
Do you understand the difference between a negotiated plea and a blind plea?
No.
Okay. Have you done anything besides a blind plea in front of a judge before?
The 2022 plea.
Yes, I think I have, yes.
And when you pled guilty on December 28th, 2022, was that a blind plea or something else?
I think it was just a plea. It wasn't a blind plea though, if I'm not mistaken.
So everything she's holding in her hand that she just read onto the record as a factual assertion that he supposedly admitted to as part of a plea was part of a plea where he wasn't actually conceding guilt. The 2017 plea, everything about, Demikian Garlington gets jumped and beat up at Club Crucial on a Monday, Sunday, Saturday night. And he gets jumped. We don't really know who's doing it. Someone's house ends up getting shot up, possibly as retribution. And the facts alleged for that incident for which he took this blind we can skip plea, me. alleged, are not something that he signed off on and initialed as acknowledgments and assertions that she should be reading into the record right now. But this 2017 drive-by shooting.
What do you, for a regular plea, what do you understand to be the terms? In other words, do you know your sentence before you plead guilty with a regular plea?
I don't know, because before the blind plea, I knew my plea.
Why did you then distinguish for the jury that it was a blind plea?
It was, but I already knew the sentence. My lawyer had already aware to me that they was offering the same thing. They was offering the co-defendants what they had pleaded guilty before me.
Okay.
So when I pleaded guilty, my lawyer aware me that they was offering the same plea deal that they gave them. But in my plea deal, I told my attorney that, I didn't want the probation. I just take the straight prison sentence.
Okay.
Yes, sir.
Here we go.
All right, outside the presence of the jury.
I was waiting for it.
Yes? Okay.
So
Okay,
fourth
you go
time.
through the jury room.
Fourth time they have to pause proceedings with this witness so far, because Love just read something into the record as fact that was not signed and sworn on. At this point, she was reading the 2017 and Alfred plea.
This is really, so I am shocked. Thanks for the super chat.
This is what's so mind-blowing. How is she a chief deputy district attorney and she just did this? Like, this is what the defense means when they say that they're trying to goad us into asking for a mistrial. And it's like, you keep asking him, what's the distinction? Blind plea versus this. Like, didn't it dawn on you?
Yes.
Oh, the squeak. That's 15 for the squeak. I have to update the counter.
To do what? Sure.
Or is
He
it
wants to go
13?
grab
We
the
didn't
paper.
count 14. So hold on. Did she just ask to go grab? I have to update the counter.
To do what? Sure.
Or is it 13? Because we didn't count 14. So it's going to be 14. Trying to do a little
Yes, sir.
shuffle-roo.
Your Honor, I have a motion for a mistrial. The evidence has just come out that two co-defendants who, to my knowledge, at least one of them is not testifying and has entered a guilty plea. That is a Confrontation Clause violation to Mr. Williams and the other people on trial. In addition, Your Honor, gave an instruction with the last line, and I know it was objected to previously, but I want to stress this, that if it's a prior inconsistent statement, it can be used against Mr. Williams and the other people. That was premature, because I don't believe there's anything inconsistent as of now. And then the third reason I'm moving for a mistrial in the aggregate, Your Honor, is that the prosecutor uses and reads the statement of the then prosecutor, I believe it was the Honorable Mr. Bailey, who entered this plea and gave a factual basis. But she did not make it clear that the Honorable Derek Wright said on page 12 of this transcript to the same court that Mr. Sledge is tendering the plea under Alfred, which is ALFORD.
Yeah, I'm seeing the same thing. And honestly, I thought that we were going to be dealing with the guilty plea that he took in this
B-22.
case. And
Well,
yeah,
sorry,
it's
look,
probably
he just
took in
said,
this
so did
case,
I.
And yeah.
If you can't hear that, Steele just said, so did I. I thought we were going to be talking about the December 2022 plea deal. As Whitaker just said, the one in this case. Steele, why am I holding up my own notebook as if that's the plea deal? Steele was quiet. If you guys are, there's no closed captions on this. He just said, so did I. And look at his face. I believe it. I do think that they're going to call this mistrial. But I think that they might have been figuring it out as it was happening, talking about this 2015 shooting, and didn't realize that this wasn't actually text in that 2022 plea. Optimistic.
Yeah, that's problematic that this 2015 case is an Alfred plea. And so I don't think that any of what I said with regard to admissions is actually true, even against this. I mean, he's saying he pled under Alfred, and I don't know why the disposition sheet doesn't say that, but it is very clear that this is an Alfred plea in this 2015 case. So Mr. Wright wants to share something. Yeah.
And let's be clear here, right? The issue, I just expressed it a few minutes ago. You guys are echoing it in the chat. Love was asking these questions, saying, oh, can you distinguish between why this plea in 2017 was different, or for a 2015 incident, the plea you took in 2017, why that's different than the plea you took in 2022. She kept asking that question. So right here, when Whitaker's saying it's obvious reading it that this is an Alfred plea, even if it's not spelled in bold text, the word Alfred written all over, watermarked all over the page, you should have known it. And here Love was reading. Let me add to past Cat there, because I still feel the same shock and disgust now as that cat did in the moment. But on the actual disposition sheet, it is going to say Alfred. It's going to say, like, I think in Georgia it's written as like guilty plea - Alfred. is the way that it's written out. And it'll repeat that for each of the charges that the plea relates to. So it does say the word Alfred in print. Putting it onto the record. And hopefully maybe she looked at this while planning her strategy of questioning today. And it still never dawned on her, even after arguing all morning about limiting instructions for the 2022 plea, which is not an Alfred plea. But you see how contentious that plea was. You read in this 2017 plea and you're reading it and you're asking the question that points to, oh, maybe I shouldn't be reading this into the record as factual assertions, factual acknowledgments. And you just keep going with it, you don't realize. That's what's so stunning about it. Like, how could that not be willful? It can't just be incompetence. Chief Deputy District Attorney, that has to be willful. It only gets worse because we know now that Love was the prosecuting attorney for that case of the Alfred plea.
Yes.
Waiting for the appropriate time that I was going to point out that it was in fact an Alfred plea. So I thought her cross-examination was not appropriate.
Well, y'all, I mean, maybe that, yeah.
It was something other than an Alfred. So
Well, maybe don't wait so long next time. But, I mean, I'm definitely going to, Ms. Love, do you want to be heard?
Yes, please.
All right, go ahead.
One, we
Sounded like she said misled there and not Miss Love.
Ms. Love, do you want to be heard?
Even the caption said misled. Look at that chat.
I mean, I'm definitely going to, Ms. Love, do you want to be heard?
Yes, please.
All right, go ahead.
One, we'd ask that the court deny the motion for mistrial. Number two, we would ask, as it relates to the assertion that no inconsistent statement was made in the factual acknowledgments.
Okay, no, see,
Not
that's the deal
acknowledgement.
with an Alfred plea, is you are not acknowledging that the facts are true like you would in a regular guilty plea. You're saying, I think that the state has enough evidence that a jury could be convinced beyond a reasonable doubt that these facts are true. But you're not acknowledging on your own, yes, these are true.
Your Honor, when I spoke of the factual acknowledgments, I meant 444Y.
Well, that's what I thought you meant.
Within 444Y, we referenced this particular
All right, let's
section.
Maybe if you can point me specifically, let me pull that one up.
Page.
Which number? Go ahead.
Number 3 on page 3 of 7, under defendants factual, I'm sorry, not number 3, number 4, on defendants factual acknowledgments on or about April 28, 2015, as reflected in Fulton County Indictment 15 SC 138994, defendant and fellow YSL associates Demekion
YSL.
Garlington and Quindarius Zachary committed a drive-by shooting using the firearm defendant wielded in the video referenced in part 3 of this section, targeting family members of a rival gang. Number 5, defendant and his fellow YSL associates committed the drive-by shooting referenced in sections 3 and 4 above on behalf of YSL and to increase the notoriety, reputation, and fear of YSL.
Okay, and so those factual assertions, what I read as the limiting instruction would be true for. But the
2022.
factual basis that you just read out from the 2015 one, that's a whole lot more than what's in numbers 4 and 5.
Your Honor.
She did not mention any of this morning through more than 30 minutes of the recess and research and arguments. I'm honestly so annoyed that this is not, you ever see those judges that keep it cool and then they snap? This is a moment for one of those judges where there should be a snap. Like, Hilton's face. We argued about this morning, and then you did this. And you guys are right about Hilton's body language. Like, Hilton knows this is not what we should have been doing. Maybe she knew and should have stopped. Maybe she just looks this way because Love got called out for it. I don't know. But something about her body language makes it seem like, Love, you just did this. And the judge has a very calm tone here. And I would not as a judge.
In number 6, defendant admitted committing and was convicted of aggravated assault and participation in criminal street gang activity, among other charges, for his participation in the drive-by shooting referenced in section 3, 4, and 5 above.
Okay.
And so if I'll, of course, comply with whatever appropriate instruction that the court deems necessary to give as it relates to the conviction of this witness for 15 SC 1
Is this an on the knees moment?
38994, but given the factual acknowledgments that were made as it relates to 22 SC 183.572, and the fact that this witness did not assert, even though the plea was given in his best interest, he was allowed an opportunity to say what he said here, and he did not say it.
No. When a defendant has an attorney who is saying, we are pleading this because we believe it to be in his best interest, the defendant does not then independently need to say, yeah, by the way, judge, here's what Alfred means.
Understood.
So no. Are you going to?
So we also don't know what agency means, representation means. Love just has her own dictionary.
Tender for admission any part of 444Y?
Yes, the state intended to tender 444Y.
In its entirety?
Yes, I
Okay.
did.
In objection to that being tendered or admitted in its entirety?
And if there is an objection to it, then
All right,
we would just.
let's find that out.
Okay.
Oh, what? Hold on. I didn't know it's not my effing case. And then is that Westmoreland saying something do you? Hold on, guys. Decipher this. And if you're going to type it in the chat, censor the F word. Use FFS. We're going to do my 90s buffering thing, my 90s kid buffering. What are they saying there? This is not my effing case. No, that sounds like Bruce Harvey.
To that being tendered or admitted in its entirety?
And if there is an objection to it, then
All right,
we would just.
let's find that out.
Okay.
I know they leaned in. That sounds like Bruce Harvey's voice to me, you guys. I know they happen to be leaning in, but it doesn't look. I wonder, that's clearly Bruce Harvey. I don't know, maybe in the chat there were other suggestions and I was trying to make sure I wasn't confusing voices. Look at Hilton's face in the freeze frame. Oh my gosh, Hilton. Like Hilton's mouth is moving when the woman speaks. It sounds like Harvey in Westmoreland. So I know it looks like they're leaning in and getting hot mic'd, but I think it's Harvey and Westmoreland. Yeah, I think someone in the chat might have thought it was Atkins. Yeah, I didn't know that's not my effing case.
I just don't, yes, I objected at this point to the entirety of the document unless the state can give reasons for which parts of the document are admissible at this time. And if they're not tendering yet, I understand that. But I can't get around how we got here. I'm
Read
trying
into
to
the
follow
record.
this factual basis and I realize I asked Ms. Renard, Renard, for this, and we're in a different case.
Yeah, we are.
You just said, yeah, we are. Oof.
So, I mean, we've been talking about these 2015 crimes, and we've been talking about, you know, what's been going on in this 22 indictment. So, I mean, I guess that's how it came about. But I wish we'd been a little more specific about it all beforehand, because I mean, I noticed this morning that this was an Alfred plea. And I would have had issues with when you started reading out the factual basis. I'm thinking, well, is this some other case that I don't know about that's not the 2015 case and not the 22 case? Because we should have been reading the factual basis from the 2015 case.
Your Honor, the 2015 case, I understand what the court is saying. The 2015 case is one of the overt acts that we allege in the indictment. And as it relates to the defendant's conviction for the 2015
Whitaker
case,
knows all of
we
this.
believe that it would be appropriate is an appropriate matter for cross-examination, and it appropriately falls under the portion of the court's instruction where it tells the jury that the conviction itself is not to be considered as evidence. And to the extent that Mr. Sledge is asserting that he didn't do it, that he dropped someone off, that is what he asserted, by the way. He said that he was not present. He dropped him off, and it was only one house.
Well, we all know how party to a crime works. So, I mean, yeah, he said, I didn't shoot, but he did admit to being the driver.
And so, to the extent that he said that the statement contained in his factual acknowledgement that he and fellow YSL associates, and I'd also point out that early on he made a very blatant inconsistent statement that YSL is not a gang. And in this factual acknowledgement section,
All right, we're not going to use anything in the factual acknowledgement section of the 2015 plea.
No, in the 22 SC 183.
Okay, yeah, no, I mean, all
We're
of
changing
that
subjects.
is inconsistent with any of his trial testimony is fair game for you to tender for admission and for them to consider as substantive evidence against everybody. The issue we have that needs to get cleared up is that before I read this limiting instruction, I thought you were going to tender the guilty plea to this 22 SC case. And it turns out that you were talking about the 2015 case, which I understand you're saying we did part of that as, part of the 22 factual acknowledgements. So those factual acknowledgements in there are fine as well. When I say in there, I mean in this 22 case. But I'm going to have to clarify for the jury that what I told them about prior inconsistent statements
does not apply.
And that everything you just read from that guilty plea also needs to be disregarded.
So, Your Honor, as it relates to the court's instruction to the jury regarding the inconsistent statement not applying, we would only ask that the court specify that the court is speaking as to the factual basis that I asked the witness about in 15 SC 138994, particularly where he has testified and he pled in his best interest.
Oh, chat. So yesterday, sorry to stop in the middle of what we're doing. But guys, yesterday when we looked at the wrongful conviction cases, we talked about the story of Brian Bowles and Charles Collins. And Mr. Collins just said, thanks so much for covering my story and the heartfelt support from your viewers with the hearts. Oh, chat. Oh, that's so amazing. So he just had his conviction overturned and he is now exonerated. So he's watching and he says, thank you, you guys. So I just saw that notification come in now. That's super, super awesome. See, this stuff matters. This stuff matters. Okay.
Okay. And you haven't tendered yet the 444Y. And so at the point in time when you tender that, then I'll say, okay, for this one, this
Okay.
is true.
I see what, yes,
Okay.
yes.
All right.
Now
If
it's
anybody
going
wants
to like
to
acknowledge.
suggest specific language, I'm willing to listen. Otherwise, I'm just going to kind of
And
give it my best shot.
I would
and
like,
Your Honor, may I say one more thing?
Shut
Yeah.
up.
Because number one, the court has previously instructed the jury that questions, and I understand the content of the question needs to be addressed. But given that the witness has testified that he pled guilty in his best interest, and given that he can also be cross-examined as to whether or not he was asserting these things, we don't believe that anything beyond a instruction regarding the factual basis for 15 SC 138994 not being considered a statement of the witness is required.
Okay.
I just respectfully don't think that goes far enough. You have a prosecutor who's saying it's just a blind plea. She leaves out everything about Alfred. She elicits, and I'm not saying that she could have anticipated this, but her questioning elicits that a non-testifying severed co-indictee pled guilty also. That is a total Confrontation Clause violation. It's the second time.
All right. And that's Zachary and.
Well, Mr. Zachary, I anticipate may testify.
Minky and
I don't know.
Garlington.
He hasn't yet, but it definitely includes Mr. Garlington, who the state has said will not be testifying. And then, just for you to know, you were not here, but the predecessor judge permitted, over objection, the state to do the same thing. They did it with a Mr. Winfrey, just like the court reporter's last name. He's not going to testify. No one believes he's going to testify. The state doesn't say he's going to testify. And they got out that he pled guilty. So they're aware of all this. And in fact, the state elicited in that case that the gentleman, Mr. Winfrey, pled guilty to avoid plea. It was vacated by the Supreme Court of Georgia.
Yeah, I remember you.
So, and
Didn't
then
he enter another one after the fact, though, anyway?
5 years later, Alfred plea and said I'm
Okay.
specifically innocent.
Yep.
I mean, it was a farce.
Right.
And then the predecessor judge wouldn't even let me examine the witness. And Miss Love said that the witness, I could call in my case in chief on direct. So the reason I'm bringing that up is this is not new.
Okay. What's your intention with regard to Mr. Garlington? Do you have any intention of calling him?
Your Honor, no. And Mr. Steele is absolutely correct in terms of the witness testifying about Mr. Garlington and Mr. Zachary and his doing that. There's nothing that indicates that the only reason he did that was because they pled guilty. So that is not, in other words, his statements that he gave to the jury about Mr. Garlington pleading guilty and all of that are not something that I asked him about or expected him to be talking about.
Right. Okay. But
Okay, no, Whitaker, that's not true because she was asking him to distinguish. So he said part of the reason he wanted to plea the way he did for that 2017 plea about 2015 was because he knew he had two other co-defendants. So his answer to distinguish what was going on and why he pled that way necessarily would include a mention of the other two co-defendants. So no, that's not right, Whitaker.
But nonetheless, we have that now before the jury.
We would
So-
ask that the court tell the jury to strike, disregard, put out of their mind anything about the Mr. Garlington pleading guilty.
I'm just to say anyone other than the witness on the stand.
Okay. But Mr. Zachary is a witness.
I know that, but he hadn't been called yet, has he?
No.
So
no.
deal with it when he gets called.
Yes.
Yes, sir.
Your Honor, on behalf of Mr. Sledge, clearly at a jury trial, we are always assessing the credibility of witnesses. My client has now been impugned, or at least attempted to be impugned by the state by suggesting that either he should have been making a statement or his plea was something other, or that these facts are in fact his adopted, admitted facts.
I'm going to make it clear that that's not the case.
And that's where I want to make absolutely clear that he was right in the position he was taking, that it was in his best interest.
All right. Anything else before we get the jury back in?
He's like, please let us get them back in.
That is a great idea. Let's all do that. Or take that opportunity.
Did Love just giggle about the bathroom break?
Okay, that is denied.
Then, because you're giving curative instructions, instead of making the same motion you would before the next question, can you just acknowledge that I would have done that and then still do the motion for mistrust?
Yes. All right, let's take 5 or 10 minutes ourselves.
Oh. Where did this quick recess screen come from? Did I put that in here? I don't remember. Oh, we're gonna come back and it's Bruce saying something. Oh, this is gonna be great. I think, oh, you know what? I must have uploaded this after the fact to condense it down. It wasn't just a clip. Going back to the story of Charles Collins, what really, and I'm just wondering, yesterday when we talked about his exoneration story, that's how we started going down the rabbit hole of the cases that Jim is looking at and started talking about Love. And then we started watching clips of Love. I wonder if he started watching that stuff too and got to see the Fulton County nightmare. But Aaron, I think you put it really well. Aaron says, I truly cannot express how meaningful public support is to wrongfully convicted folks, their families, and their team. Guys, Aaron works in the post-conviction space. She worked as part of Marcellus Williams' team and is working with the team for his estate that is still seeking relief after his execution. So who better than Aaron to know firsthand the impact it can make on the individuals and their family members? She says the process is long, hard, and often disappointing, and the support keeps people going. So it really, really does make a difference. Also, big thank you to Positive Masculinity for the super here. And I always think of potentially criminal. He says the Australian dollary dues, didgeridoo. So I always think of that. He says the plea switcheroo. Miss Love did it this day on Whitaker and did the switcheroo on Mungtunk years ago. And again, there's no way that you can convince me, especially knowing now that she was the prosecuting attorney for the 2015 case, that she didn't know that. And then it makes me sick to my stomach now. In real time watching this trial, we talked about, they use these pleas as leverage. But hearing her at the beginning of this rewind that we're doing with this Alfred plea, say, and were you aware of the maximum sentence you were facing at that point in time? It's just like she's telling on herself, and the way that she and the other prosecutors really played with the sentencing and the specific way we're charging you. Or if we switch up 133 and 131 and want to use the worst possible case scenario, when we want you to think that you're facing super scary, where the sentences have to be consecutive and there's no chance that they could be served concurrently, we'll strategically mislead you on that. because we want you to take this plea. Then on the flip side, we play dumb when we're now in trial and we're talking about these same very things on the stand. We're trying to be vague about it to get certain answers that we want out of the witness without really letting the judge on to know what we're doing. And honestly, Whitaker, I really think a judge could have gotten there. I think it would have been completely within a judge's bounds to have looked at what was going on here and declared a mistrial with prejudice. So the state can cry all they wanted, but I think a judge could have gotten there if they wanted to. So huge thank you to Positive Masculinity for all the commentary today and the support here. And yep, this line right here, the Whitaker, I want to believe this is not intentional, but this keeps happening. And this isn't like, is it X-Files that has the I want to believe? Is that where I want to believe comes from? But the little UFO, right? That's an X-Files thing, right? This isn't X-Files. Whatever it is, this isn't that. This is a court where these types of mistakes put people behind bars. So, oh my goodness. Also, big thank you here, KC Dog in the building. Says, new cat watching, old cats enthusiastic commentary. It's like having twins. Guys, I do hope that if I had a twin, they would also wear a hat and would comment on these trials. Good to see you, KC Dog, joining us live. And Touche, 10 months membership here, says, this is still home. Yeah, it's nice to have a little reunion. I wish we could do like, we could cook and have snacks together, but you know, maybe in the future one day that'll be possible over stream. So let's see. I think I put this quick recess thing in here just to let you guys know there was a break since I chopped it out. So shout out. I don't remember doing that. It's all fancy with the sepia tone.
Judge, I fully adopt on behalf of Mr. Nichols, and I know I don't need to under the rule we're operating under. The motion for mistrial, I understand your ruling. I understand you're going to give an instruction, but I ask that as part of that instruction for an admonishment under 17-875, and I think that admonishment is mandatory, where counsel makes statements of prejudicial matters which are not in evidence. And I believe that this applies to this particular instance under these particular circumstances. So I'd asked the court to admonish counsel. Yes, in front of the jury, obviously, as part of the instruction.
All right, give me a second to get signed into Lexis and take a look exactly at what the statute says. Give me that site again. 1775. I left out a number. Do you have any suggested language? I'm sure you do. That would be appropriate for the court to give at us as an admonishment.
I haven't. We can come up with something.
All right. Well, let's endeavor to do that right now.
FFS, you know DA Love would never utter these words. I never told the truth a day in my life. She would never, ever say, she would never, ever admit in the slightest way to being even misleading about something, let alone say she lied about something or wasn't truthful about something. There's no way. So big thank you here to FFS. I always love, you know, the The God's honest truth always makes me think of FFS now. That is now your phrase. And Factual Lie says, can we do a 403-day rewatch sometime? I wonder if I put, let me see if I have that in my notes, what day it was. If not, I can look through transcripts from certain days and just search for 403 and look for more appearances than usual. That was a good time. That was a good time. Is this going to be a while?
The drive-by shooting
Oh,
on
no. Okay.
and Your Honor,
My bad. Here we go.
go ahead now. Okay. Your Honor, given that 17875
squeak.
refers to statements of prejudicial matters,
Your soft voice
which
now.
are not in evidence, and the factual basis given or read by the prosecutor in the plea in the 15 SC case, while containing details that are not contained within the factual acknowledgments of 22 SC 183-572, it contains, it's about the same act, which in the factual acknowledgments for this case, the defendant says occurred. He admits and acknowledges that he, Demikion Garlington, and Quindarius Zachary committed a drive-by shooting at this residence, and that they committed the drive-by shooting on behalf of YSL and to increase the notoriety, reputation, and fear of YSL, and that he admitted and was convicted of aggravated assault, participation in criminal street gang activity, and among other charges for his participation in the drive-by shooting referenced in sections 3, 4, and 5. And given that this evidence will be properly before the jury, our position is that these statements, the questions that I asked, which contains the factual basis, the assertion about the factual basis in the 15 SC case, would not be a prejudicial matter.
It sounds like he was improperly advised on his 2022 plea agreement. Am I hearing this right? She's making the argument that his 2022 plea agreement included an acknowledgement, an actual acknowledgement, that he pled guilty to that specific act, that 2015 drive-by. Well, if that was actually an Alfred plea, and he signed a plea that said otherwise, that he actually pled guilty to that act as charged, that sounds like there's a problem in the 2022 plea agreement. Maybe I'm not hearing her argument.
Though the factual basis is not in evidence,
I think I was right.
The fact of the shooting is not a prejudicial matter, which mandates a rebuke.
Okay. Well, the fact that a co-defendant who may not ultimately testify and who you do not believe will testify has pled guilty.
I don't disagree that that should go, but that was not something that I.
No, I know. I don't think that you intended to elicit that, but yes, I'm going to give a rebuke. Ms. Love, I mean, that's just what it is sometimes to be the prosecutor in a case. Got to have a tough skin. Suggested language, Mr. Harvey or others?
Need for some smarter colleagues to give me some suggestions, which is everybody in these three tables.
And Your Honor, I'm still reading under the annotations of that particular statute regarding the rebuke.
We also presented this, by the way, as a guilty plea, not as an Alfred plea. and we read a factual basis from something that's not in evidence. It is so highly prejudicial that we all made a motion for mistrial. A rebuke is in order under 17-875, and I think the court in front of the jury can say, and I hereby admonish the state for bringing up these matters that I have just told you to disregard, and the state should not do that again.
Your Honor, what the annotations say is what the law forbids is the introduction into a case by way of argument of facts, not only not in the record, but that are calculated to prejudice the accused. And
all right, Ms. Love, I'm going to give some sort of an admonishment. And I mean, sometimes you need to just, keep your powder dry and not argue every single thing to the nth degree. I've already said I'm giving it. So.
Look at her head shake. Look at her head shake.
Not argue every single thing to the nth degree. I've already said I'm giving it. So.
Like, I don't do that.
I mean, I can grant a mistrial if you'd prefer.
Oh, no.
Okay, then maybe stop arguing at this point.
Yes, Your Honor.
Okay.
Look at her cheekbone.
Now, in terms of her having presented it as a guilty plea, an Alfred plea is still a guilty plea, so I don't find there to be anything wrong with her having references in a guilty plea, but we already talked about the whole factual basis thing, so I won't rehash that, but okay.
One of the clips we watched yesterday was after this moment in time, and everyone had to tell Love to stop arguing once again.
All right, and after I give the instructions, I'm going to ask y'all, I understand that the mistrial motions are preserved, but I am going to ask, since I haven't read out yet what I'm going to say, if y'all have any suggestions that you think would further elucidate, clarify, cure anything, I'm going to ask you for that. And if you have them, I would like for you to let me know that, and we can come up to the bench and consider any other further curative instructions, okay? All right. All right, let's get the jury back out. And I mean, I don't know that we need the witness in here for that, but
will the court prior to
go ahead?
Will the court prior to bringing in the jury
to admonish you?
Would the court be willing to read the
what I'm going to say? Well, I don't know what the rebuke. I mean, it's probably going to be something to the effect of, after I explain to them what they're not to consider, I also admonish and rebuke you, Miss Love, to pay careful attention to how you ask questions and to what you put before the jury. Ms. Harden wants more. What else?
Hold on. Was she quiet? Did she just not respond to something? She just put her head down. I know when I replay it, it's going to give me the buffer. But she actually just sits quiet and puts her head down. She doesn't actually respond to that. I'm shocked. That's a once-in-a-lifetime reaction from Love.
I also admonish and rebuke you, Miss Love, to pay careful attention to how you ask questions and to what you put before the jury. Mr. Harvey wants more. What else? I'll consider it.
You should be banned from asking any more questions ever for the rest of the.
Well, okay, reasonably speaking, though.
That may be going a little bit too far. But that's already been asked for, by the way. And that the court, in giving these instructions,
look at the table back there,
intends to rebuke the state for asking those, for eliciting that improper testimony.
So, Your Honor, it wasn't improper testimony. It
Okay.
was the question.
Improper statements of the state. That's the whole point of a rebuke. That's the whole point.
And we would ask that the court just, if the court is going to read, that the court reads only what the court initially said.
Look at Hilton. Look at them all. Look at everybody in this room right now.
I will say you should not have put that factual rendition before the jury as anything this witness admitted to. I'm listening.
At the time he pled guilty in 2017, because
I understand.
Your Honor.
Give me just a second. Sorry.
Look at Weinstein just looking like that all
Yes.
happened.
Let me request that the court consider including in its admonition the following language, if the court deems it to be appropriate. Somewhere in there, the presentation of that evidence that I've described was improper and was not in keeping with the law and the prosecutor's ethical obligations. Accordingly, the state is admonished for their behavior and is instructed to refrain from asking or presenting any improper questions or evidence moving forward.
All right. I'll do a little bit of it, but not all of it. What was that last sentence?
I like the first sentence.
I'm sure you do. Instructed to refrain from what?
Refrain from asking any improper questions or presenting improper evidence.
All right. Well, they're not presenting evidence, so.
And
All
and should conduct themselves within their ethical obligations
All
and
right.
legality.
Thank you. I'm not going to do that.
All right, got some more.
Got some more? All right. I think this is going to be enough. All right. Let's get the jury out.
In the OG chat, we have Judge Comfort Break.
I mean, do y'all want the witness in here for this?
No, Your Honor.
Okay, let me ask you a question. Have you or somebody instructed, maybe even Mr. Wright, the witness to not talk about anybody else's plea to anything? Can Mr. Wright just do that? All right, let's get the jury out. All right, ladies and gentlemen, I've got some further instructions.
Wait, I think Atkins has the squeaky chair right now, and he was sitting down to try to avoid the squeak. Look at.
All right, let's get the jury out.
He's like planking on the chair to avoid
All right,
the
ladies
squeak.
and gentlemen, I've got some further instructions for you with regard to some of what you just heard. So I gave y'all an instruction that if this witness provided testimony that was inconsistent with a guilty plea admission, that you could accept that guilty plea admission as substantive evidence against any of these defendants. But then what we heard was that this witness pled guilty in 2017 to that being a part of that 2015 drive-by shooting. But and we heard kind of a factual basis that the prosecutor in that guilty plea had read before the court, or somebody had read before the court, as a part of what Ms. Love was asking questions about, and she was, kind of reading it from a transcript. All right, here's the thing, is that guilty plea, as I think you heard this witness say, he entered that because he believed it to be in his best interest to do that. And this gets into a whole lot of kind of legal terminology and legal concepts, but there are a couple of different ways that somebody can say, yes, I'm pleading guilty to a crime. And one of them is called an Alfred plea. It's just named after a case called Alfred. But they're essentially saying, I am going to plead and accept that I'm guilty of this crime, but I am not saying that the facts that the state's putting forward are true. I am just saying I think it's in my best interest to go ahead and resolve it that way. So everything that you heard is, and that is totally legitimate to do that. And let me also say that Mr. Wright, who was representing this witness at the time, he let the court at that time in 2017 know, hey, this is an Alfred plea. He's doing this because it's in his best interest, he believes, to do this. And Mr. Sledge was under no obligation after his attorney said that to, even if he got an opportunity to say anything else, to say, yeah, what my lawyer said, to add anything whatsoever to that. So I think there was a question about that, and he didn't, he didn't say anything else. He had no obligation to, he had no requirement to, he had no responsibility to, okay? So basically what I told you about, oh, you can take those facts and those admissions and consider it against him or anybody else in this trial. When it's an Alfred plea, you cannot. So none of that I said was actually true about what you just heard about those 2017 guilty plea to the 2015 drive-by shooting. Okay. So let me think what else. Oh, and you also need to completely disregard that anybody other than this witness right here, Mr. Sledge, might have pled to anything that had to do with that drive-by shooting. All right. So just entirely erase that from your minds. And I also, at this point, am going to admonish and rebuke you, Miss Love, to pay careful attention to how you ask questions and to what you put before the jury. You should not have put that factual rendition before the jury as anything that this witness admitted to at the time of the 2027 guilty plea. And I'm going to instruct you to refrain from asking improper questions.
Yes, Your Honor. Thank you.
All right. Anything in addition that anybody needs to put before the court right now with regard to the spirit of instruction?
This was absolutely a weird, it's like Paige forgot what she was saying halfway through, but kept talking anyway and just going on and on. But what ends up making that funnier, to me, in my opinion, is I'm tuning out what she was saying in the middle of that. But then when she goes, okay, and now I'm going to rebuke you, I'm hearing that loud and clear because it's a segue out of that hobcobbled mess in the middle. So yeah, she didn't say anything that was easy to follow after the first few sentences, but that made the rebuke sentence stand out that much more. And then I don't know if you guys saw, but as soon as Paige turned her attention to the rebuking, Love's like picking up her laptop. She's making these motions. She's like, jury, look over here. Don't listen. La, la, la. Oh my goodness. And I think, thank you, Casey Doug, for the 2 here. It says, Miss Love, I rebuke how you rebuke me. I think right after this, we are going to watch where she's asking for the counter rebuke against the defense. And also FFS here says, reminds me of the song, Womp Womp Womp, talking to me like I'm dumb, should have known, left that be alone, she's always nagging. I feel like I would love someone to do coverage of this trial in music form. And if we could bring back, because that group was like mystical, and I just think that would be a hilarious group to put to song some of the sound bites from this trial. So just imagine it. Just imagine it.
All right. All right. Go ahead, Miss Love.
Mr. Sledge.
Can't even get it together.
Would you tell the jury just one moment?
Sure.
Okay, so that was the end of that. So we're gonna go over, let's do the counter rebuke day. Did I get over my... Yeah, rebuke them too, guys. We're gonna do rebuke them too.
Looks like it. All right, Ms. Love, you had two different motions.
I do, Your Honor. And one of them relates to
Was that a squeak?
the comments by Mr. Weinstein during his
It's the commentary.
cross-examination of Mr. Wright. Specifically, the comment was maybe about an hour, 19 minutes and 32 seconds from when we stopped. But specifically, the comment that Mr. Weinstein made, to which the state objected, was, you don't know how the state put those words in your client's mouth. And my objection that the court sustained, obviously, is that it was an improper comment, improper statement put before the jury. And even though the court sustained it, Mr. Weinstein and others' ongoing efforts have been to spin a narrative that the state has forced something on one of the witnesses or more of the witnesses. But those particular words, Your Honor, that you put this, you don't know how the state put those words in your client's mouth. It amounts to Mr. Weinstein making a statement, not asking a question, and him making an assertion that the state, in fact, did something that it did not do, which was put those words in your client's mouth. Everybody's heard the testimony and seen what happened. And in as much as that statement was an improper statement in front of the jury, and it could be construed by the jury as something, notwithstanding any court's instruction, that they could take as fact, we would ask that the court under 17-875 admonish and rebuke Mr. Weinstein's statements and admonish him to make no further efforts to put such improper statements before the jury. My second motion deals with Mr.
Let's take them one at a time, all right?
Yes.
All right, we're
There
gonna
was
slow
nothing
it down.
improper about that question to the witness, Your Honor. I was inquiring about the facts. I'm sorry, I'm losing the word, but the facts that were put forward that the state created. The state doesn't deny that they put those together and gave them to Mr. Wright's client without any input from Mr. Wright. I think it was a proper characterization and it was a question. So the witness could answer that, just as Attorney Love has said. All the evidence is out there. It's all before the jury. The jury can draw what they want from that evidence. So there was nothing improper about that.
All right.
And actually, well, that's all I'll say.
So I think it was a mischaracterization. It was in the form of a question, but I believe it was a mischaracterization because if we had been talking about the final version that Mr. Sledge adopted, that might have been a fair statement to say, you know, they were put in his mouth, but these were not things that he ultimately adopted. So the state wasn't putting those words in his mouth. So I think it was a mischaracterization. I don't think it goes so far. I mean, you objected, I sustained it. It doesn't go so far as to warrant an admonishment before the jury. But let's try to be careful in our characterizations, even when we are asking questions. All right?
Yes, Your Honor.
Okay. What's your second motion?
Mr. Adams' question to the same witness that the state objected to, but that the jury heard. Isn't it true, and I'm going to paraphrase, that you knew that the state didn't want your client, the state wanted Mr. Williams?
Mm-hmm.
That's been the lie that they've been, the narrative that has been promoted from the start. We don't agree with it or adopt it, and we certainly don't agree with the idea that we, do these things without a basis for them. So in as much as Mr. Adams made that assertion in front of the jury, we do believe that that merits an admonishment and rebuke under 17-875, and we would ask that the court give him one.
All right. And yeah, that statement was essentially, it followed upon another question that was not as objectionable in this way, but that had been sustained. And Ms. Adams, she pretty much doubled down on it and said something to the effect that the state wasn't interested in getting Sledge, they were interested in getting Williams. And that's
inappropriate to have asked that witness? And I don't know why you thought that there was any basis for that being an appropriate question, because it would call for speculation anyway. So what's your response to the state's request that you be admonished with regard to that?
It was not a question it was a question that I believed was an appropriate question, given the context of both this witness's testimony and his client's testimony previously. What we'd heard in the narrative that has been put forth, and quite frankly, I believe the evidence has been that the state has been mostly interested in Mr. Williams as a defendant as opposed to the co-defendants, particularly as regards this witness and Mr. Sledge. What has come out and what's been of importance is this meeting that they had on June the 9th, where this statement is made that is beneficial to Mr. Williams. The part about him advising Mr. Copeland or Mr. Sledge to take Mr. Copeland to the police. And that's left out of any questioning of Mr. Sledge. He is asked, or he is, however it comes out. There's no discussion about that. We're not going to ask you about that, whatever portion of it you choose to believe. And so there is this narrative that's out there that they appear to be interested in Mr. Williams, not so much in the co-defendants. And the fact that all of the co-defendants who took pleas were asked, made, or signed plea agreements, where the bulk of the plea agreements, and the jury has heard at least 3 of them previously, the bulk of the plea agreements make specific reference to Mr. Williams as the head of YSL. Mr. Williams did this. There is this narrative out there that and everyone has gotten probation. All of the people that the jury has heard from has gotten probation after they were denied bond, and the state took a harsh position that they didn't need to be out on the street. But the minute they entered pleas, they implicated Mr. Williams in some form or fashion in their plea agreements, then they were released. And so that narrative is out there. And I think that was an appropriate question to ask of this witness who has some knowledge of that.
How does this witness have any knowledge of the state's desire?
Ooh, look at this past question from the chat. I forgot about that. So Carnetta Reed had said, so Love can say to Sledge, ask the jury, did you wipe your nose for the jury? And she can get away with it, but now she's putting up motions, and this judge is working with the state to convict these men. Because remember, she did a motion independently here for Weinstein and for Adams.
About who they most want to get with regard to the 19 or so defendants that are indicted in this case.
Because he is a defense attorney representing one of the co-defendants who entered into assisted in entering into a plea agreement. He is familiar with the discovery. He made a statement in part of his testimony previously that he knew what the case was about. And he started going down the road of talking about Mr. Williams before there was an objection made and the objection was sustained. And so he does have knowledge of that. He knows about the case. He knows that Mr. Williams is alleged in this indictment and by the state's narrative to be the head of this YSL organization. And he knows that the plea agreements have been to the benefit of the co-defendants who have pled and to the detriment of Mr. Williams.
And every other defendant still on trial.
Well, but he also knows, I asked him one question about, was he in court when he heard the statement that was made by the prosecutor before the plea, made by the prosecutor, it was Miss Lizzie Rosenwasser at the time, where the statement was made that we're interested in anyone who wants to make a deal except Mr. Williams. We're willing to make a deal. And so he knows this. We're not doing this in the blind. He's aware of this information.
He did ask this question.
I'd like to respond.
What's that? Yeah.
I don't know of that statement that Mr. Adams is speaking about, except Mr. Williams. If he could point me to something, because I wasn't there when she said it. I wasn't even on the case, but I doubt that she would have said it. But if she did, I mean, I can't speak to that. I'd like to see it since he's made that assertion. But the second thing is, as it relates to his assertions regarding the plea agreement, Mr. Sledge, I believe, or either Mr. Wright or Mr. Sledge were cross-examined specifically on whether or not the state asked Mr. Sledge any questions about defendant Williams. And Mr. Sledge said no. And the idea that we're pushing the narrative when the state itself, as the record will reflect, elicited the testimony about Mr. Williams encouraging Mr. Sledge to take Kenneth Copeland to the police station, belies this argument that the evidence that has been brought out by the plea agreements and by the state's actions somehow or another support this, in my mind, baseless assertion by Mr. Adams in the form of, or in the disguise of a question to Mr. Sledge's attorney. There has been, Mr. Sledge's attorney could have been asked whether the state, whether the state asked more questions about one person than another, but actually he was asked and he testified that the question and answer session was more of a kind of get to know you session, and that when Mr. Sledge began talking about Mr. Williams, the state said, the only thing he said about the state is that the state said, that's not the question I asked you. And when he said something about it appeared to be a hot button issue, he later said, there was nothing that you did that made me say that. I just, based on you not asking him about that, I may jump to that conclusion. So putting in front of the witness, one, this assertion about the state's intentions.
Assertion again.
It's the state that's on trial and that the state is doing something
maybe you should
that
be.
is just wrong. Is it your impression that the state don't really want your client? He wants Mr. Williams. It wasn't an effort to solicit an answer. It was an effort to put an assertion in front of the jury that was improper and that can't be taken back. And that has been the entire.
Well, they're going to make that argument.
Yeah.
Regardless, I'm sure they did in opening and I'm sure they're going to in closing, but I don't believe, Mr. Adams, that there was any kind of a good faith basis to ask that question and to think that was a proper question for this witness to be able to answer. But Ms. Love, with regard to what you propose is any kind of curative or admonishment, I mean, I don't know what that would be.
I would ask that the court admonish Mr. Adams in front of the jury that
Just like you
the
admonished
statement he
me.
made regarding the intentions of the state as they relate to Mr. Sledge and Mr. Williams were improper statements by counsel, that in those types of statements, the jury is to remember they are not evidence, but that Mr. Adams should not have made that statement in front of the jury.
Okay. So they weren't statements. It was a question. It was just an improper question. And 17-875 talks about statements of prejudicial matters not in evidence.
And Your Honor, it's not, there's nowhere in evidence. It was a statement that was dressed up like a question, but he made an assertion in the form of a leading question.
But you also said you wouldn't know if it was in evidence because you weren't there.
He wanted mine. And the fact that he dressed it up as a question doesn't take, our position is it doesn't take it out of the realm of improper statements put before the jury that fall under 17-875 that merit admonishment at the very least, even if not rebuke, but that Mr. Adams should be admonished about that statement. It was improper and it should not. Similar statements, even in the form of questions or disguised as questions, should not be made about the state's intention, which one, no one else can testify about. And two, it was just wrong to put before the jury, pretending it was a question to this witness.
Your Honor, if I may respond briefly.
Go ahead.
I have this
She already
witness
doesn't
on
wanna hear it.
cross-examination.
Yes.
And I'm allowed to ask leading questions. I will
defer to the court. If the court felt as though the question was an inappropriate question, there was an objection made, and the court sustained that objection. And I abided by the court's sustaining that objection. This does not fall under the ambit of 17-875. This is not tit for tat, where because Ms. Love was admonished previously, now she's trying to find every opportunity to get somebody else admonished. That's not what this is. Now, I'll abide by the court's ruling, by the court sustaining the objection, but I've stated on the record what my belief was and what my good faith basis was for asking that question in regards to the narrative being put forth in the beginning of this case, and I'll stand by that.
I'm trying to look back at what happened right before that.
And speaking of tit for tat, when we do this 403 objection, remember Love did the same thing with that too. The day that Doug did the 403 objections, as soon as it was time for Doug to do cross-examination, Love started doing 403 objections right back. Don't forget, we had to give a lesson to Love on yesterday's rewatch on 404A or 404B. That was good. Right? It's everybody needs a rebuking. Can't just be me alone by myself on my island, as Haley Wolf said. At least Atkins got up there with her now. Oh my gosh. T for tit for tat. The moment he started losing his hair. Oh my gosh. %90
jury. So even.
Wait, were they still arguing even though they were going to bring out the jury? Or are they just going over the words now? If they're just going over how they figured out the instructions, the court gave him permission to
Your
re-ask.
conversation with the state, your knowledge of the case, your communications back and forth with the state, your evaluation of the plea agreement you formed, or you observed that the state was just as interested in getting this plea done as Mr. Sledge. Wasn't that true? Objection calls for speculation about the state as to whatever his observation is or belief was. It's not pertinent to any material I sustained. And then you followed that up with, was it your observation that the state wasn't really concerned with Mr. Sledge? I think it was with getting Mr. Sledge, but with getting Mr. Williams, which would also have been asking for, what the state wanted or didn't want, which I had just sustained, but asking in an even more pointed way. So it was inappropriate for you to ask that question. With regard, though, to an admonishment, any instruction I give is just going to highlight it again for the jury. So is that really what you want?
Look at Atkins.
Yeah. Why don't I just admonish Mr. Adams privately not to pull anything like that again, or you will get admonished in front of the jury. Would that suffice for now?
Yes, it does. Thank you.
Okay. Are there other issues we need to raise?
I just like
I'll
to
let
say,
Mr. Steele if you want.
Okay.
just for the court, or if you'd reconsider, Mr. Copeland made it
Put it in
clear
evidence,
in
big
his
fish.
testimony that the police wanted Mr. Jeffrey Williams, that all of, he realized.
Yeah, that's a different issue though than the
It's in evidence.
prosecution being just about Mr. Williams, which y'all can certainly argue all you want,
But you just stop them from
it
arguing
doesn't
it.
make that a proper question to have asked this witness.
And just, okay, maybe you resolved it, but you said something I found interesting earlier. I found a lot of things you say interesting, but thrift, THRIFT versus state seem to agree with the court's, what I think the court was saying. It's 310 Georgia, 499. It's in Division 7, like 6-7. It's a 2020 case. And it seems to say that a question asked is not contained in 17-8-75, but it says pretermitting. So I don't think they reached that issue, but they clearly didn't reach it, as a statement. I just wanted to.
Okay, I appreciate that. And I do think that's correct. And so I'm glad to hear that an appellate court also came to the same conclusion. Thank you. Yes, sir, Mr. Short.
Thank you, Your Honor. I know Mr. Adams has not finished his cross yet.
Right.
I also have a short cross-examination. I wanted, and as you know, Mr. Botts was flying solo this morning, and
Shout out to Botts.
I want to be clear. I'm seeking guidance from the court. There's an area of inquiry that I wish to get into, but I don't want to be accused of opening any doors.
Okay.
Mr. Come on, help me out here, right? Mr. Attorney Wright, thank you. Attorney Wright has testified that there was one specific, and I'm going to have to go up there to see the number. There's one specific, no, not three. There's one specific provision that he asked to be removed, and the state did in fact remove it. Okay, and I'm not going to dispute anything like that. I do not plan on getting into the contents of number 8, but I do plan on asking Mr. Wright if, to his knowledge from the review of the discovery, his client made any such statement to the police and any such statement to the district attorney. And the reason I'm asking that is, and then I'm going to conclude it, so this is not a situation where Mr. Sledge said one thing at one point and it was now disowning what he previously said, but rather it's just a situation where he's never said that.
Okay,
and that's it. And I'm not going to get into contents of anything, but I just didn't want to be accused of opening the door to the contents.
I think the contents of number 8 are already in front of the jury anyway, because it's one of the factual assertions that Mr. Sledge disputed. And so those were read out, weren't they?
It's very confusing.
They were.
One prior version, number 8,
is not the same as the ultimate one.
So what I believe Mr. Wright what I believe him to have been saying, and perhaps I will confirm by having him point to it when I'm up there, so it won't be read to the jury. I believe he was referring to the part where he said he heard his client heard someone say, "We caught not." And then that other number 8 was added in its place. So I'm referring to the original number 8.
Okay, I don't know if that was a number 8 or not.
Well, whatever number it was.
Yeah, you'll have to, because I don't know if you even gave a number.
Okay.
But yeah, that's fine. But I mean, I think that y'all know from, and that's a legitimate question, but I think y'all already know from maybe our discussions up at the bench that I believe Ms. Love made an argument that his knowledge was based on their post-Nuts death discussions at the condo. And and I may be misremembering it, but I think that was what Ms. Love at least indicated was her kind of basis for putting that in. So if you ask and no, he never made a statement to police, it's then possible that she gets into that. Although y'all, we are getting, I mean, could we focus on what the issues are in this case, please?
Your Honor, when the court permits, there's one more matter that I think I want to.
Okay, so do you have any issue with if Mr. Short ends up asking, that line of
questioning, you're gonna have an issue with that?
My response has to do with what Mr. Wright's answer has already been. I actually didn't quite understand what he's asking. If it'll open the door, I'm not sure what he meant. So if he could clarify so that I can respond.
Okay.
clearly.
So Mr. Wright is being very clear, and I think the jury gets it, that his client disputed a fact and it was taken out by the state.
Yeah.
Which I appreciate. But I think that, heck, if as an attorney, if I heard that, I would be under the assumption that it ended up in the first place, there in the first place, because he must have said that previously and is now disputing it. I'm not going to get into, oh, the state put this in there without ever hearing it out of your client's mouth. I'm not going to get into the dramatics of that. All I'm just going to try to establish is that, to your knowledge, what you asked to be taken out was something that he never said. Not just that he's denying it now, but he never said it.
Okay. Now I understand. So what my response is actually, I'm going to entail a question as well, similar. But so in states 452, while Mr. Wright was on the stand, I asked him about what we're discussing now, and he brought up himself. I don't know how number 8 got in there,
right?
Something to that effect. And he never said, obviously, I told you to take it out. He said it was an oversight on my part. But I asked him whether it preceded, whether number 460, that email that was sent at 8:43 on December 27, whether it was sent in response to states 452, which was sent at 5:06. He said, well, states 5:06 did not have number 8 in it, right?
Right.
And so that part was fine. But then when he gets to, he said the next thing he sees is states 453, which does have, it has a version of, it has a version of 8 in it. But not that exact language.
Right.
As we went back and forth, and he told us what didn't apply and what did apply, what number 8 ended up being was a distillation of that original statement, that it contained only the part that he wasn't disputing. So it wasn't a matter of, and that's a matter
Now,
of
your
argument.
version is that's what he was saying.
Your version.
I think that could be interpreted more than one way. But what Mr. Short wants to ask is, to your knowledge from your review of the discovery and knowledge of the case, did Mr. Sledge ever say, I personally know that somebody from YSL killed Nutt, right?
No.
No? Okay. No.
I'm getting everyone
Confused.
confusing everyone by
maybe
referring to numbers.
Okay.
I understood Mr. Wright to say, I asked, and this is what the state wanted out. I asked the state to remove something. Okay, forget about the numbers 8 or whatever. What he asked to remove was the statement that someone said,
we got him bad or something.
got Nutt down bad.
All right.
Okay, regardless of what the number is.
Okay.
And I'm not going to ask him what he wanted to get removed. I'm not going to get into the contents. I'm just going to say what you asked to get removed. To your knowledge, your client never said it. And
okay.
In the first place, and when you were representing him, he never told the state that, he never told the state investigators that.
Okay.
Just so it doesn't appear that it's something that he said at one point and is now.
I understand.
So then the question then is not going to be whether or not his client ever said that statement that is now factual acknowledgement number 8.
Right. It's the quote that got taken out from some much earlier version that is, I don't know where it is because there's so many different versions, but we got that somebody said we got Nutt down bad or something to that effect.
Right. And of course, I'm not going to say what it says.
Right. Okay. But that's what you want to ask about. But Okay.
And so, if the court could inquire, if Mr. Sharp, because we have labeled them all so that they're not confusing.
Do you know what exhibit this is going to be on? I mean, I don't know that anybody.
Or just the date and time.
I don't know. Do you have the
I
exhibits
do.
available?
And I gave them
for
to Mr.
review?
Sharp,
All
but if
right,
he'll just
Mr.
tell
Sharp,
me.
can you review and see what exhibit number that is? Because I don't know if it's on more than one. All right, and so if he asks that, he's going to ask, do you know of anywhere from the discovery that might have come from?
Or in his representation, Mr.
Okay.
Sledge ever telling someone from the state that
Okay.
prior.
Which one?
Whatever the quote is.
Yes.
I'm still stuck on her making 2 motions to rebuke 2 different attorneys. I'm gonna dream about that. Guys, I had a dream last night. I was like outside in some neighborhood somewhere walking through like houses, and there was like a pit hole in the ground. And I looked into it in the dream, and my green Diane Fossey hat went into the hole, and then I started falling in the hole, and then I woke up. I lost my hat
Okay.
yesterday in my dream.
I know it's in Sledge
And that is how Twin Cat was born.
agreement updated to sent 1:54 p.m. on Wednesday, December 28th.
All right, that's going to be, I think, 455Y.
That is correct. 455Y. And under number 8 in 4.
Sorry, but that is that is 453Y. 455Y was the one that was sent on December 28th at 1:54 p.m.
That's exactly what I just said.
I'm sorry, I thought you said 1:45. My apologies. Okay.
So it is 455Y.
Right. And I'm not saying it's not in other versions. I just know it's
I
in.
don't know whether it is or not.
I just know it's in that one.
All right. And what number was that, please, sir?
It's number 8.
So it's number 8 in 455Y. Okay,
Correct. But of course, not number 8 in the final version because it's not in the final.
right.
Okay.
Okay, so you understand what he wants to ask is that, and I don't know what you think that might open the door to or not.
I think it might open the door to the fact that Mr. Sledge has testified to the fact that he was at the condo with a number of people, one of which has given a statement that Mr. Kendrick and Mr. Stilwell both indicated that they killed Donovan Thomas using this language. We caught that in down bad. And the fact that Mr. Sledge acknowledged being at that condo during that time, if he starts asking, and he being Mr. Sharp, asks, did your review of the discovery reveal that your client made this statement, then it doesn't have any relevance, given that, one, it doesn't show up in the final version, but two, if his whole purpose is to find out the basis for the state putting it in here first, then I can inquire further about what his client did say and what his review of discovery did reveal, whether or not that statement was alleged to have been made during a time his client was alleged to have been at the condo with the person alleged to have made it. So if that's his only reason, then that's what I would.
This is ridiculous, and she's argued this before. Guys, if somebody says something in this chat today, and you are supposed to say, or someone says that you have personal knowledge of something happening because somebody said it in this chat while you were present in this chat, does that mean you actually saw that chat and have personal knowledge? Being in the same condo as somebody has no, like, I could be watching TV and you could be standing in the kitchen and you could say something to me and I could go, what did you just say? She's made this argument before too, and it's ridiculous.
I would offer up, it's opening a door into. That's just from hearing what I'm hearing so far.
Once again, I'm not getting into the contents, and Your Honor, to answer the question, of course it doesn't open the door, but I was just doing this out of an abundance of caution, and obviously the state is trying to jump through a door
And so
that's
is
not
your
open.
question going to be to Mr. Wright from whatever, however you phrase it, whether Mr. Sledge ever said he personally heard that?
I am going to say, I'm not going to use the words personally heard. I'm not going to use,
All right, what are you going to ask?
I'm going to say, Mr. Wright, on direct examination, you talked about requesting that a part of number 8 on 455Y be removed, and the state removed it.
Right.
And without getting into contents about what it said, is this something based, and I'm going to get into yours as attorney, you get discovery. Is this something based on your review of the discovery that he ever said to the police? And I'm not going to say what it is. I'm just going to say what you asked to be removed. Is it based on anything he ever said to the police? Is it based on anything that he told to the district attorney or any DA investigators? And I was just going to conclude it and say, Mr. Wright, so the thing that you asked to be removed, it's not a situation where Mr. Wright, Mr. Sledge allegedly said something and was now going back on it. It's a situation where Mr. Sledge had never said such a thing. And that's it. And I'm not going to say, oh, the state was doing this and that. I'm going to keep it very simple.
Okay.
That's fine, but we've never alleged that the state, that Mr.
Okay,
Sledge.
I think they just want to establish what he just said as his final sentence, that Mr. Sledge didn't one time say it and then disavow it.
Right.
And given that it's not something that has been put before the jury, what it is, I don't know how it's relevant.
Well, I mean, Mr. Sledge's credibility is obviously at issue.
Right. And the state is putting it before the jury that Mr. Sledge has disavowed what's been put in front of him. And I'm just trying to clear it up in front of the jury that
It
he's
is,
not.
yeah, I understand. It's fine for you to ask that question. Do not ask.
So, sensitive masculinity says, I don't understand what's going on. In all seriousness, hearing this now, this just seems like, even though Love will make a tiny issue, an hour-long issue, every single chance she gets, I feel like with this issue, she's just trying to, she wanted Derek Wright to answer some questions that she thought would help her. And when things started to go sideways, now she's just trying to delay getting him back on the stand. So
ask it in a way that suggests that the state has no factual basis for having ever suggested maybe that's something he could
I'm not going to do
agree to, because then I will let her get into here's why we said this. Okay.
Completely understand.
All right.
I'm gonna try
Everybody
anyway.
Understand that? That's going to apply to anybody that might examine Mr. Wright. Okay.
So,
all right. What else?
So, Your Honor, once okay, I'm not going to follow up. I'll just redirect if necessary. But number 3.
You might not be allowed to redirect
Mr.
on
Wright,
that question.
made a particular statement on cross, I think, as it relates to number 3, or it may have been on direct, but I think it was number 3, and Mr. Adams followed up on it. And the question was, you asked that number 3 be changed, and then number 3, the state refused to change it. Now, given that that assertion has been made and has been affirmed by the witness, we believe that the content of number 3, which I think has already been put before the jury because it was played. I think that the content, just number 3 alone from Mr. Wright's December 27th, 2022, 8:43 p.m. email to the state, the statement that he makes, the video may have seemed like the issue was gang related, but it was actually about a girl that Sledge was dating, and Kel started kicking it with her. That was the real issue behind that, not denying the video, but the real issue was the girl. I think that at this point, the language of what Mr. Wright responds with becomes very important because of the characterization made during cross-examination, which was that Mr. Sledge asserted that number 3 was false. And Mr. Sledge has stated that he feels like it was false. And then Mr. Wright asserted that it was false. But the language that Mr. Wright used to correct that assertion does not, it does not assert that Mr. Watts was not a rival gang member. In other words, it does not dispute any material aspect of it. So the only part that we would be asking to Mr. Wright to tell the jury verbatim is what his response was to number 3 so that the jury can fully understand and appreciate what it is that everybody is saying the state refused to change.
I can make this easy. I'll read that number 3 from Mr. Wright's email out loud to Mr. Wright on cross-examination, and the jury will get to hear it. I'm fine with that.
And on behalf of Mr. Williams, I don't have any objection to that. I asked the question, I believe, and it was specifically because Mr. Wright had on cross-examination said that on that one, number 3, he specifically asked that it be either accepted or changed. And so I don't think that. I think the subject matter of that language is appropriate.
1,000,000%, Trakisha. The fact that they are arguing this is wild because at this present time, Antonio is doing time because the state's credibility is questionable. And this isn't the end of the emails. This is not the end of the emails. It's going to continue to keep going. I believe we get it twice. We get 2 more sets of arguments about these Derek Wright emails. If you wanted, we have Doug Weinstein's. We could go back. It was real quick. His cross of Derek Wright. Now this happened before what we just watched. Doug waiting for Love to get all her documents together. Doug's face.
No, okay. Good morning, Attorney Wright.
Good morning.
And I've never seen her be so careful, going back to what YP Kamshik is saying here. You know, before this, when they were all looking at the many different versions, Love was holding a paper and talking really low, saying she has a version that there are no copies of. Wonder if that's in there. So again, and the issue is in these different versions, language is changing. When was it added and who added it? And was it added at the last minute? And was Sledge aware of what he agreed to or not? And I've never seen her be so diligent in making sure she collects all of her papers.
I believe we met briefly to introduce myself yesterday or the day before, but again, I'm Doug Weinstein and I am Diamante Kendrick's attorney.
Yes, sir.
If I speak to you in a normal speaking voice, can you hear me okay?
Absolutely.
I don't need to yell or shout.
Oh.
We do not.
Okay. We talked about proffer sessions.
That was clearly a dig at Love.
And a proffer session, again, I believe you said, is when a defendant meets with the state, correct?
Correct.
So to avoid legalese, I'm just going to talk about meeting with the state instead of using that word proffer. Okay?
Yes, sir.
All right. So if there would have been a meeting between Mr. Sledge and the state, you would have been there, correct?
Yes.
Was there a meeting between Mr. Sledge and Attorney Love before December 27th?
No, not that I have any recollection of. And I was, I never want to give an incorrect answer. So I was cautious, but I don't believe we ever actually sat down for a proffer.
Was there a meeting between a meeting between Mr. Sledge and Attorney Hilton before December 27th?
No.
Was there a meeting between Mr. Sledge and any member of the district, any attorney in the district attorney's office before the 27th of December?
Not that I'm aware of, no.
What about an investigator with the attorney's office?
No.
I have a slight objection just as to clarification.
Slight
because
objection.
I'd ask that the meeting part based
Look at
on
Doug.
other interactions? Just vague? Was there any
The
meeting?
objection is vague.
Okay, let me clarify. When I've used the word meeting, what I mean is a proffer session. So to all of those questions, if I didn't use the word proffer session, were there proffer sessions?
I'm not aware of any proffer session that was ever conducted or even a more informal interview with anyone from the DA's office or law enforcement as it relates to this case.
So there being no proffer sessions, I believe you received the first proposed plea agreement on December the 27th with a series of factual acknowledgements, correct?
Yes.
So how in the world, to your knowledge, did the state come up?
And I know a lot of people are watching this without looking at the screen, but Love is rearranging this desk with making all the motions, moving her arms, moving papers, just being busy and attracting eyes her way.
With those factual acknowledgements for your client to agree to without having met with your client?
Your Honor, I'm going to object based on relevance and speculation as it pertains to how the state did something or came up with something.
Nick, overruled.
I believe the state was trying to surmise through its overall
Well,
investigation.
now, he asked your personal knowledge, so if you could answer that, please.
I don't have any personal knowledge how the state came up with these factual problems.
So you don't know how the state put those words in your client's mouth?
As to the characterization of
Sustained.
Okay. How many plea negotiations have you conducted in your career?
Definitely over 1,000, maybe 1 to 2 or 1 to 3,000 over 30 years.
Okay. And these plea negotiations are like any other negotiation that takes place between parties, correct?
Absolutely.
There are things that you want in the final agreement, right?
Yes.
They're the things the state wants in the final agreement, correct?
Yes.
Do you get everything you want in that final agreement?
No.
And is this plea any different than the other pleas where you don't get everything you want?
No, it's not.
I have no further questions.
All right. Does anybody else have
Beautiful.
questions from the defense?
10 out of 10.
And I have a motion as to part of that, but I'll ask it at the time that we break.
Okay.
She's mad. And then we have, now after the arguments that we watched, Chart does his cross. So let's go watch that. His is a little bit longer, but I think more fun because we just, they're going into this knowing that Love just argued her butt off.
Good afternoon, Mr. Wright.
Good afternoon.
Attorney Wright.
Good afternoon.
May I approach to just see what the witness has in front of them?
You may.
This is 1AS, which was that final. These are just my own little notes. This shouldn't be. These are all just my own notes.
Yeah, over here.
Okay.
Just look what is in front of you.
Sure.
So your hand. Thank you, Your Honor. Okay. Attorney Wright. On direct examination, you made reference to identifying a portion of a certain factual acknowledgement that you and your client disagreed with and bringing it to the attention of the state, correct?
Yes.
Well, you mentioned several, but there was one in particular that the state changed for you, correct?
I need you to give me a little more info.
Okay.
Like which one?
And I'm not going to get into the contents of it, but it's in what's been marked 455Y.
Okay. I'm not seeing 55. Let me one more time. 6.
Oh, state's just handing it to me.
Okay.
Approach.
It is.
I believe that's 455Y.
Yes.
Okay.
Yes.
Now, we're throwing a lot of numbers at the jurors.
Okay.
Just so we know what we're talking about, 455Y is not the final plea agreement with the final factual acknowledgements, correct?
No.
Okay. On 455Y, on factual acknowledgement number 8 on that document, not the final document, but number 8 on that document, isn't it true that you identified that factual acknowledgement and said that you had some problems with that factual acknowledgement? And I'm specifically the last part of it.
Yes.
Okay. Now, as the attorney in this case for Mr. Sledge, you received discovery, correct?
Yes.
And you were able to see what your client may have said or did not say to any police officers.
Correct.
Okay. And certainly you were representing your client and are aware of what your client may have said or didn't say to any district attorneys.
Okay.
And you're aware, you would be aware of what your client would have said to any district attorney investigators, correct?
Yes.
Okay. The part of factual acknowledgement number 8 that you asked to be removed, and the state removed it. Okay, you with me?
Yes.
The state removed it. We agree?
Yes.
Okay. That part that you asked to be removed, from your review of the discovery and from representing your client never said such a thing, correct?
I can say that my client never said or adopted that statement, and that was one of the reasons he asked it to be removed.
Okay, and I understand he didn't adopt it, but to your understanding, he never said it.
Correct.
Okay, and that's why I'm just trying to clarify. That portion that you asked to be removed is not something that your client once said and is now disowning or saying he's changed his mind. It's something that was never said.
Objection, asked and answered twice.
That's correct.
Okay, thank you. I just want to talk to you about the timeline of you receiving the plea offer in an actual pleading this case, okay? You received the first version of the factual acknowledgements, you would agree, at approximately 5:00 p.m. on December 27, 2022?
Yes.
Okay, and that was the day before the plea was entered.
Correct.
And as I understand, I'm not going to belabor the point, as I understand, you went to 901 Wright Street, the Fulton County Jail, to discuss the plea offer with your client.
Yes.
Okay, Mr. Sledge. And do you recall how long you met with him that day?
Now that I don't know. It would have been long enough to make sure we're going over things for me to get a good idea of what his response would be to our conversation and the things I was going over with him. And then at some point I would leave. And then, of course, as I said, later prepare a response email to the state.
And this meeting with your client, was this you were in the attorney booth at 901 Wright Street?
Yes.
Okay. And as an attorney, or when you met with Mr. Sledge, you were on one side of the booth, there's a glass.
Objection, relevance is to.
I'm discussing their ability to go over this document. There's a thick glass barrier in between you and Mr. Sledge for this meeting.
Correct.
And he's on the other side of the thick glass, correct?
Correct.
And of course, you have to talk loud, but you can hear each other, correct?
Correct. And let me, at least so you know, because this is some time ago, I'm assuming I was, again, because we are almost always in the attorney booth. We get a little key, we can unlock it, we can go in. We can also hand documents back and forth.
Right.
That is my recollection of how I met with him, which meant I would have been able to hand him a copy so he can read it, I can read it, at the same time and go over whatever we need to go over. I'm sort of stating it because it's so long ago. Is it possible that I just saw him through one of the more window only kind of things where I could not have handed him stuff? Possible. I don't remember that. I remember being in the attorney booth.
Okay.
But I just wanted to point out that, yes, we can talk as well as hand stuff to each other to review.
Well, let's let the jury know what we're talking about here.
Yes.
So if the attorney booth, if someone's in the attorney booth, if it's being used, if it's occupied, you can use a visitation booth, correct?
Correct.
And that also has thick glass in between you and the person you're speaking to, correct?
Yes.
And the
see
main
demeanor.
difference is there's no pass through in those
Correct.
booths.
We can, all audible stuff's the same, but you just can't pass stuff back and forth.
Okay. And of course, when you met with him on the 27th, met with Mr. Sledge on the evening of the 27th, you had whatever version of the plea agreement was in effect at that point, but not the final version.
Correct.
All right. Could you refer to 1AS?
Okay.
For me?
Great questioning by Shart.
I have it, sir.
Okay, thank you.
Demeanor, nonverbal cues, you can't see.
You would agree that in the negotiations with the state, your client pled to count 1, which was conspiracy to commit RICO violation, correct?
Yes.
And he was facing 15 years to serve. He was sentenced, the agreement was 15 years to serve on probation, correct?
Correct.
Okay. And then count 30, he did plead guilty, and according to this agreement, sentencing was withheld.
Yes.
And would be dismissed if he fulfilled the agreement.
Yes.
Okay. At this point, sentencing is still withheld, correct?
Correct.
And the maximum he's facing on count 30 is 15 years, correct?
Yes.
Okay. So right when he testified earlier today, he had a 15-year sentence hanging over his head as well as the probation.
Correct.
Okay. And so his maximum exposure is 15 plus 15, correct?
Yes. I mean, technically less, we'll say any time is already ticked off since the agreement, but generally speaking, it's 15 plus potentially another 15.
So, and at this point, if he's done a year on probation, it would be 29 years instead of 30 years.
Correct.
Okay. Now, you indicated in your review of the final plea agreement, there was one factual acknowledgement that you testified you missed, correct?
Correct.
Number 8 on the final agreement, you missed.
Correct.
And, well, I'm not going to ask you to speak on behalf of your client, but you missed it.
Yes, I can only say that I missed it. And had I seen that, I would have immediately, because it was of a certain subject that from the very beginning, we had sought to exclude from this. But ultimately, for whatever reason, we missed it.
Okay. Can you, in sentencing acknowledgements, number 5 on that final agreement, defendant sentencing acknowledgements?
Yes.
This final plea agreement between Mr. Sledge and the state, as reviewed by yourself and Mr. Sledge, indicates that your client is facing as much as 35 years in confinement. Isn't that correct?
Correct.
That's what the agreement says.
Correct.
Okay. In fact, he's facing 30, maybe 29.
Correct. It would have been a max of 30. So 35 was incorrect.
Okay. So,
Your Honor, I object to the characterization. The language, I object to the characterization, and I don't want to speak further, but the question was posed whether it said he faced 35.
Department of Corrections.
That is what the document indicates.
Okay. Is that your client is facing 35 years?
I think it would be a more correct statement to say 30, but
Interesting. We have some issues over the sentencing. Paging Happily Angry Lawyer.
Point is 30 or 35, a whole lot of time. But yes, I think the correct number is 30.
All right. You're making my point for me.
Gotcha.
You signed an agreement where your client was facing, you and your client signed an agreement saying that your client was facing 35 years.
Correct.
And he was really only facing 30 or less.
Objection asked and answered.
Yes.
Ooh, bad.
Your client on that final agreement, there's a word that's crossed off and initialed by your client, correct?
Yes.
Okay. Begin was changed to being. It's just switching the letters, right?
Yes.
Okay. And that was crossed out and written and initialed by your client, correct?
Correct.
All right. And you've reviewed the video. Hey, you were in here when the video was played of your client taking a plea?
I was there.
Okay. That was something that Miss Love caught and instructed Mr. Sledge to cross out an initial, correct?
That sounds correct, yes.
All right. That wasn't something that was caught by your client.
Correct.
All right. Okay, Mr. Wright, you, in addition to what I first asked you about number 8, the portion of number 8 that you pushed back on the state and they changed, you also pushed back to acknowledgement number 3 on the final plea agreement, correct?
Correct.
And Your Honor, may I go back?
Yeah.
Okay, and number 3, which you pushed back on, regarded the video that your client made with Quindarius Zachary, where he was, we'll say, threatening a gentleman by the name of Kel or Kelvin Watts, correct?
Correct.
Okay, and you're aware that the factual acknowledgement indicates that your client, while associated with YSL and to support and express loyalty to YSL, made this video.
Correct.
And it indicates, the acknowledgement indicates that the video was made on behalf of YSL, correct?
Correct.
Okay.
Your Honor, I'm going to object to characterization.
Sustained. I mean, if you read it carefully and then rephrase.
On behalf of YSL, defendant threatened to harm a person named Kel.
You can ask that.
Okay, but the acknowledgement indicates that on behalf of YSL defendant, that would be your client, Mr. Sledge, threatened to harm a person named Kel, correct? That's what the acknowledgement says.
Yes.
Okay, and you pushed back on that and you sent Ms. Love an email, correct?
Correct. Actually, we began taking issue with that characterization from the very beginning. And this was, I think I testified an example of where we felt one way, the state felt another, and that was one of the examples where it was not changed.
Right. Okay. Do you have the emails? Actually, this might be.
460 is right here.
Do you have 460 in front of you?
Yeah.
No.
462, 461. One moment.
This is the only 460.
Ms. Love gave me this one.
Oh,
I'm going
okay.
to approach if Your Honor will allow. I'm handing you what's been marked as 461.
Yes.
Going to read to you from your email what you said about acknowledgement 3 to Ms. Love. And this email was sent on December 27th at 8:43 p.m., correct?
Yes.
Okay, this is the night before Mr. Sledge entered his plea, correct?
Yes.
Okay. You wrote regarding number 3, the video may have seemed like the issue was gang related, but it was actually about a girl that Sledge was dating and Kel started kicking it with her. That was the real issue behind that. Not denying the video, but the
And remember, they end up changing the language in one of the plea versions. So now it talks about the paramour.
issue was the girl. Is that what you
Yes.
wrote? And is that verbatim?
Yes, that was verbatim.
Okay, so the point you were trying to get across is you're not denying it, that your client, Mr. Sledge, made the video.
Correct.
And you're not denying that he had an issue with Kel,
Correct.
but that issue was about a girl.
Yes.
And you ultimately, the state was unwilling to change that factual acknowledgement in the plea agreement, correct?
Correct.
They were unwilling to take out that it was done on behalf of YSL.
Correct.
And they were unwilling,
Your Honor, my objection is vague when the question is they were unwilling to take out that it was done. And earlier, Mr. Sharp referenced the video. If you could just clarify what he's saying.
Sustained.
okay, they were unwilling to change the factual acknowledgements on your client's plea that he was to sign the next day, right?
Well, again, some changes were made, but as to that specific one, that was one example of where they were not willing to change it, even though we had a difference of opinion as to what it was about.
So the it is still unclear. So
In
if you-
factual acknowledgement number 3, I'm sorry. Yeah.
Okay.
Yes, my objection was to, could they specify what it we're talking about?
And it may help.
Factual acknowledgement number 3, which relates to the video that was made
Yes.
with your client and Mr. Zachary in it, correct?
Yes.
Okay. the state was unwilling to change the language that it was done to support and express loyalty to YSL, correct?
Correct.
And they were unwilling to change the language that it was done on behalf of YSL.
Correct.
And Your Honor,
Yes.
again, I object.
You can clear it back up on redirect, or are we already? Yeah, that was,
I haven't
you
done
still
it.
have redirect, so you can clear it up then.
They were unwilling to change the language where it said, wherein on behalf of YSL, defendant threatened to harm a person named Kel because of that individual's association with a rival gang. They were unwilling to change
All
it,
right, all
right?
right. I think that the state's objection is a valid one, and I don't know if you want to, if you need direction, but why don't y'all approach?
Does that count as an objection because it was raised by Whitaker? Does that count? And are we at 9? Are we at 9 objections? If I've got to get clear because I had stepped away. Yeah, that was really Paige with the objection for real. Shout out to Dear Woke Christian. Now, this is Jason Whitaker who put in the Rule 22. You did a great job making it clear exactly what you were asking for with your Rule 22 motion, Dear Woke Christian. I loved seeing you in there. We were cheering for you in the chat. That was a good time. And on top of it, you came in here and so generously gifted 5 memberships. And you're green, so you're just coming in here with slime and then dropping slime on people's heads. So shout out to DWC in the chat. Super, super awesome. And okay, they're coming back here. And shout out to DWC. And speaking of Rule 22s, I mean, obviously, I think we all want to make sure we can know what's going on if there is a hearing for Mungtunk. Right now, it's got to go through the appeals court for the first motion to vacate before the trial court will hear the new motion. I would totally go up there. I will totally take a trip up to Atlanta for that.
Okay, Attorney Wright, do you remember at this moment, in your email, you did not indicate specific changes that you wish to have made, correct?
I'm going to object.
Actually, in my email, the way I even described I put here are recommended changes, and then I went number by number, all the way 8 through 13 for the agreement I had at the time.
I get it. It's not like you went through it like you do in Microsoft Word and mark it with red or anything like that, like an editor would, correct?
Correct.
Okay, but the point you were conveying in the email was it was not gang related, correct?
Correct.
And it was over a girl.
Correct. As to that issue number 3.
As to number 3. Okay. And ultimately, the final version of Mr. Sledge's plea agreement includes language. You would agree that it includes language that indicates that the video and the making of the video and the threats were gang related.
Correct. That number 3 is an example where there was not a meeting of the minds with the state, and that's where they did not remove the information for, consistent with what we were suggesting be removed.
And the gang related versus a girl was where the meeting of the minds was not happening, correct?
Correct. I mean, ultimately, the state included sort of both things in there where we were saying it was really about the girl.
Right. And you told Mr. Sledge that he could explain this later to a jury.
Objection, Judge. One that answered in province of attorney-client privilege.
Then attorney-client privilege.
Okay. Mr. Wright, from your dealings with Mr. Sledge, you are aware that Mr. Sledge did not completely agree with factual acknowledgement number 3.
Objection asked and answered.
Sustained.
That was asked and answered.
On the date that he pled, he did initial that factual acknowledgement, correct?
Asked and answered.
Your Honor, this is the first time I'm questioning this.
I know, but lots of other people already have, and we've gotten that information at least a couple of times.
That context with the date was new.
I mean, you're welcome to ask whatever it is that we're leading up to.
I believe on cross, you indicated that in negotiations, you can't have everything, and sometimes you have to live with some things, correct?
Correct.
And your client initialing number 3, even though he didn't completely agree with it, is an example of having to live with things, correct?
I think I previously did state that number 3 was an example where there wasn't a complete meeting of the minds, but his choice was to either walk away and proceed with trial or enter into the plea agreement.
To go home, Mr. Sledge would have to live with that. It's part of the negotiations, correct?
Objection, Your Honor, that part is asked and answered.
Sustained.
All right, here's my question. Is it fair that Mr. Stillwell would have to live
Objection,
with your
Honor, asked
client?
and answered.
No.
I'm sorry. That is not what I'm going to add. Objection, relevance, and improper question. Is it fair that Mr. Stillwell will have to do anything is an improper question for this witness. So forgive me for.
Sustained.
Was Mr. Stillwell a party in these negotiations?
Objection, that is, again.
I'll prevent that question.
Was Mr. Stillwell a party in these negotiations? Was your client signing a factual acknowledgement that wasn't true? Is that something that Mr. Stillwell should have to live with?
Objection, one.
Sustained.
The signing of these incorrect factual acknowledgements, you would agree
Bless
that
you
it
to
affects
God.
more people than just
Objection,
Mr.
Your
Sledge,
Honor.
correct?
Overruled.
I will state this. Any person in a case where there are multiple defendants, once they enter into a plea agreement that includes certain factual stipulations, that can impact all the defendants, not just themselves. So to your point that yes, when Mr. Sledge was completing his plea, his focus was on him. However, there are effects or ramifications that could affect others.
And your focus
Your
was,
Honor,
and your
my
focus was
Hang on
on
just a
him.
second. Hang on.
And my objection was to the characterization of the incorrect or improper factual acknowledgement. So the answer, I think, sort of dealt with it, but my objection was that was a mischaracterization or improper characterization.
Was
Well, the jury's heard the testimony, so.
Was factual acknowledgement number 3 completely correct from your client's perspective?
We indicated that we took issue with some of number 3. Some of it we were acknowledging and some of it we took issue.
And he initialed it and he got to go home.
Correct.
Objection. that's
And
been asked
it affects these other gentlemen back here, correct?
Sustained.
No further questions.
And then, and then we have the arguments over the emails. So we get the emails produced and we've got some issues. We're back. Let's get this going.
What we discussed.
And shout out, it's just playing automatically, but I wanted to give a shout out. We have new faces in the building. Well, not new faces, but you guys know what I mean. We've got Flush of the Gods joining us, the king of rewinds and clips. We've got Late Night Baking with Mookie Mookie. Good to see you. And then we also, I think, recently joined, right? We had Keisha E come in here. And where was her? There we go. Yeah, Keisha had called out the testimony about the time to serve being incorrect. So, and Shart kind of having to underscore that and not either of the attorneys that were in charge of knowing that at the time.
That's at the bench regarding State's Exhibit 460. And State 460 is the paper copy
Brown
of
sitting
Mr.
up front.
Sledge's email, Mr.
Mhm.
Wright's emails.
Right.
On page,
Hey, Amber.
on the next to the last, I'm sorry, the last page of State 460. And Mr. Shart is standing next to me, so if he has that, he could pull it up and confirm that I'm getting this part right. There was an
You should
issue.
get it right.
You wanna look at mine?
I don't know. Continue. I was trying to interrupt. I don't have 460 printed out, so I'm just going to watch out.
Okay,
Go ahead.
Okay, so at the bench, there was an issue, number 4, does the court have his copy?
I do.
All right, so there was no problem from counsel for the defense that actually voiced any concern about the first full sentence. The concern voiced by Mr. Adams, I think echoed by Mr. Sharp, was the second full sentence. And then they wanted to keep in the third and the fourth sentence. What I told them was that sentence, that number 4 was made in response to the email, and you can tell that from the time and date that it was sent. That was sent in response to the email that was sent to Mr. Wright, and that was dated
December 27, 2022 at 5:06 p.m., which states 452 Yankee. The email that contains, and it may have been that we did include it twice. So Mr. Wright sent us an email on December 27, 2022 at 8:43 p.m. in response to the email that I sent to him that was subject sledge agreement updated. And in that email, Mr. Wright enumerated 1 through 8 regarding factual acknowledgements. 452 is the email he was responding to that the state has sent. And number 4, yes. And so to the extent that the counsel for the defendants have all indicated during the break that they would like redacted from any prior iteration, anything that was not included on the final states 1AS, the final plea agreement, to the extent that that number 4 on stage 452 Yankee gives context to that number 4 on stage 460, it would be necessary to be included to show that that was something that the state put on there that it believed to be true, that Mr. Sledge said no, and this was his response through his attorney.
Okay, so I'm confused now on the different iterations that lead up to the final agreement. I understand that one of them is this number 4 that the state was proposing that he say
that he was saying
that he, Sledge, had personal knowledge that YSL associates were planning to murder Donovan Thomas Jr. And that is not ultimately what number 4 said. But are you saying that
in response,
are you saying that the defense wants redacted the earlier version of number 4?
Yes. You're
Yes.
Okay. I think we're going way down a rabbit hole here. The state seems to me, we don't need anything redacted if it's not being admitted into evidence.
Well, I think it is going to be admitted or at least tendered for admission into evidence. And the reason that it is at issue is because Mr. Sledge said there were things that I absolutely wanted changed that didn't get changed. And this establishes that there were very material things that would have been beneficial to the state that got changed because Mr. Wright and Mr. Sledge requested that they be changed. So I understand why that is relevant. I mean, if these are going to come in, I would certainly think that we need an instruction that they're not to take any of this as factual because it's not in fact what he ended up agreeing to.
I agree.
Yes.
Well,
Of course you do.
Yeah. Okay.
First of all, I agree that Mr. Sledge said that. I also know that Mr. Wright and actually Mr. Sledge acknowledged that some things were changed, some things were not changed.
Mhm.
No one is claiming that nothing was changed. Okay, that's first. But secondly, I want Your Honor to understand, and I sought clarity from the state because I don't work for the state. I was not communicating with Mr. Sledge back then. These initial factual acknowledgements were in no way based on anything Mr. Sledge ever said to the state. The state came up with these factual acknowledgements from a review of the discovery and proposed these. So
Right.
the genesis of these is purely divorced from anything Mr. Sledge stated, okay? It's not, there's nothing that Mr. Sledge said, okay, this is my story, and then the state came up with these factual acknowledgements, and then Mr. Sledge was like, oh, well, you don't have that quite right. This is what the truth is. These were drafted by the state from looking at the discovery.
Okay.
So I would ask if we're gonna let in basically incorrect information that Mr. Sledge has never agreed to. And
Can't cross it
we're
now.
gonna expose the jury to this. I think we need to be a little stronger with the instructions and say, these were drafted by the state and not based on anything Mr. Sledge said. Because I've been doing this for a while.
Right, I get your point. And y'all, this is why I had us come a half an hour early is because 8:30 to 9 was when we were supposed to be figuring out what was coming in, et cetera. But, so Ms. Love, are you not in agreement with redacting things that didn't ultimately come into
the final agreement?
Correct, for the reasons that the court earlier alluded to, and also.
All right, and you do realize that some of what might come in like this, if the version of number 4 comes in that is a proposal that YSL Associates were planning to murder Donovan Thomas Jr., that there are concerns with putting that type thing before the jury.
Well, I do want to hear the court. I do want to understand fully the concerns that all of them that exist. And ordinarily, I would simply leave it at that. Yes, I know there are concerns, but in as much as Mr. Sharp has indicated that, well, his version of reality, mine differs slightly, and I would not go so far as to characterize.
I'm not going to give an instruction that says this is not based on anything.
Okay. Well, can I just respond to that though? But if you're not going to give an instruction, Judge.
I am going to give an instruction.
I understand.
If this even comes in.
This is the problem.
Good, if it
If
comes
this
in.
I think the jury would want to know, well, where did the starting point come from? And the only way we could bring it to the jury, because I didn't really know until this morning, to be honest, where the starting point was. It's always been a question of mine. How did these even get the first version? Where did it come from? The only way we could really bring that to the jury is to call the drafter of the acknowledgements to the stand, who I assume is Ms. Love, and ask, well, these acknowledgements that you drafted, when did you draft them? Was it based on anything Mr. Sledge said, or was it based on the discovery? Because, and I'm being forthright here as an officer of the court, Your Honor. I've never been a prosecutor, but I was under the assumption that there was something that Mr. Sledge said that led to the first statements, and then it was like an editing process. But the first version was not based on anything Mr. Sledge said.
There's no proper.
And that's important, because the jury has to determine, okay, did the state just come up with these? Did Mr. Sledge say certain things and he's backing out of them now? And if we don't make it clear to them that Mr. Sledge was not the genesis of even the first version, I think that question becomes unanswered. And the only way, other than an instruction, would be to call Ms. Love to the stand.
All right, Ms. Love, what's your response to that?
Your Honor, one, again, the idea that this.
All right, I don't need
I'm
like
not
a
trying to go-
full-blown
My response.
rehash of everything. What is your, let me re-ask. What do you propose?
I propose that the court instruct the jury that is to take as fact no information contained in any iteration of the plea agreement unless that assertion or that factual acknowledgement is in the final version to which Mr. Sledge.
Let me ask you this. Would you be able to get essentially the same information before the jury? And I believe the information you want before the jury is that very material things about the factual acknowledgements were changed at the request of Mr. Sledge and Mr. Wright. Is that essentially the point you want to make?
Blandly, yes. I think that I would rather ask Mr. Sledge, Mr. Wright, did the state ask, because essentially that's what we're doing, because we couldn't sit down with him. Did the state ask your client if he had personal knowledge that the murder of Donovan Thomas was pre-planned by YSL members? Did we ask him that? And did, through you, your client, tell us no? Did he say no? He believed that the shooting was.
He says he did not know.
Right.
He thinks it was not planned, but more impromptu, or at least very short or little planning.
Right. So we don't need all of that.
What's his basis for knowing that? I mean, that's part of their problem.
That it was impromptu with little planning. Well, because he was at the house with. If we're talking state's theory, because Mr. Sledge still has not met with us, but if we're talking what we believe is that everybody was talking about it. They were at the house. We had more than one witness who says at Defendant Williams' condo, they met up. And
after the fact.
Yes, after the fact. And they talked about it. They talked about catching.
Okay, they could have talked about it and it never come out whether it was planned or not.
And based on the conversations, this is what I have gathered, based on the conversations that Mr. Sledge was privy to, his understanding was that it was not pre-planned. And that is the reason when he says what he does, that he says it. So we're not trying to get into what he thinks. We'd be sufficient with, did we ask him that? Did he tell us no? Did we at first have something
Okay,
to
so
that?
I think that's a lot safer way to go about it is, did we ask him that and did he say no?
And did he
leave it at that and not follow up on, here's what he thought. instead.
I
Okay,
completely agree. But
okay,
the
well,
part
that's
that
not
I
what you
think
said
is,
a minute ago. Okay, so
the part that,
go ahead.
the part that I'm concerned about and would like to also put before the jury was, and did we include that question as part of the factual acknowledgments initially? Is that something that he absolutely said no
Okay.
and refused to acknowledge and had insisted that we change?
All right, so it seems like if y'all, the defense wants in portions of number 4, that maybe the sentence at issue could read, he thinks shooting Peanut was not planned, and then redact the remainder of it. Because that shows that he is saying, no, what the state is asserting is not true to my knowledge or belief.
And if the court lets me leave Mr. Wright, I can say, did he tell us? No. Did we
Okay.
ask him, did he have personal knowledge as pre-planned? Did he tell us?
Okay,
No.
but if we're talking about how to redact 460Y if you tender it, then that would be, I think, a much safer redaction.
So taking out everything except he thinks the shooting was not planned.
No,
or
taking out, leaving in everything except, but more impromptu or at least very short or little planning. Mr. Sharp.
Well, I just have concerns with the state. Here's the state can have their theories. Mr. Sledge on the stand has said no one talked about the murder. Okay, they talked about Mr. Thomas. Yeah, they talked about Mr. Thomas had passed, but no one was saying this is what happened. There was a discussion. So when you ask someone, if Mr. Steele asked me, hey, was that murder pre-planned? And I say no, then it insinuates, it gives the impression that I know about the murder. I have some information about the murder.
Yeah.
And that's my problem, is just saying that in a vacuum.
Okay, so how about, the beginning of what he says is really the answer. He said he did not know, and the rest of it is elaboration.
And Judge, the portion that was, let's see. Okay, so based on what Mr. Wright wrote back to me, we included a line that was not initially included in the previous iteration that I think is 452Y.
Okay.
And I think that line is number 8. And we drew the same exact conclusion number 8 of 1AS, number 8 of the document that did get admitted, which is that defendant personally knows that one or more YSL associates committed the murder on behalf of YSL. So based on the response that we got from Mr. Wright, from Mr. Sledge, that was what we concluded too. And that is why we put in here number 8, which is different. And it may not be in the prior iterations, but as we went back and forth,
Okay. This is all crazy to me because number 8 ends up being at the actual revocation hearing. Number 8 is what they seem completely fixed on. But look how unclear and uncertain all of this still is while this is happening.
Judge.
I think that it would be safer in terms of what gets put before the jury if you do this through question and answer with Mr. Wright. Would you be,
She hates that.
you let me know whether you're going to insist on tendering, but
I'm certainly not going to do anything the court says don't do.
Well, I'm not telling anybody how to try your case. That's not my job to do.
Understood. I'm not going to tender it before the lunchtime hour, at which point, if there is an issue that we need to hash out, or I need to say.
Okay.
But at this point, I'm very much intending to handle this verbally with Mr.
She's going to go pass lunch with this witness.
I think it's something that I can do clean.
All right. Is that going to be true with regard to also not tendering the different versions, just talking about them?
Right now, yes.
Okay. Yes, sir.
Let me just point out that in regard, and just very briefly, because I don't want to, go back over everything we just discussed, but number 8 is referenced by.
You're going to have to give me some
it would-
number 8 on which.
That's the Donovan Thomas personal knowledge.
I don't even have that in front of me, but I know it is. There's a lot of evidence in this
It
case.
is.
And I only have 2 screens. So
This is
give
the
me a
one,
second.
but I
give
can
it-
orient the court if it helps.
if you'll just give me a second. Okay, that works too.
I'm sure she gets the right version now.
All right. Go ahead.
So 1AS, section 8
Yes.
is the portion that Ms. Love just referred to, where she says that we made changes to the document based on what Mr. Wright said back to us. And so we came up with 8.
Right.
Defendant personally knows. Well, if the court recalls, that is what they asked Mr. Mr. Sledge about when he was on the stand, and he specifically disavowed it. He said, no, that's not accurate. That's not true. And so if we go back to what we talked about earlier this morning at the bench, my simple request was just that, and I think we may have reached there, I kind of got lost a second ago, is that in regards to them sending this iteration and Mr. Wright sending back the response that shows up in number 4, right? Number 4, where he says, he said he did not know. That's the answer to the question. And I think that's where the court ended up.
No, where the court ended up, and we talked about that yesterday, was that he said he did not know was to the version that the state had proposed that said this was planned beforehand. And the answer was he doesn't know that.
Right, but what we discussed at the bench earlier, and the reason we asked for this portion, for that sentence, the sentence reads, he thinks shooting Peanut was not planned, but more impromptu, or at least very short or little planning, is because that is speculation. That's his opinion. The fact, and you agreed earlier that.
Yes, with regard to whether it was planned or not, that's a separate issue from whether he knows personally that it was done by a member of YSL.
And the personal knowledge is what Love is trying to eject as testimony through the plea agreement. So please don't push back on Adams against this, because Adams is right.
But maybe I'm just not understanding, because I took the court's previous ruling and I thought that they were going to redact. As a matter of fact, they agreed that they were going to redact that particular sentence. That's the only thing that we objected to, because that our position was simply opinion. It was speculation. The fact that it came from Mr. Wright doesn't make it any less speculation as to him trying to explain why his client thinks that. But we asked that be kept out, or agreed, and we thought that that court was not going to be read to the jury or presented to the jury.
I don't think that part has changed.
It was the email, but that's what we discussed, because we were discussing whether or not these correspondences, including the emails, were going to be presented as evidence. The state said, well, we don't know, we might, we may, and our position was that, well, if this gets presented, we don't want that line should be redacted, just like the other line where they proposed the line about
what he had said.
Right.
Yeah, right. And that's what we're talking about right now. But that's an entirely separate thing from what number 8 ultimately ended up saying. So if Ms. Love is going to somehow get from whatever it was he said, hang on.
Number 4, Mr. Wright's email.
Shout out to Mr. Adams. He's
she
very
she can get from
kind when he speaks.
It was pre-planned. No, he didn't know that. He couldn't say that. To somehow that answer being the basis for putting in, he personally knew somebody did it. I mean, I don't know how she's going to get from one to the other, but obviously that is what they ultimately decided was okay to sign, and y'all can cross-examine Mr. Wright on that.
Your Honor, I'd also point out that how we got where with any of these assertions is not relevant or pertinent to whether or not the defendant, it does not make more or less likely whether the defendants did or did not do anything here. So how we got to any of these, in my opinion, is not relevant.
Well, Ms. Love, you're the one that's putting them all into issue right now.
I'm putting them into issue to impeach what Mr. Sledge said regarding his, regarding whether his.
Okay, so I think that you can ask a few more questions that establish that, yeah, there were very material alterations made from what it started to what it ended up with. And they were made at the request of Mr. Sledge. But frankly, you even have Mr. Wright on the stand saying, but there were other things that the state wouldn't change. So
almost
how you deal with that is up to you. But
since I want him to put in front of the jury everything that he recalls as being true, I don't care about the truth getting in front of the jury.
That's going to teeter on attorney-client privilege conversations. So I'm not sure that will fly. Hold on, let's just freeze frame what Love just said there. Ignore my old commentary.
Recalls as being true, I don't care about the truth getting in front of the jury.
I think that's point in case in point. I think that's the alpha omega issue with this entire trial. Oh my goodness. I will fly.
I'm talking about this idea that the state.
Well, the easiest way to do that is, so what was it that you want to change that didn't get changed?
Right.
And then why is it that well, that would be speculative, but I just said I wasn't going to tell y'all how to try your case, but okay. So we are not at this point going to be admitting any of these.
We're not
just going to be discussing them with him
at this point. Correct.
All right. Yes, sir, Mr. Steele.
Your Honor, just to follow up on, I believe Mr. Sharp said, would you also go through an analysis of confrontation clause, because the statement now comes from a party opponent and it's used for litigation. It is a clear to me bullseye on confrontation clause. So it's really Ms. Love who should be testifying if the state wants to get that in, because that is a confrontation clause, because where it came from, all those questions cannot be cross-examined to Mr. Wright.
Well, okay, sorry, I thought you were finished.
No. Second part, and I apologize, I'll be very brief. Second part is a 403 analysis. It's like saying, Ms. Love
That's a
saying
403?
to Mr. Adams, who represents me, did Brian Steele destroy the murder weapon in your presence or in the presence of Mr. Harvey? And then Mr. Adams responds, no. That's really bad for a jury. That is really bad. And that's really what's going on here. So I would ask you to just limit it. The point is what you said. Did the state give ample opportunity to Mr. Sledge through his counsel to make amendments? Answer, yes or no.
Mm-hmm.
Did the state make those changes? Yes or no? And he might say some not. And we may have to go into a portion by portion, but otherwise, I think that it's a wrong witness because of confrontation clause, and I think it's very prejudicial under 403.
Okay. Your Honor, we've had the witness on the stand that made the statements that signed them. We've inquired of him. He's
I think
made
that
some.
does take care of the confrontation clause issue. And with regard to 403, I mean, I agree. We've spent the whole morning on this, and let's target the questions to get to the cogent issue, which is, were they able to make material alterations upon request?
Yes.
All right.
Yes, Judge.
Okay, so we're ready to get the witness back in and the jury back in. Yes.
This is winding down here, but this comes up as an issue on another day. You guys had this comes up as an issue on another day, guys. So, like, it never ends with these emails. So here we go.
Or the state was told.
So number 4. Back on the email by Mr. Wright.
Okay.
We never read that in, right?
So
I'll
number 4,
I'll remind
we did
the
not.
court that we approached about number 4. There were obvious problems with number 4 that were inadmissible. We were told to stay away from number 4. The state was told to stay away from number 4 for obvious reasons. There's all sorts of speculation in there. And now, after being told to stay away from it, and we were told to stay away from it, and we did not address it during cross-examination. Now, after witnesses have testified, the state's seeking to admit a document
Once
that
again
has number 4 in it. And it's just, I mean, I don't know what we're doing.
Okay.
Your Honor,
Number 5 is not even relevant, right?
Your Honor, if I may just circle back briefly, as it relates to number 4, there was an objection to it. We followed the court's instruction. We did not ask him about it. And when the issue that I have with number 4 not being addressed here is, more importantly, I don't know how an assertion that the witness did not adopt is prejudicial when he is not, he denies it, and we change it, and we take it out, that he was planning, he had personal knowledge that they were planning. That is powerful because it is a material fact that
he doesn't
denies.
have personal knowledge
That's
that they were planning it.
Judge, that's the point that I'm making, that he says, I did not know that. The fact that something that.
Even saying I did not know that is sort of like,
or that's not true.
It's true, but I didn't know it.
No, he's saying that's not true. He is
No,
saying
he's
that-
not. He's saying, I don't know. I think maybe XYZ. That is not coming in. That
Finally.
needs to be kept out under 403, if nothing
Yeah.
else. And
Look at Atkins. Hold on, look at Atkins. I know it's worth the buffer. Look at the side eye from Atkins at the table. This feels like deja vu. And I don't know. Usually when it buffers when I
needs to be
reload
kept
like that,
out
but
under
look at him.
403, if nothing else. And that's really the only thing you wanted in, right? So
I didn't hear you.
is that really
I think we watched this earlier, right? We watched this earlier today in a longer clip with the, right? Did we watch this earlier? Did we watch this yesterday? We might have watched this one yesterday. I think we watched this one yesterday.
The only thing from this that you wanted in,
When you say this, you mean
from this being this part, the 8:43 p.m. email from Mr. Wright that is
Oh.
included within 460Y.
I didn't even the language of what he says, I didn't even need to have that in. I mean, I understand why that would be considered, and I understand
Today,
the court's
okay.
position there, why it would look like something was pre-planned.
All right, so we definitely got that one in this one stream. I was like, I know it feels too familiar. Like, obviously, we're rewatching things we watched a long time ago, but that felt really, 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 really familiar. And let's see. I think we're gonna wind down this one, and oh my god, there's just so many streams. There's so many clips. There's so much stuff, and we have the whole 403. So we could do a part 3. And we'll start with the 403 day where Doug is hammering 403, 403, 403 objections with Love. And then Love has to do it back as soon as Doug is doing cross-examination, because she can never let something not personally offend her. And when she's offended, she's got to hurt someone else's feelings back. It just constantly throughout that trial, that seemed like the theme. Oh my God, there's so many. Argues for admissibility of Rodelius Ryan's prior conviction. Oh my gosh, there's so many Love clips. Crazy. So we'll get together and we'll do a part 3. You know, I don't know if I could do it tomorrow. Tomorrow, guys, I will be covering, I don't know if you guys remember, if you paid attention to the Megan Jackson trial. That was a South Carolina case. She was convicted. She's sentenced to life without parole. But she had a co-defendant at one point in time. He's the former coroner. He ended up taking a plea, and he pled guilty to conspiracy to commit murder and an accessory after the fact for like covering it up. But in terms of his plea agreement, and this was the day he was supposed to go to trial, he stood up and said he wanted a plea. And the part of the plea agreement was that they were going to withhold on the sentencing until after he testified against Megan. His sentencing is tomorrow morning unless there's a change of plan. So I'm going to try to go live at the time and watch it in real time. We're going to see what happens with him. But weird trial with a prosecutor that oddly reminded everybody of Love with her demeanor, although it was a much smoother trial. The defense was kind of the hot mess over there. But yeah, so it was this woman who worked as a body transporter, Megan Jackson, ends up like moving in with some family. She has kids from a common law marriage with a guy that she's not really married to, but it's a common law marriage, and they seem to have some disputes going on legally, maybe over the kids, who knows what. But Megan Jackson moves in with this family. She knows Christopher Dontel through her line of work because she transports bodies and he's a coroner. And she's friends with the family, but then ends up initiating an affair with this guy, Christopher Dontel. And then according to what he testified to at trial, one night, even though any other time she had some claimed issue with the now deceased Gregory Rice, her common law husband, she would go handle it with a girlfriend. Like, she'd bring a female friend along with her to go handle it, never Christopher Dontel. But one night, Megan wanted Dontel to go with her. So they're going to the neighborhood, and suddenly she's demanding, as they see Gregory Rice walking, that he turns around. So he U-turns, and then Megan gets out of the car, and he says, "Pop, pop, pop, pop." Just shoots him and says, "What are you doing? Get him in the van." Makes him load the body, and now he's covering this up. And he's at Lowe's the next day buying tarps and cinder blocks. And like a few weeks later, a family that's fishing finds his body in a tarp, like stuck on a tree. So it was a wild, little, tiny, short trial, like 4 or 5 days. But I thought it was interesting that his sentencing was withheld until after he testifies. And it wasn't really clear, although I believe the story now that the trials played out. But at the time, it wasn't clear whether or not, maybe the guy did the shooting. Maybe the guy wanted the ex out of the picture. Maybe he took a plea to put himself first. But now I do think, after watching him testify and everything that came out during the case, Megan Jackson made that decision on her own. And maybe he shouldn't have tried to cover it up after the fact, but we'll see. We'll see. Yes, they also got his story was the Pepsi. But there was another trial recently, the missing boyfriend trial. I think that was a Florida case that started like a week after this one ended, where that guy was caught going and buying whatever, like duct tape and some other stuff that he may have used to dispose of the body, and a Coke. So when you're going to a hardware store and a Walmart and you're using self-checkout and you're doing incriminating things, you always got to grab a beverage, because why not? Yeah, Angelica says, I believe the guy after watching the trial, Megan was crazy. That's how I proceeded through it as well. Whew. And Tommy says, good to see you. This was truly awesome rehashing these clips. What a walk down memory lane. It's been a time. Yes, I agree. The defense was embarrassing. Honestly, he's like the star witness, this guy. And I think the cross-examination of him is like one of the worst I've seen in any trial I've ever, not just streamed, but watched even on my own. It was one of the worst. If you guys want to check that out, you could probably decently speed through the bulk of the trial between tonight and tomorrow if you're bored. Let's see. Let me get to, this is the stream link for tomorrow, but in the description is the playlist of all of the streams on that trial, as well as I specifically linked to his direct testimony and his cross-examination. But it was horrible. It was horrible. And then let's see. Yeah, we've got a lot to cover still. So let's see, you guys. Nem says, thanks for the reunion. Right back at you, and hashtag stay a slime. That is right. Thank you so much for being a member for 11 months. And I saw Trakisha said bunch of meetings in the morning. Me too, but I think I have the time right at 9. So I do think we'll be able to watch sentencing as it goes, unless it takes forever to start up. If I can make time tomorrow evening, we can do a little bit more, maybe like an hour more tomorrow of some clips. And if we do that, we'll do like shorter streams where we keep going through these clips with the best of moments of Adriane Love. That might be a better format, because I cannot do 6 hours during the week at this point in time. Oh, I sound like Landville at this point in time. So I think that's all. What are people talking about today? Because we did a little time warp. We went back in time. We're talking about this old case, a very long old case. But is anybody doing anything right now you guys want to go check out? Let's see. What does YouTube give me? And also, chat, thanks for holding it down. I mean, I don't know if we had someone in the chat. I don't know if it was the person they were proclaiming to be. But I haven't covered that case, so I don't know what they were talking about. But the whole chat held it down. That was awesome. I looked back at the screen and I'm like, what? I'm like, Vera? So you guys turned that into another reference to another memory, which was awesome. Yeah, so available for redirects. Yeah, so I don't know why, but it's acting like this video, this live stream is already done and not even giving me. Let me refresh it. Maybe it was just being weird. Okay, that fixed it. So I see we have someone talking about the Justin Baldani and Blake Lively, which has been interesting. There may or may not be, there's this thing called Subpoena Gate going on right now, where it seems like content creators that were speaking about Blake Lively and Justin Baldani, it seems like Team Lively was sending subpoenas to content creators, a bunch of them, but then it's not really clear because sometimes Google was saying, oh, it might not be an authentic email, but then Google and YouTube support both said they were authentic. So I don't love that. And I think that's Lauren. It says the court of random opinion. I think that's Lauren. So she has a deep knowledge of all of the actions going on back and forth with that. So if you guys want to check that out, that might be interesting. The other option would be, like, I don't see anything else that's live right now that's like law adjacent. So maybe we'll do that. That's the person, she's got like a deep dive of the civil filings. And let's see. Yep, maybe tomorrow, that guy Nick. Thanks for hanging out, you guys. This is going to take us over to Lauren's stream, and see you over there if you want to hang out. And if not, see you tomorrow or the next day or the next day. Bye, you guys. Please take care and have a good rest of your Sunday.